ಫೋಕಸ್ ಆಗತ್ತೆ.
ಮುಸ್ಲಮನೆ ಚೆನ್ನಾಗಿದ್ದೀರಾ?
ನೀವು ಚೆನ್ನಾಗಿದ್ದೀರಾ?
ಚೆನ್ನಾಗಿದ್ದೀನಿ.
ಫಸ್ಟ್ ಬ್ಯಾಟ್ರಿ ಇದೆ.
ಹಾ, ನಾನು ಆರ್ಡರ್ಸ್ ಮೂವ್ ಮಾಡ್ಬೇಕು ಅಂತ ಇದ್ದೀನಿ. ಸಾಹೇಬ್ರು ಏನ್ ಬೈ
ಫಸ್ಟ್ ಮ್ಯಾಟ್ರಿ ನಂದು ಮೂವ್ ಮಾಡಿದ್ದೆ. ಫಸ್ಟ್ ಮ್ಯಾಟ್ರಿ ನಂದು.
ಹೌದಾ?
ಓಕೆ.
ನಾನು ಸ್ವಲ್ಪ ಆರ್ಡರ್ಸ್ ಮ್ಯಾಟರು ಸ್ವಲ್ಪ ಭಾರಿ ಕಷ್ಟ ಬಂದಿದೆ. ನನ್ನ ಮಗಳ ಮನೆಯಲ್ಲಿ ಫಂಕ್ಷನ್ ಇದೆ. ಅವ್ರ ಮಾವನ್ಗೆ ಹುಷಾರಿಲ್ಲ. ಅವ್ರನ್ನ ಹಾಸ್ಪಿಟ್ಲಿಗೆ ಕರ್ಕೊಂಡು ಹೋಗಿದ್ದಾರೆ. ಅವಳೇ ಮಾಡ್ಬೇಕಾಗಿದ್ ಮ್ಯಾಟರ್. ಅದಕ್ಕೆ ಆರ್ಡರ್ಸ್ಗೆ ಒಂದು ಮೂವ್ ಮಾಡಿ.
ಮೇಡಮ್ ಲೈವ್ ಅಲ್ಲಿ ಇದ್ದೀರಾ?
ಹಾ, ಗೊತ್ತು.
ಪರ್ಸನಲ್ ಕಾಲ್ ಮಾಡಬೇಡಿ, ಲೈವ್ ಅಲ್ಲಿ.
ಸರಿ.
ಅಪೋಸಿಟ್ ಸೈಡ್ ಇಂಟಿಮೇಟ್ ಮಾಡಿ. ಅವ್ರು ಯಾರೋ ಮೆಮೋ ಆಫನ್ಸ್ ಕೇಳಿದ್ರು, ಕೊಟ್ಬಿಡ. ಅಪೋಸಿಟ್ ಸೈಡ್ ಇಂಟಿಮೇಟ್ ಮಾಡಿ. ಸರ್ ಈ ಕಡೆ ಅಲ್ಲಿಲ್ಲ. ಕೆಲಸ ಆಗ್ತಾರೆ. ನೀವು ಕೊಟ್ರೆ ಮುಂದೆ ಕೊಟ್ಟೋದು.
ಸಮಯ ಇತ್ತು 69, 67, 46, 71, 24, 25, 28, 78, 10, 61, 81, which is posted today. 700, 32, okay. 32. You can mention and give, or you can be just like that. 39. It will come within 10 days. 33. No, tomorrow you have to mention.
Memo book ಕೊಟ್ಬಿಡಪ್ಪ ಅವರು.
File is in the counter, no? It automatically to move. Yes, 29, 44, 42, 40, 25, 96, 37, 75, 91, 54, 89, 89, 38, 38 is there, 44. Wait for tomorrow. 44.
ಬ್ರಾಂಚ್ ಯಾವ್ದು ಬರೀಬೇಕು, ಯಾವ್ದು ಅಂತ ನೀವು ಅಷ್ಟೇ ಯಾವ ಬ್ರಾಂಚ್ ಅಂತ ಬರ್ದಿಲ್ಲ ಬರೀಬೇಕು. ಅಲ್ಲಿ 300 ಮೆಮೊ ಇರುತ್ತೆ, ಸಾರ್ಟ್ ಔಟ್ ಮಾಡೋದ್ರಲ್ಲಿ ನಾಳೆಗೆ ಬರ್ಬೇಕು ಅಂದ್ರೆ ನೋಡ್ಬೇಕು. ಫೈಲ್ ಮಾಡಿದೀರಾ ಅಲ್ಲಿ? ಫೈಲ್ ಮಾಡಿ 10 days. 10 days ವಿತ್ಡ್ರಾಲ್ ಫೈಲ್ ಮಾಡಿದಿರಲ್ಲ? ಆಯ್ತು,
ಕಾಪಿ ಹಾಕಿದೆ.
ಓಕೆ ಡನ್.
ಸರ್ ನಾಳೆಗೆ
ಹೌದೌದು.
ಓಕೆ ಥ್ಯಾಂಕ್ ಯು.
10 days. 10 days. 10 days ಏನು ಮೆನ್ಷನ್ ಬೇಡ. ಹಾ ಬ್ರಾಂಚ್ ಯಾವುದು ಅಂತ ಬರೆಯಪ್ಪ. 10 days. ಅರ್ಜೆಂಟ್ ಇಲ್ದಿರ ಮೆಮೋಸ್ ಕೊಡಿ. ಪೋಸ್ಟ್ ಆಗುವಂತದ್ದು ಇದ್ರೆ ಕೊಟ್ಬಿಡ್ಬೋದು. 10 days.
Within 10 days. If it is
ಪರ್ಸ್ಯೂ ಮಾಡ್ಬೇಕು. ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಏನು ಇರಬಾರ್ದು ಅಷ್ಟೇ. ಹೋಗಿದ್ಯಾ? ಕೊಟ್ಬಿಡಿ 10 days ಮಾಮೂಲಿ. ಇಲ್ಲ 10 days ಕೊಟ್ಬಿಡೋಣ. ನೋಡಿ ಇದೊಂದು ವಿತ್ಡ್ರಾ ಮಾಡ್ತಾರೆ, ಅದೇ ತರ ಬರ್ದಿದ್ದೀನಿ, ಇಲ್ಲೇ ಇರ್ಲಿ. ವಿತ್ಡ್ರಾವಲ್ ಮೆಮೋನ ಎನ್ಕ್ಲೋಸ್ ಮಾಡಿದ್ದಾರೆ.
Well, it's one memo.
Your lordship's kind leave.
ಮೇಡಮ್ ಒಂದ್ ನಿಮಿಷ, ಮೇಡಮ್ ಒಂದ್ ನಿಮಿಷ.
Hi.
No, is it coming this court?
MEC ಇಲ್ಲ sir. MF MEC ಇಲ್ಲ sir.
GPC. Yes.
My lords, my amendment application was rejected, which was filed prior to commencement of trial. Now, my lords, my suit is posted for plaintiff evidence.
Then it is rejected.
My lords, it was rejected in the month of November.
What are you doing all these days?
My
Then
lords,
court has to proceed further.
court has to produce, this matter was listed before the court. The court held that let the notice get served to the respondents. Now, my lords, notice is served to them. They are on record. They have filed wakalat. Now the urgency is this, my lords. On this 17th of this month, the suit is posted for plaintiff evidence. If the evidence is commenced, my lords, my IA becomes infractious.
Why? How it will become?
Because, my lords, it is filed prior to the commencement of evidence.
17th is the, if it is taken on, yes, 17th.
My lords, 15th.
No, 17th. That is. Yes.
Our property is dependent is appointed as an without an interim order, and the court says members can proceed to pass the order.
No, suit for?
Suit for partition and separate position. Plaintiffs and the other defendants are for you. Before this court is the second defendant.
Yes.
So, Malad, if the administrator is appointed, then Malad is
13th.
My lord, in this execution direction, I'm asking. In 2023, it is posted for orders. Till today, they are not doing. Well, it's an urgency. So
Date coordinate.
General memo date.
That application is rejected and matter is posted today itself for cross examination.
Yes, tomorrow. Tomorrow, yes.
Your lordship's kind leave.
Wait,
ಮೇಡಮ್
wait,
ಒಂದ್ ನಿಮಿಷ ಮೇಡಮ್.
What is that order you are challenging? No, rejection of application under which provision you have filed? Order 18 rule 17. Yes, tomorrow. Yes.
I moved the matter twice. It was listed for yesterday, it didn't come. I moved it again yesterday. It was supposed to come today, it's not listed. But I moved for vacating of the interim order.
Yes.
They're operating the bank account and withdrawing monies.
Yes.
So I need to get modification. I filed an application, my lords. It is pending for quite some time.
Yes, tomorrow. Yes.
Some great urgency.
Yes.
Great.
My lord. Suit for recovery of money, my lord.
Yes.
My impleading application is rejected by the trial court and posted the matter for orders on IA for proclamation of the property, my lord.
No, when that application is rejected for impleading.
Last month itself.
Who are you?
I am the dependent in the suit.
Yes.
I need to implead the bank person as a party to the proceeding.
Yes. 12th. Yes.
No, my
Your
lord. There
lordship,
is some emergency, my lord. There is tomorrow the matter is listed for
For what?
For orders on IA for proclamation. That's fine.
Yes, tomorrow. Yes.
Kindly, your lordship. One matter, execution case, demolition order as well as the eviction order has been passed, your lordship.
Yes.
So directly the Tahsildar, where he has no authority, your lordship, because it is comes within the jurisdiction of the municipal corporation.
Yes.
So-
Suit for?
Suit for your lordship, some of the residents has filed the suit for your lordship, declaring that that land is government land.
Yes.
Earlier, your lordship, this land was within the jurisdiction of the panchayat.
Yes.
Later, by notification in 2006, your land was invested in municipal corporation. Now, municipal corporation is the authority for your lordship to take the actions, your lordship. So now the court has passed the order to demolish the property of the petitioners, your lordship, with the
Passed an order on what? IA?
no, main execution petition, your lordship, on IA.
On IA?
IA.
Yes, tomorrow. Yes.
Lord,
Tomorrow case is.
Tomorrow, let us, tomorrow.
Lord,
Your lordship.
Your lordship,
Nothing
one
happens.
matter.
Hmm.
Suit for partition.
Yes,
Lord, the trial court raised issue of court fees
yes,
and said I have to pay court fee on the market value ad valorem, which
yes.
is totally wrong, Lord. Monday, the matter is posted for dismissal if court fee is not paid. Tomorrow, if it is taken up.
Tomorrow, yes. Yes, tomorrow.
My lord,
Yes, madam.
sir, this is, Your Honor, this is a WP which is pending before your honorable court. The connected main matter was, it's been still pending.
Early next week, yes.
My lord, in this, the defendant has been directed to deposit a bank guarantee of 88 lakhs, my lord.
Hmm.
There is urgency in this matter, my lord.
What is that urgency, madam?
My lord, this is a plaintiff suits, my lord, but here the defendant has been directed to deposit, my lord.
Suit
Here-
for what?
It's a suit for injunction, my lord.
What
But
is that
literally-
direction to deposit? Why they have directed you to?
We have
deposit?
filed IA number 8, my lord. On that IA, they have taken consideration and directed us to deposit, my lord.
No, why you have been asked to deposit, madam, in the suit for injunction? Are you tenant or something you have to be there?
I am a tenant. my-
Then you have to be paid that
No,
rent.
no, no, it's a bank guarantee, my lord, not for the deposit, my lord.
Then you said that tenant,
They have asked for the bank guarantees, my lord, in this.
yes, next week, Kali, are going date.
My lord, at least Monday, my lord.
No, date could, yes.
My
Your
lord,
lordship, it's a suit for partition, your lordship. The plaintiff had received was granted an interim order restraining the non-alienated, restraining the property from being alienated. Subsequently, they filed an IA to modify the interim order so they could alienate certain portions. They alienated the portions, we are the subsequent purchasers. We filed an IA seeking deletion of those survey numbers from the schedule. The trial court has rejected the application and instead imposed heavy costs, and now they are saying that they want to issue warrant. Your lordship, there's some urgency. It can be taken up tomorrow or on Monday.
What is that next date?
Next date is today, your lordship. Today is the next date. They are going to issue warrant is what the.
Yes, tomorrow, yes.
Tomorrow, please. Wait.
My lord, suit for declaration, my lords. I filed the application for appointment of court commissioner, my lords. In spite of serving hand summons to the trial court advocate, he is not come on record, my lords. The matter is set on for arguments on 10th, my lords. Kindly.
11th, yes.
I was directed to serve all the other side councils have served any day.
Yes, date could you.
My lord, it is a suit for recovery of money, a commercial OS, my lord. Application was filed to amend the plaint, which has been rejected. It has been posted for evidence on 17th, my lord.
Yes, 17th, yes.
Give a date. It is posted for 17th.
17th,
Date it, yes.
page wise adjournment, list number 1, page number 1. Page wise, sir. Page number 1, serial number 1 to 7. Page number 2, serial number 8 to 18. Page number 3, serial number 19 to 30. Page number 4, serial number 31 to 40.
37, my
No,
lord.
serial number 38, my lord.
Yes.
48.
Yes,
Sorry, my lord, 48 it is.
yes,
Not serial number 37.
yes,
The hand record council is suffering from some viral fever.
yes. At
Not-
the request of counsel for the petitioner, please this matter of 2 weeks. Yes.
Page number 5, serial number 41 to 47.
42,
Not-
my lord. Serial number 42.
42, yes.
Kind of 1 week time, my lord.
Weeks time is granted to do the needful.
Please.
Yes.
Page number
43, my lord.
Hmm.
Vacate application, ನನ್ನ ಸರ್ವ್ ಮಾಡಿದ್ದಾರೆ.
Hmm.
For the petitioner.
Hmm.
File the objection.
Have you informed other side?
Yes, sir. Yesterday only they
Waiting
are served
service
this
ಅಂತಿದೆ.
document.
I appear for R2, my lord. I am undertaking to occurs for R2, my lord.
R2?
Yes, my lord.
Yes. You have no objection next week?
No objection.
Yes, learned counsel, so and so is undertaken to appear for R2. This matter after 2 weeks.
Not serial number 48, my lord.
The matter granted
Yes, sir.
earlier, if any. Yes.
Page number 6,
My
serial
lord,
number
serial number
48 to
48.
Yes.
Serial number 48, I have
Hmm.
informed the other council. My
Yes.
lord, there is some inconvenience in the family. Therefore, my lord, I am seeking time till 10th, my lord. The other side has said.
No, they are objecting for adjournment, madam.
Yes, my lord, I know that they are objecting because when I communicated them, they said that they would object. My lord, in trial court, the matter is on 21st. My lord, I am asking to take this matter on 10th, my lord.
Yes, mister. 21st matter is there, then you will have it on 18th.
Urgency ಇದೆ ಅದಕ್ಕೆ
Yen urgency, the matter itself is on 21st.
ಇಲ್ಲ ಅದು ಆರ್ಎಸ್ ಪೋಸ್ಟ್ ಮಾಡ್ಬಿಟ್ಟಿದೆ ಸ್ವಾಮಿ ರಿಪೋರ್ಟ್ ಕೋರ್ಟ್ ಕಮಿಷನ್ ರಿಪೋರ್ಟ್ ಮೇಲೆ ಆರ್ಎಸ್ ಮಾಡ್ತಿದ್ದಾರೆ
ಅದಿರೋದು 21 ಅಂತಲ್ಲ, you will have it on 18th. Yes.
ಇಲ್ಲ ಪಾಸ್ ಆರ್ ಆಗಿದೆ ಸ್ವಾಮಿ ಇಲ್ಲ ನಿಮ್ ಸೀನಿಯರ್ ಬಂದಾಗ ಅವ್ರ ಮ್ಯಾಟರ್ ಇಸ್ ಬೇಕಾದ್ರೆ
Yes, madam, we'll pass it over.
My lord, what has happened is I have some urgency in this matter because I am required to go to some other place. That's why I moved at 10:30. Otherwise, I would not have
No,
moved.
but I can't help, madam. The other side is objecting. Yes.
My lord, I will ask
You have to-
one of my colleague to be present, my lord. I
Yes,
cannot
yes.
be present.
Yes,
Very
yes.
well. Very
Yes.
Page number 7, serial number 51 to 53. Page number 8, serial number 54 to 56. Page number 9, serial number 57 to 64.
59, serial number.
59, my lords.
Yes.
Case your honor. Against same implement order, other 2 writ petitions are pending.
You challenging by
Yes,
Same
my
part.
lord. Impleading applicant, there are 2 impleading applicants.
you are appearing for?
I am for the respondent number 1 to 3, my lord.
Yes, respondent number 1 to 3 submits that this petition may be called along with its own.
Its interim order may kindly be extended.
Not granted.
The date may be fixed because 2002 matter ಇವರು OS 2002. ಹಂಗಾಗಿ ಒಂದು ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡ್ಬೇಕು.
OS 2002 writ petition 2002 ಇದು. Yes. 18th. Yes.
One week time to fill up.
Have you informed other side?
Writ petition also. 35927.
Why? How it is connected?
Against the petitions are the same, my lord, against 7 different writers. They have filed a different appeal also, appearing there also. Now they have filed a writ petition also. In the writ petition, the petitions are the same. I filed a suit against the.
No, Mr. Gunchal, have you informed other side?
Sent a message, my lord, after this.
No, you have to inform early if they. Yes, at the request of counsel for the respondent, please this matter next week. Interim order is there. Interim order. Interim order is there. Not.
Page number.
You are appearing for whom? You have informed. Yes. No, either today or some other day, court will fix. If you have any objection, I will not grant the time. Wait for. No, he is saying that there is an urgency. Not Monday, mister. Monday and Tuesday, we have so many matters. Tuesday, yes. Yes, at the request of counsel for, you are appearing for petitioner. Please this matter on Tuesday. Interim order granted earlier is extended till next date of it.
Page number 10, serial number 65 to 73. Page number 11, serial number 74 to 78. List number 1 for preliminary hearing, serial number 1, Yes, sir. Egde Utla Mane for petition.
I'm appearing for the petitioner, my lord.
Yes.
In case I have challenged the appointment of a commissioner in an appellate court. Trial court, it was already rejected. I'm bringing it to the notice of the court, page number 47. Suit for declaration and injunction.
Yes.
And mandatory injunction was rejected because in mutual property, I am the owner of the property. Only for a decree decreed with respect to Asian property. When it is allegation in the application, earlier application was also for appointment of commissioner trial court. It was held, it was collecting evidence and attempt was made and it was rejected. Now another attempt is now made. In the application itself, they want to encourage measure the mutual property also. Mutual property, I am the owner of the property, trial court rejected it.
What is that order you are challenging, Mr.?
Appointment of court commissioner. Court commissioner.
You are challenging the appointment of court commissioner.
Yes, yes, sir. That too, as PDO is appointed. PDO is appointed at the instance of the plaintiff.
Where is that order, Mr.?
In Annexure M, 9th January.
Annexure?
M. Your lordship will operative portion of the order will be your lordship will kindly see. Annexure M.
Consequential.
In 98. Earlier, similar application trial court was held. It was a collecting evidence. Now, when there is already decree in his favor, how can he say, because under order 21 rule 32, if there is a violation, he can seek an executive, it is an executable order. Under order 21 rule 32.
No, Mr. What is that filed in that appeal, Mr.? It's in the
appeal is challenged, even the granting decree with respect to mutual property, they have not granted because I am the owner of the property. The court has given a finding. Issue number 3.
Suit for declaration.
Suit for declaration injunction with respect to mandatory injunction also. So mandatory injunction was rejected. But application, but a decree was granted in favor. That is under circumstances.
It's not clear, Mr. Your voice. Where is that degree?
Decree, your lordship will get it. In page. The lordship will get it. Decree, yeah. Page number 52.
52.
Yes.
Yes. Suit of the plaintiff is
decree and consequently decree hereby declare the plaintiff.
Wait.
Yes, I am not. Here, defendants are restrained. That's already restrained. I have already. Then he wants the application to measure the property.
No, you are the plaintiff or a defendant.
I am the defendant.
You are the defendant.
Yes, I am the defendant.
You have filed an appeal.
They filed an appeal. I filed a cross objection. That's all. I have not filed. They themselves filed an appeal because mandatory injunction was not granted.
Yes.
That's why they want to seek an appointment of a court commissioner. Affidavit may be seen. In the affidavit, there is an encouragement. If that's the case, under order 21 to 32, separate provision is provided for executing the decree.
Stay of order dated 9/1/2025, passed by First Additional Senior Civil Judge CJM Shimoga in area number 37 of 2021 till next date of hearing.
My lord, your lordship may, by filing a memo, R2 not necessary. Memo to that effect. R1 is only contesting. Memo is also being filed.
Whom you want to dispense, Mr.?
R2, respond number 2.
Yes. Memo dispensed. Emergency notice to R1.
Serial number 2, Bhaskar Gowda NM.
Please, madam. The suit is one for partition. My lord, page 38 would be the RTC, please, my lord. The property, my lord, land bearing survey number.
Suit for partition.
Suit is for partition.
You are the plaintiff.
My lord, I am the plaintiff. I am, my lord, my husband is the, my lord, Papaya. He dies. My lord, page 38 for a moment, please, my lord, the RTC. My lord, the suited property is an agricultural land totally measuring 4 acres of land.
No, what is that your grievance now, Mr.?
My lord, my grievance is that, my lord, the trial court, my lord, at page number 29, my lord, has issued an order of emergent notice. My lord, though I have, my lord, brought to the knowledge of the notice of the court that there is a threat of alienation. Why? Because, please, my lord, the mutation entries in the name of the respondent number 10. Where
issue notice. Parties are directed not to create third-party interest in respect of suit scheduled, petition scheduled property till next date of hearing.
Please.
Serial number 3, A.V. Amarnathan.
In this case, my lord, my lord, turn to page number 27, my lord, next D. In front of me on the road, my lord, shed is
What is
constructed.
the suit, mister?
Suit is injunction suit, my lord.
Who are you? You are the plaintiff.
Court commissioner ಏನಾಗಿದೆ ಅಂದ್ರೆ
ಅಲ್ಲ ಫಸ್ಟ್ ಫ್ಯಾಕ್ಟ್ಸ್ ಹೇಳ್ಕೋಬೇಕು ನೀವು.
facts. Some is one Rudrappa is farmed in layout and sold this.
ಅಷ್ಟು ಬೇಡ. ನೀವು
Simple.
plaintiff ಡಿಫೆಂಡೆಂಟ್ ಸೂಟ್ ಏನಕ್ಕೆ ಹಾಕಿದೀರಾ? ಏನ ಅಷ್ಟು ಸಾಕು. You are the plaintiff. Suit for
injunction.
Injunction. What is that order now you are challenging?
That I filed an application under order 26 rule 9.
You have filed an
appointment of commissioner.
You have filed.
Yeah, I filed it.
Yes. What is that appointment of commissioner for what?
That is my lord. Earlier also my lordship kindly say on
Page 10. Page 10.
Page 10.
What is that you read in that application?
Yes, ma'am.
Measurement and identified that property.
Property. And now the defendant, he says he survey number 45/4 ಅಲ್ಲಿ din 45/1 ಅಲ್ಲ ಅಂತ. There is a local complaint court ಮೇಲೆ local inquiry ಮಾಡ್ಬಿಟ್ಟು revenue authorities fraud ಮಾಡಿದ್ದಾರೆ 45/1 ಮಾಡಿದ್ದಾರೆ ತಪ್ಪಂತ ಅದೊಂದು ರಿಪೋರ್ಟ್ ಇದೆ.
Now where is that order?
Another court case ಅಲ್ಲಿ court commissioner appoint ಮಾಡಿ revenue.
ಆಯ್ತು, ಈಗ ಆರ್ಡರ್ ತೋರಿಸಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಏನು, ವಾಟ್ ಇಸ್ ದ ರೀಸನಿಂಗ್?
Yes, madam. ಆಯ್ತು. It is the page number my lord, impute not pen 19 madam. 19 sure.
Where is the reasoning given? What is the reasoning given by?
Reasoning, they say, see, I had shown my document western side road on Tosi. It is for me to establish that there is a road on the western side. On the road, he has put up the structure.
The plaintiff has failed to establish the sufficient ground for appointment of the commissioner. Purpose of such a plaintiff seeking appointment of the commissioner is not material or relevant to the adjudication of the issues. The plaintiff. Now, how it will help to the case to decide?
Yes, but the defendant says he has got site number 45/4. There is a local report stating that it is 45/4 revenue authorities fake ಆಗಿ ಮಾಡಿದ್ದಾರೆ ಅಂತ ರಿಪೋರ್ಟ್ ಇದೆ. And another case ಅಲ್ಲಿ court commissioner appoint ಮಾಡಿದ್ದಾರೆ. Court commissioner has given a report, yes, 45/4 ಇಲ್ಲ ಅಂತ. But the defendant claims that his site is 45/4. That's why they say there is a report.
ಆಯ್ತು, ನಿಮ್ದು ಡಿಸ್ಪ್ಯೂಟ್ ಇರೋದು ಯಾವ ಸರ್ವೆ ನಂಬರ್?
ರೋಡ್ ಮೇಲೆ ನನ್ನ ಆಪೋಸಿಟ್ ಕನ್ಸಲ್ಟ್ ಮಾಡಿದ್ದಾರೆ. ಕೈ ಫೋಟೋಗ್ರಾಫ್ ಮೇಲೆ 27.
You take notice. Issue notice.
Emergency notice. ಅಲ್ಲಿ ಏನಂದ್ರೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಫೈನಲಿ ನಿನ್ನೆ ಇತ್ತು, ನಿನ್ನೆಯಿಂದ 12 ತಗೊಂಡಿತ್ತು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮೇಲೆ.
Argument for what?
Final argument.
No, you filed it that at the time of final argument.
ಅಲ್ಲ, ನಾನು ಎವಿಡೆನ್ಸ್ ಆದ್ಮೇಲೆ ಹಾಕಿದ್ದೀನಿ. ಎವಿಡೆನ್ಸ್ ಆದ್ಮೇಲೆ ನಾನು ಕೋರ್ಟ್ ಕಮಿಷನ್ ರಿಪೋರ್ಟ್ ಕೊಟ್ಟೆ, ಬೇರೆ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಹಾಕಿದ ರಿಪೋರ್ಟ್. ದಿ ಕೋರ್ಟ್ ಡಿಡ್ ನಾಟ್ ಅಕ್ಸೆಪ್ಟ್ ದಟ್ ರಿಪೋರ್ಟ್. ಲೋಕಾಯುಕ್ತ ರಿಪೋರ್ಟ್ ದಟ್ ಈಸ್ ಆಲ್ಸೋ ನಾಟ್ ಅಕ್ಸೆಪ್ಟ್. ದಟ್ಸ್ ವೈ ಐ ಫೈಲ್ಡ್ an application. This court appointed court commissioner. There's a court commissioner report and a ಲೋಕಾಯುಕ್ತ report stating that there is no 45/4.
Arguments and all is over.
ಇಲ್ಲ, ನಿನ್ನೆ ಆಗ್ಬೇಕಿತ್ತು ಸಮಯ, ಅದನ್ನ 12th ಅರ್ಜೆಂಟ್ ಮಾಡಿದ್ದಾರೆ.
ಆರ್ಗ್ಯುಮೆಂಟ್ ಆಗ್ಲಿ ಬಿಡಿ. ವೈ ಯು ವಾಂಟ್
ಅಲ್ಲ, ಫೈನಲ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಕೋರ್ಟ್ ಕಮಿಷನ್ ರಿಪೋರ್ಟ್ ಇದ್ರೆ 45/4 ಅಲ್ಲ ಅಂದ್ರೆ ಡಿಫೆಂಡೆಂಟ್ ಹ್ಯಾಸ್ ಟು
issue notice stay of further proceedings in 4070 of 2021 pending in the file of 26th or 27th 26th or 27th court re Additional City Civil and Session Judge Bangalore till next date of hearing.
Serial number 4, Civil Prasad Pais for petitioner A. Madhusudan Rao.
Lord, this is petitioners, my lord.
This case, my lord, only one submission. In a earlier proceeding arising out of the same suit, your lordships had expressed some disability.
What is that? Which matter?
In an MFA number 4281, 4288 between the same parties.
Same parties.
Same parties.
I don't know if it's for your lordship.
No,
to
it has
decide,
been
my lord,
said that
we are
that's what
ready
I'm-
because there's some urgency. that
No,
we are-
I am only bringing to your lordship's notice, my lord, because that is what has happened.
Yes. This yes.
ಹೌದಾ?
That ನೀವೇ ಲಾಸ್ಟ್ ನೀವೇ ಇಬ್ರು ಅಪಿಯರ್ ಆಗಿ
ಹೌದು.
ಆಫ್ಟರ್ ಹಿಯರ್ ಅಂತ ಕಾಣಿಸುತ್ತೆ.
ಅದಕ್ಕೆ ಹೇಳಿದ್ದು.
After all some time, because I have given some legal advice to that institution.
Your lordship, sir.
That is that
institution.
Yes. Yes.
Same.
Now I remember that. Yes.
Just I wanted to.
That's all right. I have no objection to that because I do not want to embarrass anyone.
No, last occasion, you both I heard one time, one day. Second time I realized I have seen
Your
that.
lordship realized.
Then I have
That's
not seen that costly.
Yes, that's right.
Better instead of
I
that.
do not want to embarrass anybody.
Yes,
There's one problem, there's some urgency because the learned judge is proceeding on day-to-day basis.
No, I will direct the registry to post before tomorrow after taking a.
Yes,
That's order
yes,
from the.
yes.
That's tomorrow after taking permission.
Yes, not
That's the
before
law.
me. Learned senior counsel appearing for the petitioner has submitted that there is an urgency in this matter. Registry is directed to take necessary order from Honorable Chief Justice and post this matter before appropriate bench tomorrow.
Actually, I didn't want to embarrass anyone.
Yes, yes, no.
I only wanted to, because
It's all
without
right, I'm
tomorrow,
not objecting.
there is nothing to,
Nobody is
we have
objecting.
no objection to argue the matter.
Also
before any-
welcoming that, yes, yes.
ಇಲ್ಲ, ನನಗೆ ಈ submission ಮಾಡೋದು urgency ಇತ್ತು ಅದಕ್ಕೆ.
Yes.
Cell number 5, Narendra Dev HN for petitioner, Mithun Gerehalli A.
Appear for the petitioner. My lord, petitioner, my lord, is a defendant in the suit.
Yes,
Suit is filed for recovery of money.
yes,
And my lord, plaintiff says, my lord, he is in the business of milling and packaging wheat products.
yes,
And defendant, my lord, is the sole one of the distributors of the plaintiff. First, initially he files a suit for recovery for a sum of rupees 50 lakhs. The total transaction between the parties is somewhere close to 3.76 crores. A detailed written statement is filed, my lord, by the defendant saying that, look, you've not identified certain set of what you're supposed to make, the discounts, the credit notes, the payment what I've made, a detailed written statement, my lord, at page number 54, 55, 56. Narrating what are the, under different heads, what the plaintiff has not considered. At 56, I've said 89,000 is all I have to pay you. My lord, for this written statement, we also said set off because these payments had to be set off. For this, they file a rejoinder. In the rejoinder, they say there's a third party liability which I undertook to pay. And the payments made by me to the plaintiff, he has adjusted the payments to somebody else's outstanding. And that somebody else is a trust. And the plaintiff's, my lord, the claim is that one of the partners here in this defendant partnership is a trustee. My lord, no such document is filed and none of the defendants are trustees of the firm. And my lord, after the matter, my lord, we filed additional written statement for this. Evidence was led, cross-examination was done. Subsequently, my lord, at the time of final arguments, an application is filed by the plaintiff, my lord, to say there were checks issued by the defendant to the plaintiff, and this is not the suit based on accounts, my lord, this is suit based on invoices. In my written statement, I've categorically said that for checks, whatever are issued, these bunch of invoices I'm paying. My lord, their contention is, my lord, in so far as the checks what we have issued, if I may, my lord, if I may pass on this memo, my lord, on the other side copy. It's a part of the low court records. Lord sees this page.
What is that application you have?
What is application they have filed saying that kindly an application to know to get the handwriting of this one person who signed this check, and there is another exhibit. My lord, his case is that the person the person who's signed the checks from the defendant and gave it to the plaintiff is also the same person who's signed a note. Illi Swami, if this memo what I've given, my lord, this page number 2 and 3, my lord may kindly see the page number 3.
Yes.
There are these handwritten notes.
Yes.
These handwritten notes, according to them, is written by the defendant, and where we have undertaken the obligation of a third party. And they want handwriting expert on this. And right now the application is allowed. And to say that, my lord, the so-and-so person defendant has to come and give further handwriting. My lord, the checks itself is a handwriting. Is first thing. There is no need, and plus, my lords, there is no pleading in the either the plaint or even in the rejoinder that such an undertaking was given by the defendant that I will clear third party obligation. No such pleading. And my lord, n amount of evidence without pleading, my lords are well aware that it will not suffice. And this is a wild goose chase, filing another application at the time of final argument to say that you please ask them to come and give it in writing. My lord, there's no pleading to begin with.
No, how it will prejudice to you?
My lord, there is already the handwritings are here. And my lord, this is not an issue. Court has not framed an issue to prove this particular point, and they've not even taken pleading to that effect.
What is the reasoning of the trial?
And my lord, the trust, the so-called trust where they say that the 27 lakhs which I paid to them, they have adjusted towards the third party obligation. The trust is not made as a party here.
Yes, read the reasons.
My lord, reasons, my lord, the court, my lord.
In the mind of the rival contention, both
Page 32.
Page number 29 in this.
Yes.
32, my lord.
Yes.
Comparison of admitted signature. Keeping in mind the view of the parties, I would like to bestow the attention of so-and-so Section 73 of Evidence Act. My lord, on careful reading of the above provision, it's crystal clear that the court has got jurisdiction to compare handwriting signature and to secure handwriting in both words and digits, and also the signature of a person has to adjudicate the case in a better perspective. In this case, the plaintiff are relying upon Xerox copies of calculation slip, which is said to be written by DW1. DW1 denying the said document, stating that the handwriting appears to be on the said calendar does not belong to her. On careful perusal of the court record, it appears that in this case, there is a dispute pertaining to the handwriting which is appearing on some of the checks which are marked on behalf of the plaintiff. In my opinion, one of the parties asserts the handwriting appearing on the documents belonging to DW1 when the DW1 denies the same. Then the court has ample powers to direct. My lord, the court, my lord, is not looking to whether this proves the case of the plaintiff. It does not, my lord, because his case is not. Yes,
If
my
it
lord.
is proved that it is your handwriting.
Yes, my lord. If even assuming, my lord, it is proved, there is only one such note which is issued. And my lord, if my lord may see that note, I do not say that I am paying this obligation on behalf of a third party. Even assuming here it says Sneha Mai Mahila so and so trust. My lord, the obligation will be about 1,88,000. If that is the worst scenario, it does not, my lord, prove that 50 lakhs.
That is also, it is not that amount is the criteria.
My lord, he is not.
Is that, see,
my lord, he is saying
whether it will helpful to the court now that you are disputing that it is not your signature.
Yes, my lord.
Now, if it is proved that, then it is helpful for them to declare it.
And Malan, friend says that there is no issue. Issue number 5 is whether defendants prove that they're entitled for set-off. And that set-off is where they're denying. And it's the same party who was given instructions.
No, it will not cause any prejudice to give. If it is not your handwriting, it is not
my
your
lord,
handwriting.
my handwriting is already before the court. This check which I've issued is my handwriting which is already before the court.
No, even court wants further handwriting of the present. What is that prejudice to you? Why can't you go and give that?
My lord, I have, in so far as giving, my lord, I have no, right now, my lord, at the time of
The
final
way the
argument.
denying shows that.
Yes, my lord.
Then you have to be stick on to the denial what you have made in that this thing.
Issue number 5 is framed.
What will happen if you give that?
My lord, this issue, my lord, in 2021, this contention was raised. My lord, they had ample opportunity to lead evidence. My lord, even this so-and-so person.
Now that Supreme Court as well as this court is said that commissioner can be appointed even for a collecting of the evidence.
Yes, my lord.
But it should be helpful for the court to decide.
Yes, my lord. But
yes, it will helpful.
My lord, there are no
you denied.
pleadings. My lord, there are no pleadings to begin with.
No, you have denied. Court said that you have denied that it is not my signature.
And issue number 5 is that, your
So,
lord.
myopically, court says that I've denied so-and-so, so-and-so. My lord, larger aspect, is there a pleading to begin with? My lord, is my foundation itself is not there, is my humble submission.
No, without foundation, why you have denied then?
My lord, in terms of so far as, my lord, these...
pleading regarding that...
Lords, what has happened is, he has filed a counterclaim. May I take a lords to page 54, ink page 54.
What has
ink page 54.
That on careful reading of the above so in this case, plaintiff are relying upon that Xerox copies of the calculation D1. D1 is denying that said document, stating that handwriting appears to be our said calculation slip do not belongs to her.
And she's denied it in cross-examination. She says the handwriting found in the slips above is not my handwriting. It is not true to suggest that the handwriting found in the checks and the slips are my handwriting.
No, if it is not yours,
I have no objection to send the handwriting sample.
Right now,
she herself has said no objection.
My humble submission, my lord, in the pleadings when they've not set a base.
Technical objections.
No, my lord.
Now that appointment of, see,
yes,
there is no pleading, there is no this thing. Now, only thing is that give your signature, admitted signature, they will compare it. If it is not yours, reject it. That's all.
My lord, in terms of giving that handwriting, my lord, may not be an issue, my lord. But here, my lord, is it germane to the dispute per se in terms of this handwriting?
It's a matter of argument, lords.
And if they've not set their, my lord, if there was a pleading to that effect, to say that I undertook to clear third-party liability, and it's not even my liability, my lord. Third-party liability is where he says that I have undertaken by virtue of that handwritten note. And in that handwritten note, nowhere it is written. It says that I am undertaking this liability of a third party. I can understand if I've written something.
The argument is available.
Yes,
it will not go that. Only thing is that whether you are handwriting or not, that they have to be.
That's all.
Lord, I have denied
All
because these are the documents produced by him.
Yes, that's all.
Yes, my
lord. This petition is filed by defendant number 1, challenging order dated 6/1/2025, passed by 89th Additional City Civil and Session Judge, Bangalore, in IA number 14 of, on IA number 14 of 2024, whereby application filed by the plaintiff has been allowed. Plaintiff has filed a suit for
So recovery of money.
recovery of money. After that appearance of the defendant, they have filed a written statement. When at the time of evidence of DW1 has denied that calculation slip is marked as what, Mr.?
Exhibit,
Plaintiff's exhibit, my lord.
Plaintiff's
Plaintiff's exhibit, my lord.
P61A
Huh?
is P61A and
P61.
P136, my lord. P136.
and others are referred in the application.
61A and 136, there are two,
Application that's 204.
P61.
136 and P61A, my lord.
Yes. DW1 has denied that.
But there's more. Your Lordship.
P104.
There's more. Your Lordship may see
I
page.
pray just. to the
Okay,
facts,
just
I'm not
sample,
deciding.
sample,
Yes.
please.
Has denied that exhibit P61A and P136. Therefore, the plaintiff has filed an application under order 26,
Section 73 of Evidence Act.
73.
my lord.
73, filed an application under section 73 of Evidence Act. Since that DW1 has denied that Xerox copies of the calculation slips marked as exhibit P61A and P136. The trial court has an opinion that it requires to compare that signature of that defendant in admitted signature under section 73 of the Evidence Act. Therefore, on that ground, court has allowed that application. There is no error or illegalities in order passed by the trial court. Accordingly, the writ petition is dismissed.
Please.
My-
Grateful, Lord.
Divide of merit.
Serial number 6, D. Gangadhara for petitioner.
Petition is filed there, seeking for recalling the order and permit under order 18 rule 17. Application filed by the petitioner. And it is rejected by the trial court related to the IA filed for production, recalling the order and permitting to production of the
Suit for-
document. Suit for declaration. ಅದರಲ್ಲಿ ಏನ್ ಮಿಸ್ಟೇಕ್ ಆಗಿದೆ, he was not able to present at the earlier occasion due to his ill health, and now it is a posted for argument. That is why application for permitting to lead one of the boundary issues. That is why I made an application for
What is that application, Mr.?
application for relating to the boundary. There is a mistake and he could not able to
ಆಯ್ತ್ರಿ ಅಪ್ಲಿಕೇಶನ್ ಯಾವ ಪ್ರಾವಿಷನ್ ಅಲ್ಲಿ ಏನ
order 18 rule 17 ಅಲ್ಲಿ ಹಾಕಿದ್ದೀವಿ. That is to be only permitting to
opening of the case.
please.
Why reopening at this stage?
Regarding the evidence on relating to the boundary, that is the document is there. At the when the matter was posted for evidence, he was not in a position to appear due to his ill health and he was in treatment. And matter was again posted for closing and further evidence of the, for the defendant evidence. Now at this stage, the matter is posted for argument. I filed application for only relating to the boundary issue. And it may be permitted to open and to make a cross-examination of the.
No, why you have not put this question at the time of
ಇಲ್ಲ ಅಲ್ಲೇನಾಯ್ತು, when the matter was for evidence of the plaintiff, ಆವಾಗ he was in the treatment. He could not able to present.
Who?
By the plaintiff himself. That is why it was closed the procedure at that occasion. The trial court was,
order 18?
the court has got
Is
power.
that order sheet when your evidence has been closed, Mr.? Now, what is the stage now?
Now it is a process for argument.
No.
That is why I filed
Now, what
application.
are you doing till the defendant evidence has?
ಇಲ್ಲ ಅವ್ರದ್ದು ಎವಿಡೆನ್ಸ್ ಆಗೋವರೆಗೂ that it is not,
Then
provision is not permitted.
Yeah.
That is why he was,
which provision is not permitted that it cannot be reopened?
ಅವ್ರಿಗೆ ಟ್ರೀಟ್ಮೆಂಟ್ ಅಲ್ಲಿ ಇದ್ದಿದ್ದರಿಂದ he could not able to man.
How many days he was in the treatment, Mr.?
Not he is in the eye problem agi, he was long duration treatment ಅಲ್ಲಿ ಇದ್ದಾರೆ. Still it is in the treatment also. Still it is in the treatment. He is the aged person of 72 years. That is IA ನಲ್ಲಿ affidavit ನಲ್ಲಿ explanation ಮಾಡಿದ್ದೀವಿ. What was the problem, why he was.
No, when he was in that hospital, mister.
But continuously he was on treatment ಅಲ್ಲಿ ಇದ್ದಾರೆ ಆ period ಅಲ್ಲಿ ಸಹಿತ. Medical record ನಾನು ತರಲಿಲ್ಲ. But he is in the treatment also.
Is to exercise with the greatest care and most spring and use for so and so.
He is a aged person, eye problem ಆಗಿ.
ಆಯ್ತ್ರಿ ನೀವು ಎಲ್ಲದಕ್ಕೂ ರೀಕಾಲ್ ಮಾಡ್ಕೊಂತ ಹೋದ್ರೆ ಕೇಸ್
ಇಲ್ಲ, it is only relating to that aspect, the foundry relating to that, he seeking a permission of the Sarma court. ಯಾರ 3 and 4 ಅಲ್ಲಿ explanation ಮಾಡಿದ್ದೀನಿ.
Yes, you take notice.
And now it is posted for final argument, it may be stopped.
When that order has been passed, mister.
That is on, my lord, annexure.
Or issue notice, stay of further proceedings in OS number 463 of 2013. Pending in the file of second additional city civil judge JMFC Davangere till next date of hearing.
Much of it. Serial number 7, Shashank Reddy BK.
For the petitioner, my lord, the respondent has filed a suit for recovery of money against me. He is relying on certain documents which happen to be acknowledgement of debt. Since the same is insufficiently stamped.
You are the defendant.
I am the defendant in the court below. Suit for recovery of money. He is relying on certain documents which are insufficiently stamped. Hence, I filed an IA under section 33 and 34 of Karnataka Stamps Act to impound the said documents. On the same day which I filed the documents, even after I raised my objections for marking, the trial court has further gone ahead and marked the documents, my lord. Hence, I'm coming to this.
No, what is that order the court has passed?
Page number 14, my lord.
14,
yes.
Yes.
In the last portion, my lord, if my lord can observe, case has been called out. Counsel for plaintiff's file list with documents. Plaintiff has filed his affidavit evidence and the same is recorded as PW1. Documents at exhibit 1 to 3 are present. The next page, my lord, counsel for defendant has filed IA number 3 under section 33 and 34 of Karnataka Stamp Act. And the next relevant portion is page number 26.
Case posted for objections.
Yes, my lord. Page number 26, my lord. It's more clear in the bottom, my lord, self-declaration dated 3/8/2020, which is an acknowledgement of debt, is marked as exhibit P3. Even after I raised my objections for marking, the trial court has gone ahead and marked the documents, my lord, by virtue of section 35.
Now, what has happened that after this thing, IA number 3 and further evidence of PW1 on call on 21.
My lord, they filed the objections. Recently it was listed. They filed their objections and now it is listed for hearing the said document. But then hearing the said IA. But then as per section 35, once the documents are marked, then I cannot raise my question against
what
it.
can impound?
Once it is marked, my lord.
Even if it is marked, it will not take away the rights of the court to impound and collect it.
I have challenged the marking of 2 documents, one sale agreement and one self-declaration. The trial court has not marked the self-declaration on that day. It is not marked at all. It has considered this IA in respect to sale agreement.
Where is that
The
document
IA,
which has been marked now?
it is at page number 52, my lord.
50?
52. The typed copy I produced at 53.
What is this?
This self-declaration, it's a total amount due by Vinod Gopi Shetty, due to Vinod Gopi Shetty. It's an alleged acknowledgement of debt, which the defendant has
This
signed.
documents required registration.
Yes, my lord, it falls under the ambit of Article 1 of Karnataka Stamp Act, my lord.
What is this? Yes,
It,
what is
it,
that?
it is squarely falls under the acknowledgement of debt category. If I may read out to you. Karnataka Stamp Act, Article 1.
No, all calculation and all, if it is stamped, Mr., then nobody can write anything. This is that calculation they have made it.
ಇಲ್ಲ
For
ಸ್ವಾಮಿ,
that,
ಅಲ್ಲೇ ಬರ್ದಿದ್ದಾರೆ ಟೋಟಲ್ ಅಮೌಂಟ್ ಡ್ಯೂ ಟು ವಿನೋದ್ ಗೋಪಿ ಶೆಟ್ಟಿ, ಹೂ ಇಸ್ ದ
ಆಯ್ತು.
ಪ್ಲೇಂಟಿಫ್.
ಏನ್
ಕೆಳಗಡೆ
paper ಮೇಲೆ-
ಕೆಳಗಡೆ ಡ್ಯೂ ಬ್ಯಾಲೆನ್ಸ್ ಅಮೌಂಟ್ ಡ್ಯೂ ಬೈ ಬಾಬು ರೆಡ್ಡಿ ಅಂತ
They
ಹೇಳ್ಬಿಟ್ಟು.
can't write anything on the paper.
My lord, it's on this is the only document that they are relying and filed the case, my lord.
Relying on what they are relying on this?
They are relying and telling that ಇಲ್ಲಿ ಕೆಳಗಡೆ 3,50,000 ರೂಪಾಯಿ ಕೊಡ್ಬೇಕು ಅಂತ ಬರ್ದಿರೋ ಕಾರಣಕ್ಕೆ ನಮಗೆ ದುಡ್ಡು ಕೊಡ್ಬೇಕು ಅಂತ ಕೇಸ್ ಹಾಕೊಂಡಿದ್ದಾರೆ. And I can Article 1, my lord, if the court may. Acknowledgement of a debt written or signed by or on behalf of a debtor in order to supply evidence of such debt in any book other than banker's passbook or on a separate piece of paper, which is this, my lord.
What is the
When
stamp
such
duty?
stamp duty is 2 rupees plus rupees 2 for every 1,000 part of thereof, subject to maximum rupees 1,000. Once it is impounded, 10 times penalty.
Now,
has to
where
be
is
levied,
that?
my lord.
You said that their evidence that is posted for marking. Which is that annexure?
Annexure is Annexure B, my lord, page number 26.
Annexure?
B, page number 26. ಅಲ್ಲಿ ಕೊನೆಯಲ್ಲಿ self declaration dated 3/8/2020 is marked ಅಂತ ಹಾಕಿದೆ, my
The
lord.
court has verified the document and hence the document have been marked as shown. Now it is already marked.
Yes, my lord. So that's why even after I filed my IA to impound, the court has gone ahead on the same day marked, my lord. Hence, that portion has to be unmarked. I mean, the document, the IA has to be considered and disposed of, and then the court has to go ahead and further proceed with marking of documents. my lord.
We'll direct it to consider your IA.
Yes, my lord.
Even if it is marked also, court can impound. Now that latest judgment, it can be impounded by that court. That there is no bar.
My lord, my application is at page number 47, my lord.
Yes.
If may kindly. For the reasons stated in the accompanying letter, the defendant humbly prays this honorable court be pleased to impound the alleged sale agreement dated 26/2020 and further document styled as self-declaration dated 3/8/2020.
Yes, I will.
I've
direct
asked
it
for,
to- now,
I've asked for impounding 2 documents, but then the
I have
court
already
considered
filed
for
an
1
objection.
document
I will direct the trial court to decide that application.
first. And what about the document that has been marked, my lord? Can it be
In view of
unmarked?
that judgment, it can be impounded even if it is marked also.
Because after, as per section 35, once it is marked, I cannot question about the marking later on, my lord.
Notice, yes, emergent notice.
Serial number 8.
My lord, stay of further proceedings, my lord.
No, they have already marked. What is that statement?
Illa, Swami, once, because if the court proceeds with the trial, it will pass judgment based on this document, my lord.
Now they are not passing any degree tomorrow, mister. You serve it and go it.
My lord,
Yes, you serve that, mister. Yes.
Serial number 8, Manjunath KS.
Manjunath, serial number?
Serial number 8, Manjunath.
Yes, none appears. Least this matter of.
Serial number 9, Yasin Babu.
For the petition, my lord. Plaintiff's writ petition, my lord.
ಇದನ್ನ move ಮಾಡಿದ್ದಲ್ಲ.
My lord, classic example for fraud, my lord.
Yes, yes, mister.
My lord. Property sold in the favor of the petitioner's mother, my lord, suit for declaration and injunction.
Yes,
Property sold in the year 1996, my lord. Annexure F is the sale deed.
yes.
Now, after the vendor sold the property in my favor in 1996, vendor is already dead. Now, after 22 years, my lord, some stranger, defendant number 3, he creates some notary GPM, my lord, and he executes a sale deed in favor of defendant number 2. Now, my lord, I come to know only when I apply for e-khata. E-khata goskara government authorities appear near the property. Avaga gottagate yardo sale deed agogide anta. After 22 years, when I come, a sale deed is created, my lord, I file a suit for a declaration and injunction. My lord, the trial court, my lord, orders emergent notice, my lord. Despite the sufficient materials are placed, Khata stands in my name from past 25 years, my lord.
No, even today it is in your name.
Please, my lord.
Where is that
Annexure
order
for
of the
page
trial?
number 46 is the
Where is the
Tata, my
order
lord.
of the order of the trial court?
Page number 15 is the injunction, rejection. It has not ordered for rejection or what, my lord? Page number 15, notice, emergent notice anta madidare.
On 7/2, what has happened, mister?
7/2 is tomorrow, it is likely to come, my lord. Notice returnable anta. Emergent notice anta madirodu.
They may decide on that day. Plaintiff is challenging the sale deed dated so and so. We'll have it on Monday. Let us see. What
My lord, there is urgency, there is not to alienate, I have
No,
thought, my lord.
tomorrow matter is there. We'll see that what will happen.
My lord,
My order will not be influenced for that to decide. We'll have it on Monday. Let us see on that.
please.
Yes.
Serial number 10, HM Madhusudana.
Lord, if appears ಅವರು decide ಮಾಡಿ ಅಂತ ಒಂದು order ಬರೆದ್ರೆ better.
If you want, I will dispose of now itself, directed them to decide that your application.
If they tomorrow appear, the
They
trial
have
could
not
be.
appeared, then the problem.
Sorry,
Then I can say that after service, matter can be heard and disposed of.
please, my lord, I will Monday, please.
Monday.
Serial number 10,
The petition, Lord. The defendant's petition, Your Honor, may kindly appreciate the page number 12 of the text. It's suit for partition. Page number 12, the plaint. The plaintiff has filed the suit against the defendant number 1 to 4. Defendant number 1 and 2 are the father and mother. 3 and 4 are the sisters. In respect of item number 1 property, we don't have any dispute. In respect of item number 2 property, Your Honor, may kindly appreciate page number 13 of the plaint. Paragraph number 5. The plaintiff submits that in suit schedule item number 2, residential house has been constructed by availing loan from Union Bank of
Now,
India.
what is that order you are telling?
6/16 application has been filed by the defendant number 2 mother in order to strike out the said property. ಅದು ancestral property ನಾವಲ್ಲ ಜಾಯಿಂಟ್ ಫ್ಯಾಮಿಲಿ ಆಕೆ ಸ್ವಂತ ಸ್ವಾಯತ್ತ ಖರೀದಿ ಮಾಡಿರ್ತಕ್ಕಂಥ ಸ್ವತ್ತು ಪಾರ್ಟಿಷನ್ ಅಂತ ಹಾಕೊಂಡಿದ್ದಾರೆ ಸುಮ್ಮನೆ. ಇನ್ ರೆಸ್ಪೆಕ್ಟ್ ಆಫ್ ಈಗ ಇವರ ಆ ಪ್ರಾಪರ್ಟಿ ಆನ್ಸಿಸ್ಟ್ರಲ್ ಬರೋದು ಆನ್ಸಿಸ್ಟ್ರಲ್ ಅನ್ನೋದಕ್ಕೂ
ಆಯ್ತ್ರಿ, ಅದು ಟ್ರಯಲ್ ಅಲ್ಲಿ ಡಿಸೈಡ್ ಆಗುತ್ತೆ ಬಿಡಿ. ಈಗ ಯಾಕೆ ಸ್ಟ್ರೈಕ್?
ಅಲ್ಲ, ನನ್ನ ಕೇಸ್ ಏನಂತ ಒಂದು ಮೆಮೋ ಹಾಕಿದ್ದೀನಿ ಸ್ವಾಮಿ. ಇನ್ ರೆಸ್ಪೆಕ್ಟ್ ಆಫ್ ಐಟಮ್ ನಂಬರ್ 1 ಪ್ರಿಲಿಮಿನರಿ ಡಿಗ್ರಿ ಮಾಡ್ಬೋದು. ಐಟಮ್ ನಂಬರ್ 1 ಪ್ರಾಪರ್ಟಿ ಎಂಜಾಯ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಪ್ಲೇಂಟಿಫ್. ಡಿಫೆಂಡ್ ನಂಬರ್ ಈಗ ಏನಾಗಿದೆ, ಈ ಬೈ ವರ್ಚು ಆಫ್ ದಿ ಪ್ರೊಲಾಂಗ್ ದ ಮ್ಯಾಟರ್ ಐಟಮ್ ನಂಬರ್ 1 ಪ್ರಾಪರ್ಟಿನೂ ಅದರಲ್ಲೇ ಇದಾಗಿದೆ. ಆ ಮೆಮೋ ಮೇಲೆ ಕೈಂಡ್ಲಿ ಪಾಸ್ ನೆಸರಿ ಆರ್ಡರ್ ಸಂಸ್ಥೆ ಅಂತ ಹೇಳಿದ್ರೆ ಸಾಕು.
What is that memo?
In order to dispose in respect of item number 1 property, the memo is that statement ಜೊತೆನೆ ಹಾಕಿದ್ದೀನಿ. Page number 44, annexure G, Mala. Item number 1 property, the defendants in the above case already filed the counterclaim in respect of their share in item number 1 of the social property. Hence, the defendants have no objection to pass preliminary decree ಅಂತ. ಅದು ancestral property ನೇ ಇದೆ. ಅದ್ರ ಮೇಲೆ preliminary decree ಆದ್ರೆ ಪ್ರಾಪರ್ಟಿ ಡಿಫೆಂಡೆನ್ಸ್ ಅವರು ಸ್ವಲ್ಪ ಎಂಜಾಯ್
No, that
ಮಾಡ್ತಾರೆ.
cannot be, mister. All property has to be divided at a time. You can't say that one it is decide and other.
ಅಲ್ಲ
You
ಸ್ವಾಮಿ,
agree for
ಯಾಕಂದ್ರೆ-
all, they will decide it.
ಅಲ್ಲ, ಎಂಜಾಯ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಸುಮ್ಮನೆ. ಪ್ಲೇಂಟಿವ್ ರೆಂಟ್ ತಗೊಂಡು ಎಂಜಾಯ್
No,
ಮಾಡ್ತಾ
that is not that. What is that order you are challenging here?
6/16 application, my lord. 6/16 application filed by me.
What is that?
Your
order?
Honor, may kindly at ink page number annexure, impugned order at annexure J, page number 50, my lord.
50.
50. In page number 54 ಅಲ್ಲಿ reasoning portion ಅಲ್ಲಿ ಇದೆ.
Defendant filed IA order 6 through striking of the pleading in respect of the suit item. Unless failures to exercise process of interest.
Page number 54 ಅಲ್ಲಿ ಲಾಸ್ಟ್ ಅಲ್ಲಿ ಸುಮ್ಮನೆ.
Yes, the defendant related this property as so legal. CH-11, so defendant's property. This is also become absolute one of the suit property for the defendant. As we discussed about this share. Yes, let the court to decide whether it is a joint family properties or not.
ಅಲ್ಲ ಸುಮ್ಮನೆ ಡಿಸೈಡ್ ಮಾಡಲಿ, ಯಾಕಂದ್ರೆ ಐಟಮ್ ನಂಬರ್ 1 ಪ್ರಾಪರ್ಟಿ ಬಗ್ಗೆ ಡಿಸ್ಪ್ಯೂಟೇ ಇಲ್ಲ.
See, ಇದಕ್ಕೆ dispute ಇದೆ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಅದನ್ನೆಲ್ಲ you let that be given evidence in this matter also. Everything will be decided. That's all.
ಸ್ಪೀಡಿ ಡಿಸ್ಪೋಸಲ್ ಆಗಿ.
Yes. Now what is the stage?
ಇಶ್ಯೂಸ್ಗೆ ಅಂತ
ನೀವು ಈ ತರ ಒಂದ್ರ ಮೇಲೆ ಒಂದು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ರೆ ಎಲ್ಲಿ ಸ್ಪೀಡ್
ಯಾವ್ದು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಲಿ, ಇದು ಫಸ್ಟ್ ಅಪ್ಲಿಕೇಶನ್ ಇದೆ.
ಅದೇ ಈಗೇನ್ ಗೊತ್ತಾ, even if it is your self acquired property, it is not a joint family property. You can argue by filing a return statement.
Return statement fail ಆಗಿದೆ.
ಮತ್ತೆ ಈ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಕ್ಕೆ
return statement counter claim has been filed already.
See, then court will decide which are all the joint family property, then it will give a share. You unnecessary, you filed an application and yes, this petition is filed by defendant number 1 and 2, challenging that order dated 19/12/2024, passed by Senior Civil Judge JMFC Dodbalapura on IA number 4, filed by that petitioner under Order 6, Rule 16, to strike out the pleadings in respect of suit item number 2. The same aim to be dismissed. The plaintiff has filed suit for partition and separate possession. After service of summons, defendant appeared through counsel and filed a written statement as admitted that suit item number 1 is joint family property. Suit item number 2 is a self-acquired properties of the defendant number 2. Defendant number 2. Therefore, they have filed this application under Order 6, Rule 16, Order 6, Rule 16 to strike out the pleadings. Since the defendant has claimed that they have purchased this suit item property, the name of his mother,
Plaintiff claims.
out of the income of the defendant number 1.
Plaintiff claims.
Huh?
Plaintiff's claim.
Yes. But defendant has claimed that the suit item number 2 is the property belongs to that defendant number 2. It is self-acquired property. It is not a joint family property. The specific case of the plaintiff is that suit item number 2 was purchased in the name of his mother. Mother, out of the joint family income. That issue has to be decided by the trial court after hearing that parties. At this stage, that suit item number 2 cannot be strike out the pleadings. Therefore, trial court has rightly rejected that application. There is no error or irregularities in order passed by the trial court. Accordingly, the writ petition is dismissed.
Cell number 11, Ashok P. Patil for petitioner.
The
Rakshita
trial
TK.
court is directed to dispose of the suit as expeditiously as possible, not later than 1 year from date of receipt of copy of this order. Parties are directed to
Lord, this matter.
assist for early disposal. Yes.
Lord, this
For
matter,
the
we've entered
petitioners,
cases.
my lords.
Seek for 1 day's time. Monday it may be taken up. Seniors appearing in this matter. Today some personal inconvenience.
Yes,
Monday.
Mr. Patil.
Next date before trial court is on 24 of my lord. So Monday it may be taken
And
up.
request 13th, my lords.
Please.
13th, yes, 13th. Yes.
On that day, let them.
Please, no, we won't.
Yes,
That day we will
13th.
be there.
At the
Cell number
request
12.
of counsel for the respondent,
Sampath.
please this matter on 13th.
Lords, my lords, I undertake to take notice for respondent number 12 in this matter.
Serial number?
Sir,
Well,
cell-
number 12, my lords.
Yes.
But there is some urgency, my lords, with that. Of course, my learned friend, I'll serve a copy on it.
Yes.
The order, my lords, impugned is filed by the LRs of defendant number 1 for appointment of an handwriting expert. My lords, that is for comparison of a Palupatti, my lords, suit for partition, my lords, between plaintiffs and defendants. Defendant number 1, my lords, took up contention that in the year 1990, there has been a Palupatti, my lords, wherein the properties came to be decided. Now, my lords, to establish that this Palupatti, my lords, I have examined DW2. DW2, my lords, has denied his signature found on exhibit 120, D123.
Yes.
Now, my lords, since he has denied his signature, as well as the Panchayat Parikar, I wanted this document to be referred to an handwriting expert. That application, my lords, is rejected. My lords, on the last occasion, your lordship wanted to know, since this document, exhibit D123, has been marked subject to objections, whether, my lord, such a document can be referred.
Yes.
My lords, there are 2 judgments on this point.
Why it is objected for marking?
Well, it's because it's an unregistered document.
Register.
It's an unregistered document, my lords, and the law on the point would be, even an unregistered document, my lords, can be looked at for collateral purposes. Sorry, excuse me.
No, it can be looked at to collateral purpose.
Correct.
Can it be referred to that handwriting?
Correct, my lords. That is the point, my lords, now.
Yes.
In fact, my lords, on the last occasion I submitted. Now, once, my lords, a
No,
document
is it the judgment related to that?
correct, my lords. My lords, in the first judgment, my lords,
Yes.
here also, my lords, an application under order 26 rule 10A
Hmm.
came to be rejected, my lords. That, my lords, will find in paragraph number 3. My lords, the relevant portion, my lords, is para 5.
Yes.
My lords, this is the submissions made by, in this case, Contra Learned Counsel Srinivas, so and so, would contend that Exhibit D18 is an unregistered document which has no evidential value, and the trial court is justified in rejecting the application. Kindly, my lords, have para 6, my lords. Having heard the learned counsel appearing for parties and on perusal of the writ petition papers, I am of the view the trial court committed an error in rejecting the application IA number 7 filed under so and so. My lords, the finding, my lords, is in the next paragraph, my lords, next page, page 6. In the middle of, my lords, about 4 lines. When the petitioner plaintiff has denied signature on Exhibit D18 for whatever purpose, kindly, my lords, note the word, when the document is on record, petitioner defendant is justified in filing an application. My lords, the Honorable Court, my lords, said the document could be marked for whatever purpose.
Yes.
My lords, there's another judgment, my lords, I have also my lords, kindly have, my lords, page 6, page 8, para 5, my lords.
Yes.
My lords, per contra, learned counsel for
Which one you are relying on? Same
page
judgment.
8, para 5, my lords.
Para 10.
Para
Page 8,
5,
Page 8.
Page 8, para 5, my lords.
Yes.
Per contra, learned counsel, the defendant also contended Exhibit D66 was not subject to objection, just in our case, my lords.
Yes.
He contends that Exhibit D66 was not duly stamped and was not registered. Therefore, no purpose would be served in allowing the application, allowing defendant 6 to 8 to prove the said document as the same is inadmissible in evidence. Then, my lords, may kindly have page 10, my lords. I read from 3rd line, my lords.
Yes.
They also claimed that the plaintiffs are signatories of Palupati dated so and so. Though
Yes.
this document is marked as Exhibit D6 is subject to objection, this court document could still be looked at for collateral purposes, namely that plaintiffs and defendants severed the status of joint family.
Yes.
Therefore, last 4 lines, my lord. However, since this is a crucial fact that the defendant 6 to 8 had to prove to establish that the sale in their favor is just and lawful, an opportunity deserves to be granted, so and so. My lords, the courts have said, my lords, for whatever purpose it is marked, my lords, it is duty of cast on me to prove the document. This is one of the more.
Lordship, matter may be posted next week, my lords. Senior is not well, he's.
Yes.
I have no objection, my lords, but the matter is on Monday, my lords, for evidence.
Yes.
Therefore, I
My
request
lord,
for a.
matter
Then
is
we will
posted
take
for
up for-
arguments.
Huh?
Matter is posted for arguments in the.
That-
No, that's why he wants to stay. No, if you are agreed, I will allow and dispose of that.
Lordship
for-
next meeting.
Yes, how issue notice. You will take notice to whom, Mr.?
Respondent number 12, my lords.
Respondent number
12.
12. Who is 12? 12 is that the defendant.
His
Number 4.
Defendant number 4, my lords, whose
Plaintiff is the
DW2,
necessary party.
yes, who was disputed that document.
Yes. Stay of further proceedings in OS number 28 of 2012, pending in the file of Senior Civil Judge JMFC Dodbalapura till next date of hearing. So and so. R1 to 04. So and so is undertake to appear for 1 to 4. You are for
I undertake to take notice for
R1 to 4.
11 and 13.
11 and 13. So and so for 11 and 13. Name 12.
12, my lords.
12. Remaining notices to go. Yes. Notice to other response.
Sorry, my lords, the others are formal parties, my lord. The others are formal.
File in a memo. Other.
I'll do it on the next day.
Short.
Only file it. Will dispense to others.
Akbar,
The
I'll
date
file-
may be fixed.
Are there a memo put in there? Dispense. Yes.
Lordship, date may be fixed in next.
Birth. Yes. Get ready. Yes.
Serial number 13, Satish
Sir.
TS.
Lords, I am the member of the
Indian Pest Control Association. What mandates me,
87.
any government order, I have to be a member of the Pest Control Association to carry out the. This being the case, I'm also a management committee member of the first respondent. First, it's my suit. I had filed a suit against the issue of show cause notice and disciplinary proceedings against me. Plus, what happened was, in an AGM conducted on 10/8/2024, there was a question I asked in the AGM, wherein, my lords, the allegation is at ink page 9. It's a very trivial question, my lords. At para 3B.
No, the suit filed by you for what?
Declare that the show cause notice at annexure E is null and void.
Why you are challenging the show cause notice? You have to face for it.
But what happened is, the matter is very trivial.
No,
And
what
as
is that?
per the annexure F, their own rules.
No, what
rules
is
of
that?
theirs.
What is that order you are challenging now?
Non-issuant of emergent notice, they didn't issue me the stay. I had asked for
The
stay of
stay-
the show cause notice.
Stay of show cause notice. Why?
Yes,
What will happen to that show cause notice, Mr.?
They have initiated disciplinary action. I have replied to the show cause notice. Then they have initiated disciplinary action, which is against the procedure. And they are also planning to suspend me from attending any meetings.
That you can challenge suspension if we can say it, stay.
But
Not that conducting any inquiry.
No, why I am saying annexure D, page 53. Class 9, sorry, 57. Class 9, it mandates that any action, I'll read out, it's 9.3. When any complaint is received by the General Secretary, he or she shall investigate immediately and he shall bring to the notice of the President, who shall make it attempt to resolve the complaint satisfactorily between the members concerned, and if it public is not, he or she shall make effort to bring about satisfactory settlement of the complaint. When the matter is settled, the President will inform the management committee. If the matter is not settled, the disciplinary committee shall be formed to probe the matter, consisting of a current President, immediate past President, and one active member, nominated by the agreed member, public for inquiry. This procedure they have not followed. What happens, my lords, if they down the it was posted for 29/1/2025, my lords. They appeared and they did not file any objections or any written statement. It is posted for 14/3. By that time, my lords, I shall be suspended or terminated from my membership. If that happens, my lords, then I shall not be able to take up any government orders or any tender participation. That is the only issue, my lords. And what is
Where
that?
is your application?
My lords, my application is at annexure. Annexure C, my lords, at ink page 26.
Yes, heard, issue notice. Who has issued that notice?
Respondent number 3, my lords.
Respondent number 3 is directed not to precipitate that matter pursuant to that show cause notice dated 8/9/2024 till next date of hearing. Yes.
Number 14, at least.
Not to precipitate pursuant to that notice, Mr.
obliged.
What they can do it, yes.
I may be continued in the MC. I'm also a MC member.
All that we are not that.
Obliged.
Yes.
Hearing for the petition and this one. Lord, it's defendant's petition before my lord.
Yes.
Suit is one for declaration, my lord, seeking for setting aside of the registered deed of sale certificate, page 38, if your lordship comes to. The
Yes.
prayer sought in the plaint by the plaintiffs is firstly to declare that issuance of sale certificate dated 28/11/1992, my lord, in favor of one S. Chandrasekhar, who is my grandfather, as null and void.
Yes.
Second prayer is to declare that registered deed of release dated 13/6/2005 in favor of defendant number 8 is null and void.
Yes.
Prayer C, my lord, to declare that the alleged registered deed of settlement
Yes.
dated 2/11/2010
Yes.
executed in my favor as null and void.
Yes.
And also for permanent injunction.
Yes.
Now, my lord, kindly see the schedule, my lord. Next page, page 40 is the schedule.
Yes.
Immovable property situated at Mangalore Taluk, Kodriya Vale, 89A, Bejaji Ward of Corporation City of Bangalore.
Yes.
Within the Mangalore City registration sub-district so and so, my lord.
Yes.
Now, this,
No,
my lord,
this, what is that extent is only 43
cents.
cent.
Please, my lord.
For that, there are 3 sale deeds.
Please, what happened, my lord? My grandfather purchased in court auction, my lord.
Yes.
Sale certificate was issued by the court in the year 1992.
Yes.
Subsequently, there has
They have, yes.
released it, and subsequently, in my favor, it is now I am the owner, my lord.
Yes. Now, what is that order you are saying?
13, my lord. The suit is valued under 24D of the Karnataka Court Fees and Suits Valuation Act.
Yes.
Only rupees 75 is paid, my lord.
No, even for declaration also.
Please, even for declaration, para 13 page.
No, what is that order passed by the trial court?
Annexure A, my lord, page 17 onwards.
Yes.
My lord, I preferred an application under section 11 to decide this issue as preliminary issue.
Yes.
Now, my lord, the court at para 23, para 7 onwards,
Yes.
gives reasoning. It has
But the
rejected
right is
my
not
application
executed on
mainly on the ground that
Please seeking a declaration certificate to release. So on, so, market so on, so. Yes.
page
Or
12
issue notice. Stay of further proceedings in OS number 51 of 2019. Pending in the file of 3rd Additional City Civil Judge Mangalore till next date of hearing.
Cell number 15, Ravi HK.
Yes, Mr.
This is a matter wherein the subject land, my lord, belongs to the petitioner.
Hmm.
However, my lord, the family members of the vendor
Hmm.
of the property, my lord, they collude and file a suit for partition
Hmm.
and enter into a compromise and obtain a compromise decree.
You are also a family member.
No, my lord. In fact, the father of the plaintiff, my lord, in the suit,
You
sold
come
the
to
property.
that, you come to that plaint.
Kindly see, my lord.
Plaint, where is that plaint?
Lord, plaint is at page number 43, annexure H.
43.
The family members of one Subramaniam, my lord,
Hmm.
they filed suit for partition
Against whom?
against their own family members.
Hmm.
And they enter into a compromise petition and get a compromise decree.
Hmm.
Incidentally, this Subramaniam himself had sold the property in favor of my father-in-law,
Oh, you are the purchaser.
purchaser.
Hmm.
Without bringing to my notice, they enter into a compromise in order to get a decree to create third-party rights.
Hmm.
Therefore, the decree has been obtained by playing fraud and misrepresentation of facts. On that ground, my lord, the petitioner has approached this honorable court. Kindly see, my lord, it's a very old sale deed, my lord.
Where is the degree passed by that?
Annexure A, my lord. Page number
Passed
60.
in where? In Lok Adalat or court?
Lok Adalat.
If it is a court, writ is not maintainable.
In Lok Adalat.
Where is that?
Annexure A, page number 60.
16.
16.
They have parties that partition has been settled. Parties are settled
Yes, my
for
lord. Yes,
partition.
Yes, my lord.
No, you, property purchased by you is allotted to whom?
Property was purchased by my father-in-law, my lord.
Yes, yes.
From father-in-law, it
Ultimately,
came to
it
my
comes-
husband.
Yes.
And right now, I am the owner. Kindly see, my lord, sale deed at annexure D, page number 31.
Which is the property it is sold to you, Mr.
Lord, land in survey number 219/1, measuring 1 acre 22 guntas.
Your
Thus,
grievance is only to that extent.
only to that extent. In fact, that particular extent has been divided amongst the parties to the suit.
Yes.
Kindly see, my lord, the sale deed in favor
I
of
will direct that to not to create any third party interest in respect of that property. That is what that property you have to be.
Yes, my lord. The decree should not be misused, my lord, because that is their
No,
intention.
therefore, on the degree, they should not alienate to that any parties.
Lord, the decree itself may be stayed because,
No, other properties, why do you are concerned?
Lord, this decree, my lord, has been drawn only insofar as this property.
There is no other properties.
Yes.
No, there are so many properties are there.
Lord, so far as final decree is concerned, my lord, annexure A.
No,
kindly
all only 219 only.
Yes, my lord.
What is that extent, total extent?
Out of 1 acre 22 guntas is what they write.
1 acre 22.
Yes, my lord.
Yes, or issue notice. Stay off. What is the date of the degree? Compromise degree date. Where is that compromise? It is in the court.
It's before the Lok Adalat, my lord.
Where is that?
My lord, the order is at page number 57, my lord. Dated 16/3,
50,
16/3/2024,
57.
57. Compromise petition is at 51, my lord.
Yes, it is before the local content of a compromise petition has been read over and explained to the parties and they have been submitted. Yes. Or issue notice. Stay of operation of compromise degree passed in OS number 525 of 2023. What is the date, Mr.?
Lord, dated 16/3/2024.
In prior date, how can that be, Mr.? How can such a relief can be started? No objection has been raised.
Lord, in fact, in the final decree, my lord, they don't mention the date. As per the order,
If it is a compromise, why
Yes.
are you going to that final degree?
Yes, madam.
Compromise itself is,
the order is at page number 56, my lord.
what is the date?
16/3/2024.
Stay of operation of the compromise degree dated
16/3/2024.
16/3/2024 passed in OS number 525 of 2023 in the file of Municipal Civil Judge and JMFC at Nanjangud, Mysore district till next date of it.
Serial number 16, Umesh MN.
For the petitioner, please. I am permitted to file power for the respondent number. 6, my lords, please. Num caveat, ಅವ್ರದ್ದು appeal ಆದ್ಮೇಲೆ file ಆಗಿತ್ತು ನಮ್ ಗಮನಕ್ಕೆ ಬಂದಿದೆ.
Yes, serial number ಎಷ್ಟು?
Sir, serial number 16.
ಆಫೀಸರ್ ಮಾಡಿದ್ರೆ
ಈಗ ಅಪಿಯರ್ ಆಗ್ತಾ ಇದಾರ ಹೌದು ಐನೋ ನಮ್ಗೇನ್ ಕೇಳಿ ಪರವಾಗಿಲ್ಲ.
ಇಲ್ಲ ಸರ್.
ಅಲ್ಲ ಆಯ್ತು.
ಕಳಿಸಿದ್ವಿ,
Now
ನೀವು
he
ಅಪೀಲ್
wants-
ಆಗ್ಬಿಟ್ಟಿದ್ರು ಸ್ವಾಮಿ. ಆದ್ರಿಂದ ಪುಟಪ್ ಮಾಡಿಲ್ಲ ನಾವು.
Now he wants time. You have any objection? Is there any urgency? Let
Madam,
that-
I will serve the copy on him.
Yes.
ಆಫೀಸರ್ ಮಾಡಿ.
When do you want?
ಮಂಡೇ
Monday ಬೇಡ, Tuesday.
ಟ್ಯೂಸ್ಡೇ
Tuesday or Wednesday. Tuesday or Wednesday.
Yes.
ಆಯ್ತು, ಟ್ಯೂಸ್ಡೇನೆ ಆಗ್ಲಿ ಸರ್.
Wednesday.
ಆಗ್ಬೋದು.
You will take notice to whom, Mr.?
ಫಾರ್ ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್
All respondents.
1 to 6.
1 to 6.
1 to 6.
Yes. ಇನ್ನು ಸುಮಾರು ಜನ ಇದ್ದಾರೆ.
So ನಾವೇ contested, so
Others you will discuss.
now 1 to 6 contested. We are the owners of the land.
Yes. So and so undertake to appear for respondent number 1 to 6. Learned counsel for the petitioner has filed a dispensation of notice to so and so. Office is directed to show the name of so and so. Counsel for the petitioner is directed to serve 2 sets of copies on so and so. Leave this matter on 12th.
Please.
Much.
Serial number 17, Narendra S.
Yes.
Plaintiff writ petition, my lord. Suit is one for partition and separate portion, my lord. Plaintiff is one of the joint family member, my lord. Respondents 1 to 10 are the joint family members, my lord. My lord, during the pendency of the suit, my lord, a joint development agreement has been entered by the parties, respondent 1 to 10,
With whom?
with the proposed respondent 11 and 12, my lord. With the same social properties, my lord.
Suit
Developed
for-
suit for partition and separate portion, my lord.
Yes.
Behind the back of the,
Yes,
Petition-
there is a JDA. Yes.
please, my lord,
Now
coupled
what?
with GPA, my lord. I have filed an application to implead the,
You have
proposed
filed an
respond-
application.
please, I have filed an application for implead the respondent number 11 and 12, my lord, in the said suit, my lord. Court has rejected the IA without assigning proper reasons as per annexure A, my lord.
Page,
They are not necessary parties.
page.
Page, my lord, the operative portion on IA for order number 5, my lord, internal page 13, my lord.
Yes.
Solely on the ground that, my lord, they are not necessary parties. The trial court has rejected the IA filed by the petitioners.
Yes, where is that? Order. Read.
My lord, internal page 14, my lord. It is to be noted that order 1 rule 10 of CPC empowers the court to add parties
That is not the court or the parties. The plaintiff is the master of the suit. He can add the parties and delete the parties. The court has observed that, my lord, court has the power to either to add the parties or delete the parties.
That
Further,
is
my
what
lord,
that 10-2 says.
please.
Order 1-10-2, it is
please,
for the
please, please.
discretion of the court.
Please, further, my lord. The same social properties has entered in the JD between the parties, my lord. There is nothing survives if they develop and they alienate the social properties. Before arraying them as a party, I can't file an injunction against those proposed respondents, my lord. If I add them as a parties only, then only I can restrain the acts of the proposed defendants 11 and 12, my lord. My lord, my rights have been involved in the above suit. My lord, suit is one for partition.
Yes.
Behind my back, this JD has been entered by the respondents 1 to 10 herein, my lord.
You take notice. Issue emergent notice.
Sought for stay, my lord. My suit has to be further proceedings, sir.
How, see, when you are asking for an entry order, you should think how we will get that your suit is stayed. Benefit, mister.
Stay of the
Yes, you want to implement so A, B.
Please, my lord.
They are out of that. Now, if you get it stayed, your suit will be stayed.
Stay
Stay
of-
will not affected, mister.
Stay of the impute order, I'm sorry, my lord. Stay of the impute. I'm sorry.
Stay ಮಾಡಿದ್ರೆ ಏನ್ ಸಿಗುತ್ತೆ ಅವ್ರು ಇಂಪ್ಲೀಡಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್ ರಿಜೆಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ. You take notice, mister. ನಿಮ್ ಸೂಟ್ ಅನ್ನು ಸ್ಟೇ ಮಾಡ್ಬಿಟ್ಟು ಅವರು ಆರಾಮಾಗಿರ್ತಾರೆ, ಅವ್ರು ಹೊರಗಡೆ ಇದ್ದಾರೆ, they have not impleted. Why do you want to stay that suit?
My lord, the developments have been going on, my lord.
ಆಯ್ತು ನಿಮ್
I am permitted to serve the trial court advocate also.
ಸ್ಟೇ ಮಾಡಿದ್ರೆ ಅವ್ರ ಡೆವಲಪ್ಮೆಂಟ್ ನಿಂತೋಗುತ್ತೇನಪ್ಪ, ಅವ್ರ ಪಾರ್ಟಿನೇ
please.
ಆಗಿಲ್ಲ ಇನ್ನು.
My lord, kindly state date may fix, my lord. I am permitted to serve the
Serve it and move that. After
My lord.
service you can.
trial court advocate also permitted to serve the trial court advocate.
I will grant any stay. I will say that post is for next year. You serve it and move it. Yes.
My lord, I am permitted to serve the trial court advocate also
Okay.
along with
No, he has not yet impleaded whom he will be served, mister.
other defendants, my lord.
ಅವ್ರಿಗೆ ಯಾಕೆ ಬೇಕ್ರಿ? ಬೇಕಾಗಿರೋದು ಇಂಪ್ಲೀಡಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್ ರಿಜೆಕ್ಟ್ ಆಗಿ. Yes.
Bill number 18, Bharatiyam.
For the petitioner in this case, my lord.
Yes.
Here the petitioners have, is a respondent number 1 in a suit for partition filed by respondent number 1 to 3, my lord. Respondent number 1 to 3 have filed a partition suit number OS number 20 of 2012, my lord. Here respondent number 1 is petitioner has been marked as a ex parte, my lord. On judgment, I have filed an RA. On limitation
No,
application, I have been rejected, my lord.
Suit is decreed.
Suit is decreed, my lord. RA has been rejected on limitation application. I filed application after 6 years, 8 months, my lord.
Now, what are you doing?
My lord,
Now, who are you? You are a family member or you are a person?
I am a family member, my lord.
what is
I
that?
have produced the family tree, my lord. May I take to the,
No, that is not that. I just asked you, when the degree has been passed in the year 2016,
yes, my lord.
what are you doing from that day?
My lord, I have given the entire document to my counsel. I have said this in my affidavit also, my lord. My counsel was not well. He was not contesting the matter. I was not aware on that fact.
No,
And I couldn't come down with,
forget about that merit of the degree. After the degree, to file an appeal, how many years you have took?
6 years, my lord.
Then for that, what is your explanation?
That's my lord, my counsel. During the proceeding only, I don't know if the degree has happened also, my lord. During the proceeding
not-
of the OAS itself, I have given to my counsel. My counsel was ill and he was passed away also, my lord. I filed my affidavit. But in 2022, I was also suffering with joint pains. And I have produced my medical certificate also before the trial, my lord.
No, after that preliminary degree passed in that partition,
Yes,
are they not filed in a final degree proceedings?
they have raised it, my lord. It's on Saturday. FDP is on.
No, see, when that notice is served to you in that final degree proceedings, that is the simple. Then you are aware from that final degree proceedings itself.
No, they have initiated final degree proceeding very recently. Monday, my lord.
That when you have received that notice in the final degree proceedings.
My lord, can you have tomorrow, my lord? I'll get entire detail, my lord, because on Saturday, the final degree proceeding is it.
Let them, you are entitled for the share, they will give it. Yes. Leave this matter on Monday.
My lord, Saturday ಇದೆ ನಾಳೆನೇ ಇರ್ಲಿ ಸ್ವಾಮಿ.
Saturday ಇರ್ಲಿ ಬಿಡಿ ಏನಾಗುತ್ತೆ?
ಇಲ್ಲ FDP proceeding ನಲ್ಲಿ they have appointed the court
You are
commissioner.
not allowed, are you in the possession of that property?
I'm my lord.
Then you naturally you are dragging this. Yes.
No, my lord, I'm not dragging it, my lord.
No, you are in the possession, you are not allowed to partition.
Lord, I'll
I have not filed, otherwise I will pass an order on merit itself now that I will
My lord,
dismiss.
one simple. This is not one suit. It has been filed, my lord. Right from 2006, they have filed. I filed all the partition suits.
Tomorrow, yes.
Please, my lord.
Cell number 19, Narendra, yes?
For petition discussion.
Yes.
Lord, it's proposed impleading applicant's writ petition, my lord.
Hmm.
Suit is one for partition separate possession, my lord.
Yes.
An impleading application has been filed by the proposed defendant in this case, my lord,
Hmm.
to implead himself as a party, my lord.
Suit for partition.
Suit for partition, my lord.
Who are you?
The present suit is for declaration, my lord. The declaration suit filed by the respondent one herein, without arraying me as a party to the said proceedings, my lord, claiming that property is granted in the name of her husband.
No, you come to that suit.
Suit, my lord, plaint is in the internal page B, annexure B, my lord.
This Rangama has filed in a suit for declaration.
Declaration.
What is that declaration?
Declaration that, my lord, it's in Kannada, my lord, prayer is
ನಮ್ಗೆ ಓದ್ತೀವಿ, ನಮಗೆ ಗೊತ್ತಾಗುತ್ತೆ. Yes.
ವಾದ್ಯ ದಾವಾ ಸ್ವತ್ತಿನ ಪರಿಪೂರ್ಣ ಮಾಲೀಕರೆಂದು ಮತ್ತು ಅವರು ಸದರಿ ದಾವಾ ಸ್ವತ್ತಿನ ಮೇಲೆ ಸಂಪೂರ್ಣ ಸ್ವಾಧೀನ ಹೊಂದಿರುತ್ತಾರೆಂದು ಉದ್ಘೋಷಿಸಬೇಕೆಂದು ಮತ್ತು
Declaration that she on the basis of that partition deed.
Please, my lord. Without arraying earlier to this,
Who are you then?
I am none other than the brother of the husband of the respondent one here in my lord. A separate suit has been filed by the very same respondent along joining hands with this petitioner. In OS number 184 of 2020, my lord, annexure E is the plaint filed in the seeking partition, my lord. The without leaving this property, claiming that has been granted in favor of her husband, she filed a separate declaration suit. It's inured to the benefit of the rest of the family members. That is the settled law, my lord. As per this honorable courts in ILR 2015, my lord, any land granted in favor of any male member of the family will inure to the benefit of the.
In the family, there was a partition in the year 2005.
That has been questioned in the. She has joined hands. There was no partition. That there was no partition, my lord.
Then what is that on 27/10/2005?
My lord, kindly peruse the prayer sought in the annexure.
ಅದನ್ನೇ ನೋಡ್ತಾ ಇದ್ದೀನಿ. There was no partition.
There was no partition.
You have filed in a suit for partition now.
We have filed a suit for partition.
Which is that suit?
Annexure E is the, my lord. Internal page 38 is the plaint. Kindly peruse the first plaintiff is Srimati Rangama. That is the very same respondent one hearing.
This property is also in a suit schedule property.
Please, that has been. Please,
Where is that plaint scheduled?
That has not been included in this suit, my lord. She claims that has been granted in favor of her husband. Deliberately.
Our ಮಾಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ you can seek for.
That's what I sought for impleading myself in the suit for filed by her for seeking declaration, my lord.
ಅದು ಬಿಟ್ರೆ partition suit ಅಲ್ಲಿ have you included this property?
I have joined hands with along with me. She has filed a suit for partition, my lord. Application is yet to be considered before the trial court, my lord.
No, have you filed an application in the joint partition suit saying that property in this suit scheduled properties is in a joint family property?
Yet to be filed before the trial
Yet
court,
to
my
be
lord.
filed 2020 suit, mister. If that is the joint family property, if you have any right, you could have asked to include that property, whether you may be a defendant or a plaintiff.
Please, either of the parties can add the.
What is your interest to implead in that declaration suit? If it is in a partition, if it is in a joint family property,
Please,
it should be a part of that partition suit. It is not there. Then it is in a self-accord. She is seeking for a declaration. What is your presence in
Lord,
this
the land granted in favor of husband of the respondent one hearing, it will inure to the benefit of rest of the joint family members. That is the contention taken by me in the impleading application.
That means to say that property should be available for the partition.
Please, my
In
lord.
partition suit, it is not there. You have also not raised 4 years. Then now how can you say that?
Trial court has rejected only.
You take notice.
Stay of the impugned order, my lord.
No, mister.
Cell number 20, Nandish Gowda GB.
Yes.
Plaintiff writ petition, suit for injunction.
Yes.
Application filed for temporary injunction, restraining the defendants, my lord, to not change the nature of the suit scheduled property.
Suit for?
Injunction, bare suit for injunction.
Yes.
My lord, the trial court dismissed the application and the first appellate court, my lord, confirms the order.
Injunction for not to
My lord,
interfere.
No, it is what happened, my lord. Defendants number 2 to 4, none other than my own brothers. Scheduled property, my lord, survey number 78. Total extent, my lord, 36 kuntas, my lord. It was my father purchased under the registered sale deed 1994, not in dispute. Thereafter, my lord, in the year 2021, my father himself has filed a suit against us, against the children.
No, now you are sued for injunction.
Alla ಹೇಳ್ಬಿಡ್ತೀನಿ. That suit ended in compromise.
Yes.
And scheduled property, my lord, in the compromise, my lord, fallen to my share in the year 2021.
Yes.
And towards western side, my lord, the shares allotted in favor of my father, and towards northern side, my lord, the shares allotted in favor of my brothers also not in dispute.
Yes.
Pursuant to that, my lord, revenue records were affected. The same was got it registered, and it, my lord, it is in my name. My
Yes.
lord, the sketch.
What is that application you have filed?
Now, what happened, my lord, after the suit decreed compromised in favor of the members of the family, my father and brother, my lord, alienated portion of the land in favor of the first defendant. He is trying to put up the construction over the, including my land, encroaching my land. And my lord, apart from this, my father and brother, my lord, filed one more suit against me for the relief of partition and separate position, and whatever the compromise decree passed.
Application under order 39.
39(1) ಅಲ್ಲಿ ಏನಾಗುತ್ತೆ, one more suit has been filed against me for the relief of partition, and that compromise, my lord, has been called in question in the subsequent suit. Without there being filing an application under order 23 rule 3A. My lord, the findings recorded by the trial court rejecting the application, since, my lord, the comprehensive suit is already filed challenging the compromise that was taken place in the year 2021. You cannot seek the injunction against the other owners. That is factually incorrect, my lord.
Why?
My lord, there is already a partition. It is acted upon, and whatever the share allotted to the in favor of my father and brother, they are already alienated in favor of the first defendant.
Now, what is that compromise between the parties?
My lord, only one item, survey number 78 ಅಲ್ಲಿ 36 ಗುಂಟಾಸು, 36 ಗುಂಟಾಸಲ್ಲಿ 16 ಗುಂಟೆ ನನಗೆ ಬಂತು. ಇನ್ನ ಮಿಕ್ಕಿದ್ದು 8 ಗುಂಟೆ ತಂದೆಗೆ, 8 ಗುಂಟೆ ಸೆಕೆಂಡ್ ಡಿಫೆಂಡೆಂಟ್ ಬಂತು. Out of 8 guntas, 6 guntas, my lord, my father and brother, my lord, jointly alienated in favor of the defendant number 1. Now, defendant number 1 is in possession of portion of the 6 guntas of land. Rest is in possession of my father and my brother only. One more suit has been filed in OS.
No, in this case, you are filed in a suit for injunction.
Injunction. Mere
Injunction suit ಕೇಳ್ಬಿಟ್ಟು how can you ask not to put up any?
ಅಲ್ಲ, over my property, my lord, they are trying to put up the ನನಗೆ 11 sketch ಆಗಿದೆ, ಕಾಂಪ್ರಮೈಸ್ ಆದ್ಮೇಲೆ ಖಾತೆ ಆಗಿದೆ, ಕಂದಾಯ ಆಗಿದೆ, 11 sketch ಆಗಿದೆ. I am in possession and enjoyment over 16 guntas of land. Our share.
You could have seek for an injunction to restrain, not to put up under they are in the possession. Then how can you file a suit for?
My lord, so far as 6 guntas of land, now trying to encroach the land belongs to the plaintiff and trying to put up the land, my lord, which was fallen to the share of the plaintiff on the instigation of the defendant number 2 and 3, who are none other than my own brothers.
Sir, if you are in the possession, then the next remedy for you to seek for a temporary injunction, not to interfere. It covers everything.
My lord,
if you say not to put up, that means to say he is already in the possession.
Yes, to the possession of 6 guntas of land. It is admitted.
No, your injunction is for entire extent.
No, my lord, I sought for, my lord, injunction over my property. 16 guntas ಏನಿದೆ ಅದಕ್ಕೆ ನಾ ಇದು ಮಾಡ್ತಾ ಇದ್ದೀನಿ. Now, based on that, on the instigation of my father and brothers, he is trying to interfere with my possession and trying to put up construction over the land. Layout ಮಾಡೋದಕ್ಕೆ ಟ್ರೈ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ನನ್ನ ಲ್ಯಾಂಡ್ ಅಲ್ಲಿ. ಅದಕ್ಕೋಸ್ಕರ I sought for injunction. Original suit is, my lord, decreed in my favor.
Okay, where is your application?
Annexure C.
What is the prior?
Ink page number 41. The accompanying affidavit, pray that this honorable court may please to pass an order of temporary injunction against the defendants, their agents or GPA holder and their legal heirs from digging or constructing the building in portion of the suit scheduled property pending disposal of the case. So and so. 78 ಅಲ್ಲಿ 18 ಗುಂಟೆ ಹಾಕಿದ್ದೀನಿ.
ನೀವು why that has to be paid for not to construct? You could have sought an injunction not to interfere, mister. See, when you seek a suit for possession, there you can say that.
Not for possession, my lord, I sought for injunction only.
Injunction means
injunction, yes.
He is not in the possession. If the day he is in the possession, your suit is gone.
My lord,
now the prior shows that they are in the possession.
My lord, 2 and 3.
Of a construction.
2 and 3, they are my own brothers. They are trying to put up the construction.
If you are sued for an injunction.
Yes, my lord, they are put up the constructions to the share allotted to the share, my lord, fallen to the share of the defendant number 2 and 3, not in dispute. my lord, while putting up the construction, my lord, now they are trying to encroach and they're trying to put up they have dug the, my lord, the
No, that-
foundation for the
that's-
my land.
Then you should be asked to not to interfere, is it not? Yes, heard. Issue notice. Parties are directed to maintain status quo in respect of petition scheduled property. Both the parties
Please, my lord.
maintain status quo in respect of petition scheduled property till next date of year.
Yes.
You also don't do anything.
Please, my lord.
Yes.
Serial number 21, Musrat Tabassum for petitioner, K. Vishwanatha.
Playing for petitioner in this matter, my lord.
Yes.
Petitioner is the impleading applicant in the suit, specific performance suit, my lord.
Hmm.
A suit for specific performance and contract, my lord. My lord, facts of the case is this, my lord, the petitioner have filed a suit for partition and separate possession against all the family
Suit
members.
for specific performance.
Yes, my lord.
Yes.
My lord, impleading applicant had filed the suit for partition and separate possession against all the family members.
Now you come to that page 10.
Yes, my lord.
See, who has executed that agreement?
Defendants, my lord, Sonnappa, Jayamma and Sarojam.
They have executed that
Yes, ma'am.
agreement of sale. What
Yes,
is the date of agreement of sale?
Date of agreement of sale 28/4/2020, my lord.
28/4/20.
2020. Yes, ma'am.
Now that you are also filed in a suit for partition in respect of the very same property.
Yes, my lord.
Now,
That
who
is
are the,
Annexure C, my lord.
where is your suit plaint?
Annexure C, my lord, page number 18.
18.
Yes, my lord.
Nagaraj,
Nagraj.
Anand Pavitra, so and so. Sonnappa Sarojama is also a party.
Yes, my lord.
Jairam.
Schedule, page number 20, my lord. Item number 6, my lord. The land bearing survey number 5/6 measuring 35 guntas, my lord.
Now, where is your application? Why it is rejected?
My lord, it is rejected on the ground. Annexure E, my lord, page number 30, my lord. Para number 6. The applicant wants to come on record as a proposed party. The proposed defendants in the present case is contending that partition suit is pending between the defendants and proposed applicant, contending that false agreement of sale has been created without the knowledge of the proposed applicant. Hence, prays to allow the above IA to come on record. But this is a suit for specific performance of contract. The list
Yes,
is
mister,
restricted.
let them come on record. Suppose if you collide with that plaintiff, suit is decreed, then it will affect their partition suit.
No, earlier to this application, the same, the father of the applicant herein, they have filed application, similar application, that application is rejected. Thereafter, they have filed this application.
Specific performance, same properties ಇದೆ. Suppose ಯಾರು ಅಗ್ರಿಮೆಂಟ್ ಬರ್ಕೊಟ್ಟಿರ್ತಾರೋ ಅವ್ರು ಕೊನೆಗೆ ಏನ್ ಮಾಡ್ತಾರೆ, ಹೆಂಗು ಫ್ಯಾಮಿಲಿ ಜಾಯಿಂಟ್ ಫ್ಯಾಮಿಲಿ ಇದ್ದು ವಿಲ್ ಗಿವನ್ ಎ ಕನ್ಸೆಂಟ್ ಡಿಗ್ರಿ ವಿಲ್ ಬಿ ಪಾಸ್. Then it will affect their
Specific
rights.
performance suit ಅಲ್ಲಿ agreement joint, already they have filed the suit for partition. Let them prove their share.
No, if in the partition suit you are not party.
Like collusion, some is unnecessary, they have filed application.
No, see, the defendant who are alienated that property, no, there are different types is there. They may be colluded or suppose if they are colluded and they are agreed that yes, suit can be decreed specific for partners, we will ready to execute that. It will affect that their rights. They are claiming that it is a giant family property. Let them there in the party. They cannot see all other things. They cannot be. They can only as in a watcher to see that other persons should not be compromised. Otherwise, they have no role to say in that specific performance.
Like in fact, they have entered.
Or they, yes.
Register agreement, my lord, 15 lakhs are already paid.
No, but register agreement one day, specific performance, you have to know that what are all the ingredients you have to prove. All that if you are, even though if you know that you are failed to do it, then you can settle with that defendant saying that yes, I will give some more money given a consent. Technically, specific performance, they have no role. But when there is a partition suit in that same, ultimately it will affect that.
If at all they.
But they'll put in a condition, they should not take and drag that matter after impleading. Yes.
There are Supreme Court judgment.
What is that, madam?
My lord, the impleading application
allowed by the trial court is rightly upheld, my lord.
No, in
Para
the
number
partition
7.
suit, specific performance,
Yes, my lord.
where is that?
My lord, para number 7 of this judgment, page number 3, my lord. Whether the first respondent can claim any right over.
Para
the
number?
suit for- Para number 7, my lord. In this case also, it cannot be stated that the first respondent had no semblance of title. Whether the first respondent can claim any right over the suit property can be decided only during trial. Having regard to the fact that the first respondent claims share in the suit property and also to the fact that the suit property was ancestral property in the hands of the second respondent, to have binding decree, the first respondent is necessary party to the proceedings and the court below has rightly allowed the application.
Yes. ನೀವೊಬ್ರೇನಾ?
ಒಬ್ರೆ sir.
Is there any other respondents?
Yes, my lord.
ಕೇವೇಟ್ ಹಾಕಿದೀವಿ ಸುಮ್ಮನೆ ಅದು.
Your case
ಅಲ್ಲ
is
ನೀವೊಬ್ರೆ
taken.
plaintiff. Other have no objection. You will delete them or you want to, what you want, madam? You file a memo for dispensation.
Please, sir.
Yes. Caveator is undertaken to appear for the respondent number 1. Counsel for the petitioner has filed a memo seeking deletion of so and so. Plaintiff has filed a suit for specific performance of the contract for enforce specific performance of the contract dated 28/4/2020. The impleading applicants, petitioner impleading applicants have filed a suit for partition in OS number 101 of 2020, claiming that suit scheduled properties in OS number 630 nadu
Not one. No.
adalri nimdu 638 of 2020 is also suit scheduled properties in partition suit. Since they have interested in that suit scheduled property, they have filed an application for impleading. The trial court has rejected the same, being agreed by the same. Plaintiff petitioner is before this court. Petitioner has filed a suit for partition OS number 630. No, yours is 108.
Not 101, my lord.
101 of 2020. Suit scheduled properties in OS number 638 of 2022 filed by respondent number 1 herein is also one of the suit scheduled properties in OS number 101 of 2020 filed by the impleading applicants for a partition and separate position. The defendants in OS number 638 of 2022 is also party in that OS number 101 of 2020. Since the impleading applicants are contending that suit scheduled properties are a joint family property and they are claiming their share in that said property, if any degree passed in that suit, it having binding on the plaintiff. Therefore, there are necessary parties in the proceedings. The trial court is error in rejecting that application. In view of the above, the writ petition is allowed, order dated so and so is set aside. The IA number 4 filed by that petitioner in OS number 638 of 2022 is allowed. It is made clear that the petitioner should not seek any time when the matter is fixed by the court, and they should not drag that matter. They have to cooperate for early disposal of the suit.
Serial number 22, Chandra Kumar R.
Yes. Yes. And appear release this matter of 2 weeks.
Serial number 23, Venkat Reddy CM for petitioner, Sagar U Shastri.
Yes.
It's a case where, my lord, the sale consideration has not passed on.
Yes, suit for?
My lord, the respondent filed a suit for permanent injunction.
Hmm.
The said matter, my lord, made an application for temporary injunction.
Hmm.
It has been granted.
Yes.
And the same has been confirmed by the appellate court.
Hmm.
I think the said order, my lord, the present writ petition is before your lordship.
Yes.
Lordship, kindly see, my lord, the sale deed.
Hmm.
In the sale deed.
No,
my lord,
this is the matter you said something settlement and all.
compromise-
Settlement did not.
Yes.
Yes.
Lordship, kindly see the sale deed, my lord,
Hmm.
output produced by the, they have produced.
No, you give that just very facts, I've forgotten. I can't remember
Objection ಕೊಟ್ಟಿರಿ.
each and every matter. Every day it is coming before me, it is a fresh matter.
Yes, yes, ma'am.
Unless,
Lordship, kindly see the objection filed by my learned friend. He has produced the sale deed.
yes,
Lordship, kindly see page 42 of that.
42 of,
Oh, no, ನಿಮಿಷ. ಎಲ್ಲಿಂದ copy?
no, they have filed in a suit for injunction.
Injunction.
Based on the registered sale deed.
Yes,
So
ma'am.
you have purchased that property.
1/3/2021.
1/3.
2021.
My lord, under the sale deed, my lord, they say, my lord, that the amount has been paid already through Punjab National Bank.
No, you are that, that is what you said, that amount is not,
Has not passed on to me. Therefore, my lord, under section 54 of the
no, what is that amount, sale deed amount?
Rashma Kandi set annexure. So,
ಎಲ್ಲಿದೆ? Sale deed.
Lord, page 18. In my objection statement. Filed
Yes.
on the last time. Portal file ಮಾಡಿ.
Page 18.
Please.
Yes.
Clause A.
Hmm.
ಎರಡನೇ ಪಾರ್ಟಿಯವರು ಥರ್ಡ್ ಪೇರ್ ಮಾರಾಟದ ಪ್ರತಿಫಲ 75,60,60,000 ರೂಪಾಯಿಗಳು ಒಂದನೇ ಪಾರ್ಟಿಯವರಿಗೆ ಎರಡನೇ ಪಾರ್ಟಿಯವರಿಂದ ಈ ಕ್ರಯ ಪತ್ರ ಬರೆದು ಸಹಿ ಮಾಡುವ ಮುನ್ನವೇ ಈ ಕೆಳಕಂಡಂತೆ ಸಂದಾಯವಾಗಿರುತ್ತದೆ.
ಚೆಕ್ ಮುಖಾಂತರ ಅಂತ.
ಎರಡನೇ ಪಾರ್ಟಿಯವರ ಆದಾಯ ಸೋ ಅಂಡ್ ಸೋ. ಉಳಿಕೆಯ ಪ್ರತಿಫಲವಾದ ಸೋ ಅಂಡ್ ಸೋ 75,03,300. ಒಂದನೇ ಪಾರ್ಟ್ ಕ್ರಯ ಪತ್ರ ಬರೆದು ಸಹಿ ಮಾಡುವ ಸೋ ಅಂಡ್ ಸೋ ಪಂಜಾಬ್ ಸಂದಾಯವಾಗಿರುತ್ತದೆ. ಈ ರೀತಿ ಮಾರಾಟದ ಪ್ರತಿಫಲ ಪೂರಾ ಎರಡನೇ ಪಾರ್ಟಿಯವರಿಂದ ಒಂದನೇ ಪಾರ್ಟಿಯವರಿಗೆ ಸಂದಾಯವಾಗಿದ್ದು ಕ್ರಯಶೇಷವೇನು ಇರುವುದಿಲ್ಲ ಅಂತ ಒಂದನೇ ಪಾರ್ಟಿಯವರು ದೃಢೀಕರಿಸಿರುತ್ತಾರೆ. ಶೆಡ್ಯೂಲ್ ಸತ್ತು ಖುದ್ದು ಸ್ವಾಧೀನವನ್ನು ಒಂದನೇ ಪಾರ್ಟಿಯವರು ಎರಡನೇ ಪಾರ್ಟಿಯವರಿಗಾಗಿ ಈ ದಿನವೇ ವಹಿಸಿಕೊಟ್ಟಿದ್ದು ಇನ್ನು ಮುಂದೆ ಶೆಡ್ಯೂಲ್ ಸತ್ತನ್ನು ಎರಡನೇ ಪಾರ್ಟಿಯವರು ಅವಿಚ್ಛಿನ್ನವಾಗಿ ವಂಶ ಪಾರಂಪರ್ಯವಾಗಿ ತಮ್ಮ ಮನ ಬಂದಂತೆ ಅನುಭವಿಸಿಕೊಂಡು ಬರಲು ಅದರಿಂದ ಬರುವ ಸಮಸ್ತ ಉತ್ಪನ್ನಗಳ ಸಾಲೇ ಸಾಲು ಹೊಂದಲು ಸಂಪೂರ್ಣ ಹಕ್ಕುಳ್ಳವರು ಸರ್ವತಂತ್ರ ಸ್ವತಂತ್ರ ಆಗಿರುತ್ತದೆ.
Now, my rest of submission, Rashma kindly see section 54 of the Transfer Property Act. According to me, the sale consideration has not passed on to me at all. Transfer Property Act. Section 54, my lord.
Yes.
Judgment ಕೊಡಿ ಮೇಲೆ. Judgment ಕೊಟ್ರಿ ಮೇಲೆ. 54, my lord.
Yes.
Sale is a transfer of ownership in exchange for a price paid or compromised or part paid and part performed, promised.
Yes.
Sale how made? Such transfer in case of tangible immovable property of the value of 100 rupees and upwards, or in case of a reversion or other intangible thing can be made only by a registered instrument. In case of tangible immovable property of a value less than 100 rupees, such transfer may be made either by a registered instrument or by delivery of possession. Love, my lord, this section has been interpreted by this Honorable Supreme Court. The other day I had given AR 2022, Supreme Court, page 564, paragraph 15 and 16. Next judgment.
Yes.
15, paragraph 54, 15.
Yes.
Section 54 of Transfer of Property Act reads thus: sale defined. Sale is a transfer of
Yes,
ownership.
That's you have read, yes.
Yes,
In
madam.
case,
So here, madam, there is, if it is
You
wide
read-
document. It is a wide.
no, you read that last,
Yes, madam.
no, in definition, you have already read.
Yes, hence a sale of immovable property has to be for a price. The price may be payable in future. It may be partly paid, and the remaining part can be made payable in future. The payment of price is an essential part of a sale covered by Section 54 of TP Act. If a sale deed in respect of an immovable property is executed without payment of price, and if it does not provide for the payment of price at a future date, it is not a sale at all in the eyes of law. It is of no legal effect. Therefore, such a sale will be void. It will not affect the transfer of immovable property. Now, my lord, Rashma, kindly say, my lord, if the deed is void, what is the consequences? Whether am I required to challenge the same? Rashma, kindly say paragraph in another judgment, my lord.
Yes.
Paragraph. Copy. My lord, D, my lord, in the head note.
Yes.
Void ab initio document need, if any, for a decree setting as such held, there is no need of a decree in such a case as such would be nullity. If the document is void, my lord, I need not question. It is non-est in the AF law.
Yes.
So here, my lord, admitted, my lord, there is a recital, my lord, the amount has been paid through National Bank already. They have not produced any document to show that the amount under the sale deed has been passed on to me. Therefore, it is a void document. Rashma, kindly say, my lord, the reason for this two sale deeds, my lord, there was a joint development agreement between the petitioner and respondent in respect of the other property. The respondent did not develop the said land. Then, my lord, we wanted to entrust that property in favor of third persons. Then certain amount was required to be paid to him. As a security, my lord, he demanded to execute these two sale deeds. Therefore, my lord, for smaller amount, it is not for market value. This for smaller amount, my lord,
Now that what is the property is a land.
it's a coffee estate.
Now it is in whose possession now?
Therefore, Lordship, kindly suggest I pass on a document.
Now you maintain status quo.
I have no objection.
I will.
As on
We'll
the
hear
date
the
of filing the
I will
suit.
submit,
Lordship,
my lord.
1 minute. Lordship, kindly see these documents. Lordship, kindly see.
We'll hear that now you maintain status quo. Who are there in that possession, let him there.
My lord, injunction order has been operating since 5/12/2022.
Maybe operating.
And my lord, your
since
police protection order has
2021.
been given.
See,
That has not been challenged.
Yes.
And all revenue documents stand in my name. Now I am doing coffee proning. Kasi ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಈಗ.
Where is that, this thing?
Lordship, kindly
that
see.
Documents to show that you are.
Yes, yes. Just may I take your lordship's my lord?
Yes,
I will take your lordship to these documents. I have already served a copy.
Yes.
Lordship, kindly see the notice issued by me, my lord, at page 3, my lord, before paragraph 7.
Yes.
My client instruct, page 3, my lord.
Yes.
My clients instruct me to state that as you had not paid the sale consideration amount to my clients with respect to the registered sale deed dated 1/3/2021, my clients are still having the possession of their land bearing number so and so. There is no reply to this legal notice. Suddenly, after receipt of this legal notice, my lord, the present suit has been filed by the respondent.
Yes.
Then, my lord, Rashma, kindly see the photographs. It is, my lord, since 2021, 22, 23, I have been cultivating the land in question. Then, my lord, document number 13, I have been paying the tax. Rashma kindly see, my lord. Page 13, 13 to 16. These are all the tax paid receipts. Then, my lord, Rashma kindly see, my lord, I have been paying, I have been selling the coffee grown in the land in question to the one Mr. A.V. Naresh, Kandamane Coffee Traders. Rashma kindly see, my lord, he has also executed a Pramana Patma at page 19.
Yes,
Just I will read, my lord.
yes.
ನಾನು ಮೇಲ್ಕಂಡ ಪೇಜ್ 19 ವಿಳಾಸದಲ್ಲಿ ವಾಸವಾಗಿರುತ್ತೇನೆ. ನಾನು ಸಕಲೇಶ್ಪುರ ಟೌನ್ ಸೋ ಎಂಬ ಉದ್ಯಮದ ಹೆಸರಿನ ಕಾಫಿ ವ್ಯಾಪಾರ ವ್ಯವಹಾರವನ್ನು ಸುಮಾರು 20 ವರ್ಷಗಳಿಂದ ನಡೆಸಿಕೊಂಡು ಬಂದಿರುತ್ತೇನೆ. ಹಾಸನ ಜಿಲ್ಲೆ ಸೋ ನಾಗೇಶ್ ಅವರ ಮಕ್ಕಳುಗಳಾದ ನಿಶ್ಚಯ ಅಮೋಘ್ ಸೋ ತಮ್ಮ ಮಾಲೀಕತ್ವದ ಸಕಲೇಶ್ಪುರ ತಾಲೂಕು ಕಸಬಾ ಹೋಬಳಿ ಆನೇಕಲ್ ಸೋ ಇಲ್ಲಿ ಎಕ್ಸ್ಟೆಂಟ್ ಅಲ್ಲಿ ಇದೆ. ಜಮೀನುಗಳಲ್ಲಿ ಬೆಳೆದಿರುವ ಕಾಫಿ ಬೆಳೆಯನ್ನು ನಾನು ನಡೆಸುತ್ತಿರುವ ಮೇಲ್ಕಂಡ ಕಾಫಿ ಉದ್ಯಮಕ್ಕೆ ಅನೇಕ ವರ್ಷಗಳಿಂದ ಮಾರಾಟ ಮಾಡಿರುತ್ತಾರೆ ಹಾಗೂ ಅನೇಕ ವರ್ಷಗಳಿಂದ ಕಾಫಿಯನ್ನು ಶ್ರೀಮತಿ ಸುಗಂಧಿನಿರವರಿಂದ ನಾನು ಖರೀದಿ ಮಾಡಿರುತ್ತೇನೆ ಹಾಗೂ ಅವರು 21 ರಿಂದ 24ರವರೆಗೆ ಪ್ರತಿ ವರ್ಷ ಸುಮಾರು 10 ಟನ್ ಕಾಫಿಯನ್ನು ಮೇಲ್ಕಂಡ ನಮ್ಮ ಉದ್ಯಮಕ್ಕೆ ಮಾರಾಟ ಮಾಡಿದ್ದು ಸದರಿ ಕಾಫಿ ಬೆಳೆ ಬಾಬ್ತು ಮೊತ್ತವನ್ನು ನಮ್ಮ ಉದ್ಯಮಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟ ಬ್ಯಾಂಕ್ ಖಾತೆಯಿಂದ ಮೇಲ್ಕಂಡ ಸೋವರೆಗೆ ಆನ್ಲೈನ್ ಮೂಲಕ ಪಡೆಯುತ್ತೆ. Then my lord, kindly see the next, these are all the bills, my lord, up to 26.
No, this, you have finishing along with that application for injunction. You furnish along with that application for injunction.
It has been produced. No, my lord, therefore let there be an order of status quo, my lord.
See, to give a finding, you give an application along with these documents. Then we can see that on what basis we have to give any finding for consideration of application. Let it be all these documents on that IFR under order 39 rule 1 and 2. And
ನಮ್ಮ ಅಪ್ಲಿಕೇಶನ್ ಎಲ್ಲೋ ಆಗಿದೆ ಟ್ರಯಲ್ ಕೋರ್ಟ್.
No, here he has challenged. Here also you can file an application under 39 1 and 2 for injunction. On that application, if a document is placed, you file an objection for that because he has given a document to show that he is selling the copy. Then I will decide on that.
Then one
granting any injunction till that disposal, I can do it.
my lord, trial court, my lord, he has they have challenged the, my lord, execution of the sale deed after 2 years. Separate suit has been filed.
No,
In
I'm
that
not-
suit, they have not sought an injunction.
Not on that. Injunction applications allowed by both courts, he is challenging that. Here also you can file an application under 39 rule 1 and 2. He can produce
Now-
the documents, you file an
Now
objection.
police protection has been given, my lord, and that order has been passed on 6/3/2024.
See,
Already implemented.
now that he wants that injunction, let him place these documents.
My lord, the order, based on the order injunction granted by the trial court, my lord, we filed an application for police protection. And my lord, before the state police, they have stated that they have handed over the possession.
You place it, police handed over now after
ಅಲ್ಲಲ್ಲ,
that injunction.
ಅಲ್ಲಲ್ಲ, ಆ ತರ ಅವರು ಸ್ಟೇಟ್ಮೆಂಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
By forcibly.
My lord,
No, Mr. Ravi, you place it along with that application. I cannot give any finding on these documents without placing on a records and giving an opportunity. You file it according to that, then I will decide that whether it can be granted, who is the possession on the basis of the records.
ಅಲ್ಲ, ನನ್ನ ಡಾಕ್ಯುಮೆಂಟ್ ಅನ್ನು 2 ನಿಮಿಷ ತೋರಿಸಿ.
No, I am not granting any that. Let him file, he is a petitioner, let him place it by affidavit along with that application. With that 39.
That affidavit is given, my lord, is 2025 affidavit. ಅಲ್ಲಿ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ಲ, ಇವ್ ಯಾವ್ದು ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ಲ.
Now he is producing some documents for injunction under 39 1 and 2.
ಇಂಜಂಕ್ಷನ್ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಕೇಳಿಲ್ಲ.
Yes, Mr. You file it under 39 1 and 2, then we will see. Is it bar under this court? or
No, I am submitting that, my lord.
See, let all this to be on record with the proper application to giving an opportunity to you. I can give a finding. If I give some finding that the records which is not on properly placed before this court, my order will become wrong, Mr. Tomorrow, if it is challenged, then it will go. It is not based upon that. It is not a writ petition. You are throwing all papers here. Put it on affidavit under 39.
Till then status quo, my lord.
No, you,
No,
you file it the day after tomorrow. I will take it.
Lakshmi kindly on Friday, my lord. Monday.
Not Monday, Wednesday. Yes. After serving the copy, you place it that. Otherwise, this is documents now he is producing. He has no opportunity. I cannot give any reasoning on that.
Not one submission, my lord.
the passing of consideration,
No, see, you answer that. There are all documents to show that.
these are all created for the purpose of, my lord,
ಆಯ್ತ್ರಿ ಅದಕ್ಕೆ ನಾನು ಹೇಳ್ತಿರೋದು. They will give an opportunity, you file an objection, then I can decide, mister.
yes.
Now they are producing the document to show that every year they are
So far as,
a copy.
so far as injunction is concerned, my lord, on the immediately, one submission, immediately after execution of the sale deed, my lord, sale deed reciters itself show that they have handed over the possession, they have signed the sale deed.
Mr.
One,
Shastri,
one submission.
I am not deciding. That's why that in all,
And all revenue documents stand in our name.
see, that is what that court has to see when granting an injunction. Who is in the possession? What are the materials available? That's all.
And the passing of consideration is not, my lord, material.
That is not the case I am deciding, mister. In all cases, everybody is arguing a suit before me when application is there. That is not this case, whether in that amount you have paid, he is not received or not. Only that injunction regarding the possession, whoever is there on the records, it is convinced me, I will grant an order. That's all. Yes.
ನೋಡು ಒಂದು 2 ದಿವಸ ಬಿಟ್ಟು ಗುರುವಾರ ಅಥವಾ ಶುಕ್ರವಾರ ಶುಕ್ರವಾರ
Wednesday.
ನೆಕ್ಸ್ಟ್ ಶುಕ್ರವಾರ ಅವ್ರಿಗೆ ಏನೋ
ಇಲ್ಲ ನಮ್ಗೆ ಅಲ್ಲಿ ಸ್ವಲ್ಪ ಇಲ್ಲ ಕಾಫಿ ಅಂಡರ್ ದಿ by taking the police protection.
22 ದಿಂದ ಇಲ್ಲಿವರೆಗೆ ಇಲ್ಲದ one submission 4/4/2024 writ petition has been filed. They are pressing for interim order after 12 months.
Problem is arises when the crop has.
ಕಾಫಿ ಅದು
ಕ್ರಾಪ್ ಇಲ್ಲ ಈಗ ನಾವು ಪ್ರೋನಿಂಗ್ ಕಸಿ ಮಾಡ್ತಾ ಇದ್ದೇವೆ ಈಗ ನಾವು ಮಾಡ್ತಾ ಇದ್ದೇವೆ ಈಗ
ಅವ್ರು ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಪೊಲೀಸ್ನವ್ರು ಹಿಡ್ಕೊಂಡು ಬಂದು ಮಾಡ್ತಾ ಇದ್ದಾರೆ
ಪೊಲೀಸನವರು ನಮ್ಮ ಸ್ವಾಧೀನ ಕೊಟ್ಬಿಟ್ಟು ಈಗ ಚೇಂಜ್ ಯುವರ್ ಕಲರ್.
Wednesday, yes.
Office objection, first time matter.
Thursday ಆಗ್ಬೋದಾ?
Thursday, yes.
Serial number 24, Varadaraj or Avaldar for petitioner.
Petition, my lord. Office objections have been, this court fee of 100 rupees has been paid on day before yesterday. And other objection is that IA number is not set up in the prayer.
Yes. Yes, what is this?
Lordship may kindly appreciate. There is an execution case number 20 of 23.
Yes.
That is annexure B, my lord.
Yes, suit for?
That is suit for it.
No.
A suit was filed. OS 52 of 2016. Between respondent number 1 and respondent 2-5. On a specific performance, and it was compromised. Now, this petitioner is the family member of respondent 2-5 and her father Abdul Rasul Khan.
Yes.
He was the owner of this survey number 52.
The joint family properties has been compromised by that one of the family members.
He was not a party to the suit.
Yes.
Now, in the execution petition, the respondent 2-5, they are not taking any part. They have been asked to execute this.
Yes, your application is dismissed.
Huh?
Your application is dismissed.
Yes, it is dismissed.
Why?
Order 21/258. The only ground on which it is dismissed is that para 11.
Yes.
They say that she has no independent right. Under the Mohammedan law, my lord, she is a sharer. She has got a definite share.
Yes. Issue notice. Day of further proceedings in execution number
20 of
2023, pending in the file of which additional, Mr.
That is the annexure A, that is the,
Additional senior civil judge.
yes,
Annexure
annexure A.
pending in the file of senior civil judge and JMFC Bhadravati till next date of hearing. In the meantime,
They will make only the order.
petitioner is directed to comply office objection in the meantime.
Yes,
That numbering.
ಅಲ್ಲ, ಕೊಟ್ಬಿಟ್ಟಿದ್ದೀವಿ.
No, that numbering only, that is the only option.
ಮಾಡ್ತೀನಿ.
Yes.
ಈಗಲೇ ಮಾಡಿಸು ಇಲ್ಲ ಡೆಲಿವರಿ ಕೊಡಕ್ಕಾಗಲ್ಲ. Serial number 25.
For the petitioner minutes, there's one office objection. That provision of
Clause to be stated correctly.
written statement and they are yet to file minutes. This is a matter where ex parte injunction order was
No,
refused.
what is that correct law stated?
227 Bardirala Swami. That's, I will comply it in the course of the day itself.
Yes,
My lords,
what-
suit of the plaintiff's writ petition. Suit of the plaintiff, my lords, is for permanent injunction. Notice, emergent notice is issued, my lords. This is a matter where in the year 1979, grant was made in favor of the petitioner.
Hmm.
Then subsequently Sagu Valli chit also was issued.
Hmm.
Revenue entries stand in the name of the petitioner.
Hmm.
Now, my lords, the defendant, on the pretext
Hmm.
that we had fenced the property, we had compounded the property.
Yes.
He tried to demolish the compound. Then we went to the police station, my lords, lodged a complaint.
Who are there?
They claim, my lords, they have nothing to do with this property.
No, are there adjacent owner or
They claim to be adjacent owners. But the property which was fenced,
that trial court order?
trial court order, my lords, is at page 15, typed copy is at page 16.
Hmm.
Saying that notice is issued, we have to hear the other side before granting an ex parte order.
Yes, heard. Issue notice. Parties are directed to maintain status quo in respect of petition scheduled property till next date of hearing. In the meantime, petitioner is directed to comply of subjects.
I will do it today. I'm grateful.
Number 26, Satish Nishad Rao.
Yes.
There are some office objections. I can comply during the course of the day itself. Not.
Registration certificate.
It is all
annexures,
here.
Para details to be correctly stated. Yes.
Everything can be done.
Pass off.
Now itself. Not.
No, if
Yes,
small mistake is there, I will. Otherwise, you do it, then we will hear.
Please, but your
Pass
lordship may have it at, by, can it be taken by around 4? I can reach Agila on the Samasya.
Illa andre mention madi. I will do it. If that is matter which has been passed over, I will take it that. Yes.
Please.
Pass over.
Number
Yes.
27, Krutika Raghavan.
Your Lordship, all objections that have been raised are clerical objections, Your Lordship. They will be complied with in a day's time.
Yes.
For the petitioners in this matter, Your Lordship, we have
Do
preferred.
you want to argue?
Please.
First you have to comply. We'll see that court fee has not been paid. All that pass over, you complied, then we'll do it. Yes.
Serial number 28, Manikanta HB.
Lords, there are two office objections, my lords. One is that the written statement is not produced. It's an application for res judicata, my lords. Written statement would
List
not,
of the events to be chronologically ordered in synopsis.
my lords, only 2 points, my lords, that
Yes. What is
99,
this? Yes.
my lords, an application under section 11 was filed.
Yes. Now suit for?
My lords, this suit, my lords, present suit is for declaration, recovery of possession and injunction, my lords.
Hmm.
The earlier suit was for injunction and declaration of a sale deed, my lords.
Hmm.
The property involved in both the suits were one and the same.
Hmm.
The parties litigating were one and the same, my lords. In this suit, my lords, they have made all the persons party who had hold the title. In the earlier suit, only the purchaser was made the defendant, my lords.
No, this suit is for declaration.
Declaration, recovery of possession and injunction, my lords.
Hmm.
Earlier suit was,
Now, yes, we'll come to
Yes,
that.
my lords.
Now, what is that you are challenging?
my lords, section 7, section 11 application, my lords. Res judicata.
Yes. Order 7, rule 11.
No, my lords, we had filed an application for
11.
11 itself, my lords.
No, even then that is also ground under that order 7, rule 11. Order 7, rule 11.
Only it is barred by law, my lords. I can seek for rejection of claim.
Hmm.
Now, the earlier suit has already been decided
Hmm.
and held in. Yes, my lords, the suit has to be dismissed, my lords.
Hmm.
If under,
Rejection of plaint is also same thing.
my lords, if rejection is granted, then they can file a subsequent suit, my lords.
Where it is, does not disclose cause of action. Where emblem is so and so. Yeah. Yes. What is that order passed by the trial court?
My lords, the trial court, my lords, order at page number 61, my lords. Reasoning from page number 62.
Page 62.
Yes, my lords.
Yes.
Para 5, my lords.
Yes.
It is clear from the careful going through the provision in section 11. The first point to be considered while considering section 11 is whether the question is decided in the former suit and the present suit or question substantially and directly decided in the former suit is identical in the present suit. In the case in the case on hand, this present suit is for permanent injunction on defendant number 1. Some of the sale deeds and gifted are not bind on the plaintiff and declaring the plaintiff as absolute owner and the permanent injunction. But on the perusal of the documents produced by the defendant, number 3, the former suit which is already been decided is in the nature of permanent injunction.
Hmm.
Kindly, my lords, page 22, my lords. My prayer in the former suit, my lords.
No, present suits. Questioning the substance directly decide former suit, identical and so and so and so. Deed, gift and not binding on. Here only that sale deed and gift deed is not binding on that
Yes,
plaintiff.
my lord, declaration,
Is absolutely owner of the suit scheduled property and permanent injunction. Yes, earlier, where is that
my
plaintiff?
lord, page 22.
Yes.
My prayer is, A is for permanent injunction, my lords. Prayer B is,
No, earlier suit is also for the same.
yes, my lord, same suit schedule property, my
No,
lord.
plaintiff is the same.
My lords, defendant, earlier he was defendant in the former suit, my lords.
No, you have filed in a suit earlier.
Yes, my lords, my purchaser had filed a suit against this plaintiff in the present suit.
No, Vijay Kumar has filed in. Who is Vijay Kumar?
Vijay
No,
Kumar,
Vijay Kumari.
Vijay Kumari, my lords, my purchaser, my lords.
No, you have sold that land to Vijay Kumar.
Yes, my lords.
That she has filed in a suit.
Yes, my lords.
Against to whom?
Madini Ramaya Chaudhary, who is the plaintiff in the present suit.
Plaintiff.
Yes, my lords.
Yes. She has filed in a suit. A declaration on the basis, declare that permanent injunction restraining the defendant so and so peaceful possession. Declare that sale deed dated so and so that in the office of sub-register are not binding on the plaintiff.
Yes, my lords.
Hmm.
Both the prayers were held in my in the favor of the plaintiff, my lords.
Hmm.
And the sale deed was declared as null and void. Kindly, my lords.
Now,
And
what
pa-
is that he is seeking that, which is that sale deed and gift deed?
My lords, the sale deed and the gift deed, my lords, he now is seeking, which was executed in the favor of
Now
Vijay
that
Kumar.
your vendor
Yes, my lords.
has filed in a suit.
Yes, my lords.
What has happened to that suit?
My lords, now the present suit is filed. There are two persons.
I am asking that first suit filed by
Yes, my lords. My purchaser.
your purchaser.
Yes, my lords.
Yes.
Page number 34, my lords.
No, you have sold it on which date?
Lords, I have sold it on 2016, my lords.
2000?
15/3/2016.
Now, what is the 2/11/1995 sale deed?
2/11/1995 is claimed by the plaintiff in the present suit, my lords. Defendant in the former suit. Madini Ramaya Chaudhary.
No, originally property belongs to whom?
My lords, originally property belongs to my lords. One, my lords, Vijayendra Raju, my lords.
Vijayendra Raju.
Yes, my lords.
Yes. He has
Subsequent,
sold to whom?
lords, subsequently, that property has been bequeathed by defend number 4, 1 V Anil Kumar by way of will, my lords.
Anil Kumar?
By way of will dated 14/12/1992.
No. This Vijay Kumar, Vijay Kumar Raja.
Yes, my lords.
How it comes to that Anil Kumar?
Anil Kumar by way of will, my lords.
Huh? Gift.
Will, my lords.
Will.
Yes, my lords.
Vijay Kumar Raja has given a will.
Yes, my lords. 14/12/1992.
14/12/92
1992.
in
Yes.
favor of defendant number 4.
Yes, my lords. V Anil Kumar.
R4.
Subsequently, my lords, on 21/1/2013, a gift deed was executed in favor of defendant number 5 V Arun Kumar.
21/1/2013.
21/1/2013. Yes, my lords.
Gift deed kotra avaro.
Yes, my lords. Gift deed.
Yaro Anil Kumar.
Anil Kumar ಅವರು Arun Kumar ಗೆ a gift deed was executed.
What is the Arun Kumar ಎಷ್ಟನರಿದ್ದಾರೆ?
Defend number 5, my lords. They are brothers, my lords.
Gift ಕೊಟ್ಟಿದ್ರು.
Yes, my lords. Subsequently, on 18/3/2015,
18/3/2015,
my lords, it is sold to the petitioner, who is defend number 3.
Yes, that Arun Kumar has sold to you.
Yes, my lords. Vijay Kumar.
Sold to Vijay Kumar, huh?
Yes, my lords. Defend number 3.
Defendant number 3.
Subsequently, the petitioner sold the same property on 15/3/2016 to the first defendant, Vijay Kumari, my lords.
You sold to?
Vijay Kumari, R, first defendant, my lords.
You sold to the first defendant.
Yes, my lords.
What is the date?
15/3/2016.
2016.
Yes, my lords.
Sold to D1.
Yes, my lords. This is the title that has been claimed by Vijay Kumari, my lords.
Now, what is the 2/11/1995 has come?
My lords, that sale deed has been taken up by the
plaintiff in the present suit, he says he has purchased the property under 1995 sale deed.
From whom?
My lords, he says he has purchased it from one P Murthy, represented by his GPA holder KU Gurupade Gowda. And there is no reference to any GPA or the earlier title document which has been passed on to him. He only refers to one sale deed, my lords. That is of the year 1995.
No, that Vijay Kumari has filed in a suit
Yes, my lords.
to declare that that is null and void.
That was declared as null and void, my lords.
Sale deed which claiming by the plaintiff has been declared by null and
Null and void, my lords. Now in the present suit, the plaintiff is claiming the title under the deed which was declared null and void.
Now that where is his prior?
My lords, kindly, my lords, it's prayer at page number 50, my lords.
50.
Yes, my lords. Prayer starts from page 48, my lords.
Yes.
Page 48, first prayer is for recovery of possession, my lords, for delivery of possession.
48.
Yes, my lords.
Delivery of possession, so and so. Consequently, declare that gift
Gift
deed.
deed that was executed earlier by R4 to R5 to null and void. Declare the sale deed executed by the petitioner to defend number 1 as null and void. Declare the confirmation deed executed as null and void. Declare the sale deed executed in favor of Vijay Kumari as null and void. Declare the memorandum of deposit of title deeds that they had.
He is claiming something different, Mr.
Kindly, my lords, page prayer 7, my lords. Consequently, declare the plaintiff is the absolute owner of the suit scheduled property, having acquired in the same through sale deed dated 2/11/1995. He is claiming the title under a document 2/11/1995, prayer 7, my lords. He is claiming title from the to the property over that document which has already been declared as null and void.
Yes.
So yeah, it does not have a title at all, my lords.
Then suit has to be dismissed. How it become res judicata, Mr.
My lords, but
That is on the merit, suit has to be dismissed.
My lords,
How?
if he is claiming on a basis of a sale deed which has already been decided, this court does not have a jurisdiction to again consider the same, my lords. Even if they declare my sale deeds as null and void.
No, he is not seeking declare that sale deed is null and void. He is saying that claiming a rights on that.
Yes, my lords.
But court say that that sale deed itself is null and void.
Null and void.
Therefore, you cannot be
Yes,
declared
my-
as an owner.
Yes, my
But
lords.
court cannot, he is not seeking that so and so sale deed is null and void because court cannot decide 2 times.
Yes, my lords.
It is
Correct.
already decided.
Yes, my lords.
On that judgment, his suit can be dismissed, not for res judicata, Mr.
My lords, that is what, my lords, res judicata.
See, if sale deed is bogus and all, that can be decided by the court saying that it is bogus, you are not entitled.
Yes, my lords.
But court is not deciding again that sale deed. Here not deciding that again sale deed.
My lords, it is being decided on the same, my lords.
No, therefore, that is the ground for rejection of the dismissal of the suit.
Yes, my lord, that is what we sought.
Res judicata anta andre, it cannot be decided again.
Yes,
They are
my lord.
not seeking for deciding that.
My lords,
Suppose
yes, my lord.
if somebody has filed in a suit saying that the 2005 sale deed is null and void again, then there cannot be
My
2
lords,
times.
their contrary thing is, my lords, their
Take notice, yes.
dispensation, notice be dispensed with, my lords, other respondents, my lords, who are only the defendants, my lords.
Yes. Issue emergent, filed in a memo dispensation of 2
My lords, 2 to 8, my lords.
emergent notice to R1.
I may
He
permitted to serve.
permitted to serve a copy
My
on
lords,
counsel appearing for the petitioner, the respondent before the trial court.
The suit is set down for cross-examination.
Ugly, serve it and come.
Kindly,
Yes.
my lords. Grateful, my lords.
Office objection, in the meantime, you complete.
my lord, sir.
Yes,
My lords, that written statement may be overruled, my lords.
yes,
Not be required.
yes. Put office of serial number 1. Office objection in respect of serial number 1 is overruled. We, in the meantime, petitioner is directed to comply office objection number.
Serial number 29, Parameshwarappa MV.
Petitioner, my lord. Petitioner is the
IA
teacher.
details to be stated in the prior. Objection, if any, is to be furnished. Office objection.
Office objection only is residing in Haveri district.
No. That is not that matter. IA details to be stated in the prior. Do it, pass over. Yes.
Serial number 30. Bhargavaji,
Your lordships, court fee has been paid.
Court fee,
Court fee has been paid.
written statement to be filed,
Written statement has not
copy
been
of
filed by the
annexed
defendant.
to be furnished. Yes, court fee is paid.
Court fee is paid, defendant has not filed his written statement.
No, when
And-
court fee has been paid? Today?
Yesterday.
Yes. Yes, what is this?
Your lordship, suit is for ejectment. I had filed an application for impleading myself as one of the defendants, and my application has been rejected.
Who are you?
I am the owner of the property, your lordships.
No, who has filed then a petition?
The suit has been, petition has been filed by impleading applicant. By the impleading applicant.
No. Who has filed the suit, mister?
A suit has been filed by one Sarika Devi, who also claims to be owner of the property. And there's already a suit with respect to declaration of title, your lordship, pending between us.
You come to that to plaint.
A plaintiff initially at the time of filing of the
Sarika Devi.
Sarika Devi is the plaintiff who claims to be owner of the property.
Now, is there any relationship with Sarika and that impleading applicants? Are they relative?
No, they are not related, your lordships.
Then she is claiming that owner.
She claims to be owner, and I am also claiming to be the owner.
You file in a separate suit.
No, initially I was made a party, that is defendant number 2. She Channa Revana. My name was, initially she made me as a party, and later my name was deleted for reasons best known to her, your lordships.
Now that she has filed in a suit for ejectment.
Ejectment,
Then,
when her title is seriously disputed and dual relationship has not been established, she could not have filed a suit for ejectment, your lordships. She should have filed a comprehensive suit making me as a party to the suit, and that has not been done.
Now, by impleading as a defendant, what you can do that?
I'm the owner. If I am able to show that I am the owner of the property, and she won't be able to dispossess my tenant. Defendant number 1 is the tenant, your lordships. And also, to show that there's a serious dispute with respect to title, may I bring your
order passed by the trial court?
Trial court ಹೇಳ್ತಾರೆ, since it's a suit for ejectment, there's no need, relevant page is at 22, your lordships. 22, ink page number 22. From the top 6th line, this court has to see only whether the owner of the property has made out grounds to evict the tenant from the scheduled property or not. When there's a serious dispute with respect to ownership, the court cannot come to a conclusion that the plaintiff herself is the owner of the property.
Yes.
And also there's another suit pending. May I bring your lordship's attention to ink page number 39.
Filed by whom?
Filed by a very same plaintiff against me, against the impleading applicant.
For what?
Seeking a declaration with respect to the property, ownership of the property.
Then our suit has to be dismissed on that ground itself. She is not yet be declared owner.
Yes,
How can you file an eviction suit?
She could not have filed an eviction suit, your lordship. That's
Yes,
why I have
but-
to be heard.
Issue notice. Stay of further proceedings in OS number 2152 of 2000. What is that date, mister?
Or impugned order, your lordships.
No, that in that interim order, that prayer is not proper, mister. OS number which year, mister?
2152 of 2021.
20?
21.
2152
2152.
of 2021, pending in the file of 52nd Additional City Civil and Session Judge, Bangalore, till next date of hearing. In the meantime, petitioner is directed to comply of subjection.
Your lordships, office objection may be overruled.
No, typed copy,
Plaint is legible, your
no,
lordships.
typed copy of annexure B.
That is plaint. Plaint is legible. That may be overruled.
Statement is not filed.
Written statement has not been
Yes,
filed.
Submission is accepted, office objection is overruled. First
Much
order.
Serial number 31, Bhatt Ganapati Narayan. Kindly
Yes.
pass on, madam.
Office objection. Comply that 1 week time is granted to comply of. subjection.
Monday, my lord, date may be, partition suit, my lord.
You comply it, then move that matter. Any day we'll take it. Yes.
Serial number 32, Omkara N.
I appear for the petition this matter, my lords.
Yes, office objection, you have to comply, Mr.
My lords, court fees has been paid,
When?
today, my lords.
Then ranking
My lords, matter is set down for Monday, my lords. I may request, my lords.
jurisdiction to be stated in cast title, blanks to be filled. No other alternatives. You pass out, you complied. Yes.
Grateful, grateful.
Serial number 33, B N Jayadeva for petitioner.
The petition in this case, my lord. I have filed a suit for injunction,
No, first office objection.
office objection ali that
Part two is not a.
that
party.
Shardama is dead now, my lord. After filing the suit, I
Correct.
came to know, I am not.
Annexures to be stated in the interim prayer. Detail of LRs are to be stated. What is this, Mr.?
ಅಲ್ಲ ಅವ್ರು ತೀರೋಗ್ಬಿಟ್ಟಿದ್ದಾರೆ ನನಗೆ ಗೊತ್ತಿರ್ಲಿಲ್ಲ ಹಾಕಿದ್ದೆ ಐ ನಾಟ್ ಪ್ರೆಸ್ ಅಪ್ಲಿಕೇಶನ್ ಆಸ್ ಅಗೇನ್ಸ್ಟ್ ಶಾರದಮ್ಮ
R2 is not a party before the trial court.
ಅದು ಪೊಲೀಸರ ಪಾರ್ಟಿ ಮಾಡಿಲ್ಲ ನಾನು ವಾಟ್ ಹಸ್ ಹ್ಯಾಪನ್ ಐ ಒಬ್ಟೈನ್ ಆರ್ಡರ್ ಸ್ಟೇಟಸ್ ಕೋ ಮೈ ಲಾರ್ಡ್ ಆಫ್ಟರ್ ಸರ್ವಿಸ್ ಆಫ್ ನೋಟಿಸ್ ಆಫ್ಟರ್ ದೆನ್ ದಟ್ ಆರ್ಡರ್ ಹಸ್ ನಾಟ್ ಬಿನ್ ಪಾಸ್ ಬೈ ದ ಟ್ರಯಲ್ ಕೋರ್ಟ್ 9 ಹಿಯರಿಂಗ್ ಡೇಟ್ ಆಗಿದೆ
ಯಾದಕ್ಕೆ?
ಆರ್ಡರ್ ಆನ್ IA for police protection, my lord. Interim order has been granted. Interim order has been granted, my lord.
Seeking only direction. Seeking only direction.
Only direction.
Only direction.
Then why you have made police as past year?
ಅಲ್ಲ ಇಲ್ಲಿ ಕೇಳಿದೆ I made only direction ಕೇಳ್ತಾ ಇದ್ರಿ ಪೊಲೀಸ್ ಪಾರ್ಟಿ ಮಾಡಕ್ಕೆ ಅದಕ್ಕೆ ಪಾರ್ಟಿನೂ ಮಾಡಿದ್ರಿ
Policener direction and court ಕೊಡಕ್ಕಿಂತ ಮುಂಚೆ policener ಗೆ directions.
ಆಗೋದು then I won't.
Yes, we'll direct. Which is your IA?
Last. Next year.
Annexure A, my lord.
Next year? No, which is that IA, Mr. IA filed the number.
At page 37, my lord. Page 37, annexure D.
Respondent is served now.
A respondent has been served.
ಅಲ್ಲಿ ಎಲ್ಲಾರು ಸರ್ವಿಸ್ ಆಗಿದೆಯಾ?
I didn't press against the dead person. I said I filed a memo saying that I am not pressing the application as against the dead person.
No,
Yes.
before
Opening
the
of result
trial
defend-
court, all the defendant has been served, Mr.
Only one defendant has been served, my lord. Interim order has been granted.
Yes. What is the next date?
Next date 9, 10 to 9 ಸಲ ಕೊಟ್ಟಿದ್ದಾರೆ ಡೇಟ್ಸ್ ಆರ್ಡರ್ ಮಾಡ್ತೀನಿ ಅಂತ.
ಎಲ್ಲಿ ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ ಇದೆ?
ಆರ್ಡರ್ ಕೊಟ್ಟಿದ್ದೀನ. Annexures. Annexure C, my lord, at page 24. At page 33, my lord.
Yes.
Interim order was granted, my lord. On 8/9/24. ಆಮೇಲೆ 12/11 ಗೆ ನಾನು ಅರ್ಜಿ ಹಾಕಿದೆ ಪೊಲೀಸಲ್ಲಿ ಬೇಕು ಅಂತ.
ಯಾವತ್ತು ಆರ್ಡರ್ ಆಗಿರೋದು ಇಂಜೆಕ್ಷನ್?
Injunction was granted on
Parties are directed to maintain status quo. What is the date?
10/9, my lord.
10/9.
10/9 ಗೆ interim order ಕೊಟ್ಟಿದ್ದು.
10/9/24.
I filed my application at 12/11, my lord, at page 34.
12/11.
34, page 34.
ಅಪ್ಲಿಕೇಶನ್ ಮೇಲೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಆಗಿದೆಯಾ?
ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್ ಎಲ್ಲ ಆಯ್ತು. ಆರ್ಡರ್ಸ್ ಗೆ ಅಂತ ಹೋಯ್ತು. ಆಮೇಲೆ ಕ್ಲಾರಿಫಿಕೇಶನ್ ಅಂತ ಡೇಟ್ ಕೊಡ್ತಾ ಇದ್ದಾರೆ. 8 ಹಿಯರಿಂಗ್ ಡೇಟ್ ಆಯ್ತು, 9 ಹಿಯರಿಂಗ್.
Only order has to be passed.
Order has to be passed.
Yes, third. In this writ petition, delete ಮಾಡಿ policener.
ಆಗುತ್ತೆ.
Petitioner has sought following relief. Petitioner has sought only a direction to direct the trial court to dispose of that application filed by the plaintiff under order under section 151 of CPC, seeking police protection.
ಇಲ್ಲೇ
In
ಕೊಟ್ಟು
view of the above, issuing notice to respondent is not necessary.
not necessary. Order 41/14.
Petitioner plaintiff has filed a suit for
Injunction, my lord.
injunction. The trial court by order dated 10/9/2024 has granted an
Status quo, my lord.
status quo. Has granted an interim order. Both the parties are directed to maintain status quo till next date of hearing. Thereafter, petitioner has filed an application.
On 12/11, my lord.
Huh?
12/11.
Application under section 151 of CPC for police protection on 12/11/2024. Even today, the court has not passed any order. Therefore, plaintiff is before this court. In view of the above, without expressing any opinion on the merit of the case, the trial court is directed to dispose of that application filed by the plaintiff under order under section 151 of CPC as expeditiously as possible, not later than disposed of in accordance with law. as expeditiously as possible, not later than, what is the next date, mister?
9/2 ಕೊಟ್ಟಿದ್ದಾರೆ.
9/2 ಇದೆಯಾ?
10/2, 10/2.
10/2, not later
week
than the
ಅಲ್ಲಿ
end of February 2025.
ಅಲ್ಲ, ಅಲ್ವರ್ಗು ನನಗೆ ಆ ಪ್ರಾಪರ್ಟಿ ಅಲ್ಲಿ ರೋಡ್ ಮಾಡ್ತಾರೆ ನನ್ನ ಪ್ರಾಪರ್ಟಿ ಮೇಲೆ.
ಅದೇ ಈ ಮಂತ್ ಎಂಡ್ ಒಳಗಡೆ ಎಲ್ಲಿದ್ದೀವಿ? 2 weeks ಇದೆ ಅಷ್ಟೇ. Yes.
ಅಲ್ಲ, one week ಅಲ್ಲಿ 9 dates have been given, my lord. Every time clarification.
Next date is when?
At 10/2, my lord.
10/2.
10th of February next month.
Not later than.
Sorry, ಬರೋ ಮಂಡೇಗಿದೆ. ಬರೋ ಮಂಡೇ ಇದೆ.
Monday ಇದೆ. Not later than
10/2.
end of 20th February. Yes.
15th of February ಮಾಡ್ಬಿಟ್ಟು.
2025. ಮಾಡ್ತಾರ ಈಗ ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಅಲ್ಲೇ ಮಾಡ್ತಾರೆ. ಆರ್ಡರ್ ಆಗಿದೆ ಅಂತ. Yes. Office objections, submission is accepted, office objection overruled.
Serial number 34, Dhananjay Kumar.
Yes, 2 weeks to 2 weeks to comply office objection.
1 week.
1 week, yes.
Serial number 35, Lokesh B.
1 week. 1 weeks to comply office objection.
Serial number 36, Mahendra.
Complaint Swami, ಒಂದೇ ಇದ್ದಿದ್ದು petitioner is not party before the court below clarified. We are not the party, Swami. By obtained fraudulent degree by the one respondent 1 to 3 has filed the partition suit which are sold by their father in the year 2004. Converted property without made me a party. They have obtained the collusion degree. I have produced the order sheet. Kindly peruse for minute, my lord.
Writ petition page properly typed.
I have typed and I have put.
Annexure to be stated.
I have complied all the office objection.
When?
Last week.
No, after that it has been raised, mister. Better copy of the memorandum. You see that so many other office.
Supervisory jurisdiction I have mentioned, my lord.
No, to
Typed
be
copy of the-
paginated. Typed copies, annexure L to be marked,
Yes, my lord.
annexure to be stated correctly. There are other office objection also, mister.
Yes, my lord.
You complied.
Complied, my lord.
No, it is not complied, mister. It is shown that it is not complied today.
Today itself I will comply.
Yes. Week's time is granted to.
Today itself I will.
Yes, pass over.
Serial number 37, Arjan, office objection, third time matter. Serial number 38, Nandish Gowda G.
38. All the 4 objections are complied. Fresh objections has been raised by the office stating that, my lord, the prayer should be clear and specific with annexures. The same has also been done. My lord, the
What is
prayer
that prayer you are sought?
issue a writ in the nature of certiorari, quashing the impugned order dated 27/4/2024, passed by the court of the principal senior civil judge Bangalore in OS number so and so, ಅಲ್ಲಿ wide annexure F, and consequently set aside the compromise dated 11/2/2013 as far as it concerns to survey number 11/3 measuring to an extent of 1 acre 8 guntas.
What is this relief, mister? What are you challenging
My
here?
lord, the compromise was taken place between the members of the family.
Before where?
My lord, trial court itself. Later, my lord, the defendant number 1 and 3, they have taken, my lord, the responsibility of the father, first plaintiff. They have joined together, my lord, and whatever the property allotted to the share of the plaintiff father, my lord, alienated. Portion of the alienated. Hence, my lord, the father filed the application under order.
What is annexure C1?
C1 ಅದೇ ಕಾಂಪ್ರಮೈಸ್ ಆಗಿರೋದು.
ಎಲ್ಲಿ ಕಾಂಪ್ರಮೈಸ್ ಆಗಿರೋದು?
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ.
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಕಾಂಪ್ರಮೈಸ್ ಆದ್ರೆ ನೀವು ರಿಟ್ ಹೆಂಗ್ ಹಾಕ್ತೀರಾ?
ಅಲ್ಲ, ರಿಟ್ ಬರಲ್ಲ ಅಲ್ಲಿ. 23(2)(3) has been invoked, but application rejected by the trial court stating that if there is a fraud and is there, you have to file a writ petition, not filing an application under order 23(3)(a).
No, if it is only in case of compromise in that Lok Adalat, then you can file a writ. Otherwise, under 23.
ಅಲ್ಲ, 23(3)ನೇ ಇನ್ವೋಕ್ ಮಾಡಿರೋದು.
ಅದನ್ನ ರಿಜೆಕ್ಟ್ ಮಾಡಿದಾರ?
ಅದನ್ನ ರಿಜೆಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ.
Where is that order?
My lord, in page number 80, relevant portion, my lord, para 14, 80, my lord, para 14. The considering the facts and circumstances of the case, once the decree has been passed in the Lok Adalat.
Page number?
Page number 80. By considering the facts and circumstances of the case, once the decree has been passed in Lok Adalat, the aggrieved
No, it
party
is under
has
Lok
to,
Adalat.
before the High Court of Karnataka under order and the provision of
Lok Adalat,
26.
you can't challenge before them, mister. It is Lok Adalat only you have to file a writ before this court.
My lord, 23(3)(a), it can also be invoked, my lord, when the compromise has
No,
taken
Lok
place.
Adalat Act ಬೇರೆ ರೀ.
ಇಲ್ಲಿ fraud, my lord, fraud is,
No, Mr. Counsel, you just Lok Adalat Act ali, it is attained finality. Supreme Court said,
May I
if
request,
there
my
is
lord,
any
yes,
fraud,
have this
then you have
matter,
to file 227.
have this matter on Monday, I will try to convince, my lord.
Yes,
So for
please.
us, office objection kindly be overruled, my lord.
Yes, what is that office objection?
Prayer should be clear and specific ಅಂತ ಹೇಳ್ತಾರೆ with annexures. 1 to 4 complaints ಆಗಿದೆ.
Yes, we'll see on that. Yes,
Please.
Read this matter next week.
Monday,
Monday I have some other matters. Next week we have busy. Yes, let us see.
please.
For order serial number 39, Ravi Shankar A for petition.
That's filing a memo for withdrawal.
Cabinet counsel of the petitioner has filed a memo, leave of this court.
Well, that's return of annexes are mentioned in the memo, my lord. Certified copies. My lord.
Yes, office is directed to return that certified copies to the petitioner forthwith after retaining that Xerox copy.
Grateful.
Serial number 40, Shamegowda HV.
Appearing for the respondent, your lordship.
Petitioner in the matter have served the papers, petition papers on the learned advocate for the respondent. Only a short issue is involved in the matter, my lords. It may be disposed of.
No, that only one respondent.
Only one respondent.
Yes,
Sole
madam.
respondent, sole
Yes, your lordship.
petitioner.
You are taking
Here for the
notice.
respondent.
I had served papers way back on 31-1 itself, my lords.
You are ready?
Yes, your lordship, may be heard.
Yes. My lords, the suit is one for recovery of money.
Yes.
The case of the plaintiff is that they had placed an order, wide purchase order dated 24/2022, for me to, please, my lords, suit for recovery of money.
Yes, you are the plaintiff for a defendant.
I am the defendant.
Yes.
I, my lords, filed IA number 3 for return of plaint under order 7 rule 10, which came to be rejected by the trial court, commercial court.
Yes, on what ground?
On, my lords, it is a very vague order, my lords. May I kindly see the impugned order?
No, you are filed an application under what ground?
Because no cause of action, not even a single part of cause of action arose in Bangalore.
Yes.
Everything arose in Maharashtra.
Yes.
My lords, the case of the plaintiff in a nutshell is that they had placed an order of 100 metric tons of steel. Wide purchase order dated 24/2022.
24?
20/04/2022, please.
Yes.
For supply of 100 metric tons of TMT steel bars.
Yes.
Out of their case is that I have only supplied 10 metric tons and remaining 90 metric tons was not supplied. And it is also alleged by the plaintiff that towards the payment, they had made a payment of 40 lakhs.
Yes.
And accordingly, after adjusting the money for 10 metric tons, I am liable to repay them 31 odd lakhs is what their suit for recovery is.
Yes.
My lords, may I kindly turn to the purchase order at page number 68, annexure G for a moment.
Your lordship, I would like to object. Page number 68 is not the purchase order. 68 is a sales order and we have
No,
categorically
you wait
denied
for
that.
your turn, madam. Let him argue. Yes. 60?
68, please, my lords, annexure G. My lords, may I kindly see the address of the plaintiff company in the letterhead.
Yes.
Zetwork Manufacturing so-and-so, which is the respondent. The address is, my lords, Pune, Maharashtra, which is in Maharashtra.
Yes.
Next, my lords, the supplier's details right below to the left. Dioli Growth Center, Dioli, Maharashtra.
Yes.
And my lords, the next billing address is also Pune, Maharashtra. Even the delivery address, my lords, is Jalgon, Jamner, Maharashtra.
Yes.
No part of cause of action has arisen in Bangalore.
Yes.
And my lords, may kindly turn to page number 72.
Yes.
There is one clause under 27, the last second clause.
Yes.
Governing law and dispute resolution. The PO shall be governed by the laws of India, and any dispute arising out of this order will be submitted to Indian law and to the exclusive jurisdiction of the courts of Bengaluru.
No,
This is what, the plaintiff is trying to take advantage of.
What is the condition?
Condition number 27, please. At ink page number 72, Malaj.
27.
27.
Yes.
Governing law and dispute resolution.
Yes.
The purchase order shall be governed by the laws of India, and any dispute arising out of this will be submitted to Indian law and to the exclusive jurisdiction of courts of Bengaluru. This is what they are trying to take shelter under.
Yes.
I have disputed this purchase order in my written statement by assigning detailed reasons. And moreover, my lords would be aware that even by agreement, assuming that there is an agreement, even by agreement, parties cannot oust the jurisdiction of civil court where the cause of action actually arose. And my lords, vest it with a court where there is no cause of action that has arisen. And my lords, may kindly now see the cause of action that is stated by the plaintiff in the plaint. At paragraph number 18, my lords, ink page number 35.
Yes.
The cause of action for the suit arose on 31/5/2022 and 16/7/2022, when the defendant failed to fulfill the terms of delivery of the consignment in accordance with the PO. On 22/9/2022, when the plaintiff sent a legal notice to the defendant and sought for payment of sum of rupees 31 lakhs so and so, being the amount receivable by the plaintiff as on the date of legal notice and thereafter continuously on several dates. It is submitted, next paragraph, Malats. It is submitted that the commercial court at Bengaluru has jurisdiction under section 6 of the Commercial Courts Act to adjudicate the above dispute, and further both the plaintiff and defendant have expressly agreed that the PO shall be governed by the laws of India and any dispute arising therefrom will be subject to the exclusive jurisdiction of the courts of Bengaluru.
On that conditions, they are saying that cause of action.
Cause of action is arisen. So, Malats, what is crucial here is, in the cause of action paragraph, nowhere do they state as to where the cause of action arose.
No, they said in terms of the 27, it's
27, it is.
wherever transaction.
Well, that is what they say. And let's have the judgment of the division bench.
No, what is that the trial court has said while dismissing your?
Trial court has said, please, Malats, at ink page number 26, it is only a one single page order where I had produced several judgment fellows of this honorable court, even the division bench.
Read that, what is that?
Please. In the background of the above, let's get page number 26.
Yes.
In the background of the above facts and circumstances, the court feels that no elaborate reasons are required to be recorded to answer the question raised by the defendant. As per section 20 CPC, the suit like present nature shall be instituted in the court within the local limits of whose jurisdiction the defendant or each of the defendants actually and voluntarily resides or carries on business or personally works for gain, or the cause of action wholly or in part arose. In present case, it is not in dispute that the plaintiff is a company having its registered office at Bengaluru. Malats, this, my respectful submission is that, is irrelevant for the purpose of computing jurisdiction as per section 20 CPC, because it says where the defendant carries on business or resides. Next portion, Malats. The plaintiff has issued purchase order by imposing a condition that the courts of Bengaluru would have jurisdiction to take cognizance of the dispute. Having accepted the purchase order, the defendant allegedly supplied 10 metric tons of TMT bars. The plaintiff is seeking the refund of surplus amount. The plaintiff, well, next sentence is very crucial. The plaintiff allegedly transferred the said amount through RTGS to the defendant from HDFC Bank, MG Road, Bengaluru. This is nowhere stated in the plaint. This is nowhere stated in the plaint, nor has there been any document that is produced along with the plaint to this effect. It is clear that past cause of action arose in Bengaluru. Therefore, this court has territorial jurisdiction to try the suit. The next sentence, my lord, there is an absolutely unwarranted statement against me, which say where the trial court says the defendant is filing this kind of application again and again, probably to protract the proceedings. The conduct of the defendant in filing this kind of applications is deprecated. I have not filed any such applications again and again. This is the only application that I have filed for return of plaint, please.
No, two things. One is that, that office is registered in Bangalore.
In Bangalore, that is what they say. But the purchase order speaks to the contrary. The purchase order says that their office is in, let's me kindly turn to the purchase order 68 at Pune. Zetwork Manufacturing.
Yes.
Who's
Is there
the-
any office in Bangalore?
They
Yes,
say
Your
that there
Lordship,
is an
our
office in
registered
Bangalore.
office is in
They
Bangalore.
say, but Malas, my respectful
We have
submission is that.
produced incorporation
20.
certificates also.
Yes, we'll see the section 2. Please.
Come here, only. Take this. May I be permitted to read, Mills?
Yes.
Section 20, other suits to be instituted where the defendants reside or cause of action arises. Subject to the limitations aforesaid, every suit shall be instituted in a court within the local limits of whose jurisdiction A, the defendant or each of the defendants, where there are more than one at the time of commencement of the suit, actually and voluntarily resides or carries on business or personally works for gain. Only the defendant. B, Millets. Any of the defendants, where there are more than one at the time of commencement of the suit, actually and voluntarily resides or carries on business or personally works for gain, provided that in such case, either the leave of the court is given or the defendants who do not reside or carry on business or personally work for gain as aforesaid, acquiescence in such institution, or C, the cause of action wholly or in part arises. Well, let's hear the no cause of action or even a single.
What is that explanation?
Explanation. A corporation shall be deemed to carry on business at its sole or principal office in India or in respect of any cause of action arising at any place where it has to also, it has also a subordinate office at such place.
Yes.
My office is admittedly situated in Dioli, Maharashtra. This suit has been filed all the way here in Bangalore only to drag me here and harass me. One judgment, which I would like to pass on.
Yes.
The Decision of this honorable court. I'll only take my lots to the relevant paragraphs, my lords.
Yes. Which is that paragraph?
Well, it's one, yes, I'm sorry. Writ petition 26568, the chairman and others versus M. Nakpal.
Yes.
Do my lords have that, please?
Yes.
That's in almost at the end. Paragraph number 27, page number 5, my lords, page numbers are at the bottom.
Yes.
The considered judicial view from the container of judgment cited by both the sides is that it is not open for the parties
Read
by
that para 27.
27, please, my lords.
Yes, consider, yes.
Considered judicial view emerging from the container of judgment cited by both the sides is that it is not open for the parties by an agreement to confer jurisdiction on the court, which it does not possess under the Code of Civil Procedure, but where two courts or more have under the CPC the jurisdiction to try the suit or proceeding, an agreement between the parties that the disputes between them shall be tried in one of such courts is not contrary to public policy, and such an agreement does not contravene Section 28 of the Contract Act.
No, but
Now,
trial
please.
court has not relied on that point.
Well, I had produced these decisions. I even have a memo to that effect.
No,
None of
but
my judgments
trial
are
court
considered.
has not said they have a jurisdiction because there is a condition in that. That is not the finding.
That is not the finding.
Yes.
Only regarding the
Only
place of
regarding their
payment,
office.
alleged place of payment.
No, they said that their office in Bangalore,
Please,
you have paid that amount in that Bangalore.
in Bangalore. Well, it's their office would not be relevant for the purpose of calculating jurisdiction.
Yes.
Well, second, regarding the place of payment, nowhere in the plaint is it disclosed. That finding, HDFC Bank, Bangalore, is not at all forthcoming from the plaint government.
From where that court has got that?
The court, they to my objections to IA, they produce some bank statement where they have maintained an account in HDFC Bangalore. They say that UTR number tallies with this, where I have made the payment. Well, that would not be a place from where it cannot be presumed that the
Yes, madam.
Lordship, I would like to draw your attention to ink page number 82, para 9 of the objections that we had filed to the said IA.
82.
Ink page 82, para number 9.
Yes.
The averment of the defendant that they had no transaction within the territorial jurisdiction of Bangalore is false and is denied. The registered office of the plaintiff is in Bengaluru. The advance payment was made to the defendant by the plaintiff from its registered office at Bengaluru through HDFC Bank MG Road branch in Bengaluru on 20th of April via NEFT with UTR reference so and so. And we have also produced a print copy of the bank statement, which is Annexure A, which the petitioner here has conveniently not attached with the petition.
Yes. No, this is your written statement.
No minutes.
This is the objection to IA, Your Lordship. IA number 3 that they have challenged here.
The plaint for regarding that pleading regarding the cause of action.
Cause of action pleading, Your Lordship, we had stated that the registered office of the petitioner is in Bengaluru.
Where is that?
Your Lordship, the plaint.
Where is their registered office? Have you mentioned that
Yes,
office
Your Lordship,
address?
we have also got the incorporation certificate along with the plaint.
Where is that? Show me. Where is your plaint? Plaint is produced.
Plaint is produced, please. Ink page 29, Annexure B.
Yes.
Paragraph number 3, over the page at page number 30. They mention regarding their address.
Yes.
It is incorporated in Chennai. However, the address was changed and subsequently it was transferred to Bangalore. We have produced both the documents.
Where you are reading?
Paragraph 3.
Para number 3, Your Lordship.
Yes.
Ink page 30.
Yes.
The plaintiff is a private limited company having SIN number so and so incorporated under the Companies Act at Registrar of Companies Chennai, and a copy of the certificate of incorporation is produced as document number 1. Subsequently, the registered office was shifted to Bengaluru, Karnataka.
No,
and
that is immaterial. Your office shifting here or your, see, section 20 says it is for the defendant.
Paragraph number 6, where my address is mentioned.
Part of the cause of action, if I may take your lordship to the order, the first reason that has been provided.
Yes.
Apologies, your lordship, just a moment. Page 26, Your Lordship. As per
26 of-
section 20, where the part of the cause of action has arisen, that is the reason, Your Lordship, the judge has given in the district court. That since a part of the cause of action, all the communication was made from Bangalore. The payment was made from Bangalore, and we have produced a proof of that. The incorporation is in Bangalore, and hence and also the purchase order, Your Lordship, which they have accepted in their statement of admissions and denials,
No,
they have
that,
accepted that document, Your
What
Lordship.
is that? Have you examined on that cause of action?
Please, my lords.
That if you see, entire object of the act is that for the interest of the defendant.
Please, my lords.
Now, if you see A, B, C.
Please.
Cause of action, even if the plaintiff's office is situated in Bangalore,
Please.
if you place an order from that Chennai or some other place, if they are dispatched from Bangalore, again, cause of action is.
Please,
stopped.
my lords.
Then it is defeating that A and B. Have you examined that cause of action regarding this?
Indeed, my lords, indeed. What there is one judgment of the division bench of the Gujarat High Court, wherein our own Chief Justice, my lords, when their lordships there was, has said place of payment in the current mode when the technology has taken over, if it is made through payment modes like RTGS, NEFT and all, that would not amount to even a part of cause of action because it can be made from any place of the
I'm
world.
saying that
Please,
their office is situated in Bangalore.
please, my lords.
They have made a transaction from Bangalore.
Please.
Can it be a cause of action?
It cannot be, my lords. My respectful submission is that it cannot be.
Have you any judgment? See,
Yes.
cause of action means the day when you are ordered, day we are supplied,
Please.
wherever the transaction is applied, it is also
Please,
cause of action.
Please, and it is not
Now
the-
that suppose
Please, my lords.
you are not disputing, admittedly their office in Bangalore.
Please,
You are in that Chennai or Maharashtra.
please, my lords.
You place an order from Maharashtra.
Please.
They have supplied from that Bangalore. Can they file in a suit that there is a cause of action in Bangalore?
My lords, if they had supplied from Bangalore, then my lords, they could have.
Then
Here, my lords, the place of supply, delivery, everything is in Maharashtra. Their own office is in Maharashtra, going by the purchase order.
subsequently they have shifted to Bangalore.
Subsequently, they have shifted to Bangalore.
When
And
we have shifted to Bangalore, see, in respect of this transaction is concerned, nothing has been done from Bangalore, that Bangalore office.
Indeed, my lords.
Your Lordship,
There-
all the communication and the payment has been made from Bangalore office, and the petitioner herein is aware of the same.
No, see, when you have shifted that office to Bangalore,
2019 is what they say in the plaint. But my lords, this order is not all placed from Bangalore.
Your
No,
Lordship,
no,
a
when
short
that order has
accommodation
been
may be
placed,
granted.
the
I will
order-
produce all the documents. All the annexures have not been produced along with this petition.
you give that which are the documents?
Let's,
Place the documents. Next week.
well, it's
We will.
20th April 2022 is the purchase order.
Hmm.
In the plaint at para 3, they say, subsequently, the registered office was shifted to Bengaluru, Karnataka on 15/10/2019. And well, it's even assuming that they placed an order from Bengaluru, my respectful submission going by section 20 of CPC is that it would be immaterial because it specifically says,
No, that's what I'm asking. What
Please.
is that class C, cause of action?
well, it's one
Cause of
judgment, if I
action
may,
Doesn't says that
please.
it is only in the place of the defendant.
Please, it's, well, it's cause of action. A and B, well, it's covers it.
Now, therefore, I'm saying that if
Please.
C has been interpreted widely,
Please.
then object of A and B will defeat. it.
I understand, my lords.
Have any judgment on that point?
I understand my lord's concern. It is usually, my lords, the debtor should seek the creditor is the principle that's followed, on which basis my lords are asking me a question if that can be considered. That was also considered, my lords, by our own Chief Justice in the division bench decision, which I may be permitted to pass on.
Yes.
My lords may kindly see. Third page, my lords, paragraph number 4.
Yes.
The contention. Learned senior advocate for the petitioners in the submissions emphasized that the agreement dated 28/6/2011 between the plaintiff and the defendant was entered into in Goa, which was for transportation of petitioners' iron ore and other minerals from the anchored vessels, and that the total work under the suit contract was carried out in Goa. It was submitted that the barge was hired as per the suit contract and payment was to be made in respect of trips undertaken as per the contract terms. It is next submitted that the plaintiff under the suit contract was made by the petitioner through RTGS from Goa, and that even the checks were issued to the petitioner
Different.
on
No,
certain
I'm asking
occasions.
that
Please.
office. If office is situated,
Please,
then it will be a cause of action.
please, Malats, here, I
You
understand.
just examine that. In the meantime, you also produce that whatever.
We'll
the
file
document.
our objections and wakalat also, your lordship. 2 weeks' time may be granted, your
Malats,
lordship.
may kindly pass an order of stay staying further proceedings because it's on
Your lordship,
17. Day by
your
day, the
lordship,
matter is
as
being
per the
had.
Commercial
It-
Courts
No,
Act,
what
the suit has to be disposed of expeditiously, your lordship.
Please, I am all in Malats for the suit to be disposed of.
Suppose if suit is decreed, then this will become infructuous.
Indeed,
No, your
Malats.
lordship, it is still in the state, even
No, what
issues
is,
have not
what is
been
the
filed.
next date? In
Malats,
that
I have filed an application.
No,
See-
what is the next date in that suit?
Next date is
Next date is
17th,
17th.
your lordship. They have
17th.
filed yet another IA.
The
But orders on those IAs.
Yes.
my apprehension, it was on the 3rd, Malats. Then again the trial court, as soon as I filed my IA, their objections was filed on the 3rd. The trial court said, you argue today, if not, I'll dispose. The same happened even on IA number 3.
On 18th. In the meantime, you file it. You also verify on that.
Please,
point.
Malats,
What-
may I seek for stay of the
No, till
proceedings?
then, nothing will happen. Therefore, I am granted on 18th. Yes.
Please. Great.
Much obliged.
Yes. If it is posted for argument on finally, then I will take, don't worry.
Please, Malats.
No, your
Great.
lordship, even issues have not been framed.
Yes, that is still there.
It is before the issues are framed only, I am permitted by law to raise the objection regarding jurisdiction, Malats.
No, why that provision has been made to save the time of the court.
Indeed, indeed.
It has to
Indeed.
be decided in that threshold at the beginning itself.
Indeed, Malats, indeed.
Now let us
And
see
even
that
in the Gujarat High Court decision that I furnished, it says section 20, the object was never to harass the defendant.
No. That's different.
Please,
If it is covered under C,
please,
then what is that A and B will be.
please.
that-
I'll assess my
they-
lords on that. I'll do something.
Examine on that.
Great.
Copy of the citations will be provided to us, your lordship.
I'll provide it later, Malats. If he was here, I would have given it.
Yes. Hmm. 57.
They have made an application for early hearing.
Yes.
Main suit has been disposed of yesterday.
Yes.
Just want to go through it next week.
No, suit is disposed of, then
Filed by the person in whose favor the plaintiff, the suit is allowed. I just want to submit next week it may be.
yes, at the request of counsel for the respondent, please this matter next week.
Serial number 47.
40?
47.
Hmm.
And kindly issue a summons to the defendant number 1 to 5 and
Wait, mister, matter is not at reached.
ಏನಕ್ಕೆ ಕೊಡ್ತೀನಿ ಸ್ವಲ್ಪ ಅರ್ಜೆಂಟ್ ರೆಕಾರ್ಡ್ ಏನ್ ಹೇಳಿ
ತಿರ್ಗಾ ನಮ್ಗೆ ಕೋರ್ಟ್ ಆಫ್ ಇವರು ನಿಮಗೆ
ನಾಳೆ ಡೇಟ್ ಜಾಸ್ತಿ ಮತ್ತೆ ಮೆಮೋಸ್ ಜಾಸ್ತಿ ಕೊಟ್ಬಿಟ್ಟಿದ್ದಾರೆ ನಂಬರ್ ಕಡಿಮೆ ಹೇಳಿದ್ದಾರೆ ಅವ್ರು ಫೋನ್ ಮಾಡಿ ಆಯ್ತು ಕೇಳ್ತೀನಿ ಸರ್
ಅಲ್ಲ ಹೇಳಿ ನನ್ಗೇನ್
ಹಾಕ್ಬಿಟ್ಟಿದ್ದಾರೆ RF ಯಾವ್ದು ಹಾಕ್ಸ್ಬೇಡಿ ಬರೀ ಡೇಟ್ ಅಷ್ಟೇ ಇರೋದು ಹಾಕ್ಸಿ ಅಂತ ಹೇಳ್ತೀನಿ ಇನ್ನೊಂದು
ನನ್ಗೇನಿಲ್ಲ ಅದು ರೀಚ್ ಆಗದಿದ್ರು ನಾನೇನ್ ಬೇಜಾರಾಗಲ್ಲ ಡೇಟ್ ಇರುತ್ತೆ ಅಂತ ಪದೇ ಪದೇ ಓಡಾಡೋ ತಪ್ಪತ್ತೆ ಈಗ ನಿಮ್ಮೆದುರಿಗೆ ಸಾಹೇಬ್ರಿಗೆ
ನಂಬರ್ ಕೊಡಿ ನಾನು ಹೇಳ್ತೀನಿ ಏನಪ್ಪ ಅದು ಇವಾಗ ಬೇಕಾ ಅರ್ಜೆಂಟಾ ನನಗೆ ಅರ್ಜೆಂಟ್ ರೆಕಾರ್ಡ್ ಸಾರ್ಟ್ ಔಟ್ ಮಾಡ್ಬೇಕು ಅದು ಒಂದಕ್ಕೆ ಹಿಡ್ಕೊಂಡ್ರೆ ಎಲ್ಲ ಟೈಮ್
ಅದು ಕನ್ನಡ ಸ್ಕೂಲ್ ಹುಡುಗರು ಸಫರ್ ಆಗ್ತಾ ಇದಾರೆ ಅದ್ರಲ್ಲಿ
ಲಾಸ್ಟ್ ಟೈಮ್ ಹೇಳ್ಬಿಟ್ಟಿದ್ದೆ ಅಂತ ಇವಾಗ ಫೋನ್ ಮಾಡ್ತಾ ಇದ್ರಿ ನಾನು
ಇದಾಗಿದೆ ಒಂದ್ ಪಾಸ್ ಅವರ್ ಆಗಿದೆ ಒಂದ್ ಎಂಟ್ರಿ ಮಾಡ್ರಿ
ನೀವೇ ತಂದು ಎಲ್ಲ ನಿಮ್ದೇನೆ
ಒಂದು ಪಾಸ್ ಅವರ್ ಆಗಿದೆ
ಈ ತರ ಕೊಟ್ಟಿದ್ದೆ ನಾವು ಇದೆಲ್ಲ ಆರ್ಡರ್ ಶೀಟ್ ಎಲ್ಲ
ಅದೇ ಅದು ಕೊಡಿ ಕೆಳಗಿನ ಕೊಡಿ ಇದು ಕೊಡಿ
ಯಾರು ನಿಮ್ದೆ
ನಂದು
ಹೇಳ್ತೀನಿ ಸಾಹೇಬ್ರ ಹತ್ರ ಮಾತಾಡ್ತೀನಿ
ಹಾಕ್ಸ್ಬಿಡಿ ಸರ್
ಆಯ್ತು
ಆಯ್ತು
29 ಪಾಸ್ ಅವರ್ ಆಗಿದೆ
ಅಂದ್ರೆ ಮಕ್ಳು ಭವಿಷ್ಯ ಇದೆ
ಇವಾಗ ಇಲ್ಲ ನೋಡೋಣ
ಮಕ್ಳು ಭವಿಷ್ಯ ಇದೆ
ಆಗ್ಲಿ ಸರ್
ಕನ್ನಡ ಸ್ಕೂಲ್ ಅದು ನಿಮ್ಗೆ
ಆಗ್ಲಿ ಸರ್ ಆಯ್ತು ಏನಪ್ಪ
ಬರ್ಲಾ
ಸರ್ 2:30 ಹೌದಾ ಇಲ್ಲ ಪಾಸ್ ಅವರ್ ಮ್ಯಾಟ್ರ್ ಆರ್ಡರ್ ಆಗೋಗಿದೆ ಸರ್ ಅದು ಒಂದು ಆರ್ಡರ್ ಆಗೋಗಿದೆ 24.
ಆಯ್ತಾ? ಏನ್ ಬೇಕಾಯ್ತಾ? ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ಅಲ್ಲಿ ಆಮೇಲೆ ಬನ್ನಿ ಸರ್, 2:30 ಬನ್ನಿ. ಅದೇ ಆಮೇಲೆ ಬನ್ನಿ, 2:30 ಬನ್ನಿ, ಅರ್ಜೆಂಟ್ ಇದೆ ನನ್ಗೆ. ಕ್ಲಾರಿಫಿಕೇಶನ್ ಎಲ್ಲ 2:30. ಗಿರೀಶ್ ನಿಮ್ದೇನು?
48.
ಅದೇ ಹೇಳಿದ್ಮೇಲೆ ಆಮೇಲೆ ಬನ್ನಿ 2:30ಗೆ, ಅರ್ಜೆಂಟ್ ಇದೆ, ಸ್ಕೂಟನಿ ಕಳಿಸ್ಬೇಕು. ಅಬ್ಜೆಕ್ಷನ್. ಗಿರೀಶ್ ಜೋರಾಗಿ ಹೇಳು.
Serial number 41 office of the
ಕೊಟ್ಟೋಗಿದೆ, ಎಲ್ಲಿದೆ? ಪಾಸ್ವರ್ಡ್ ಆಗಿದೆ, ನನ್ನ ಹತ್ರ ಯಾವ್ದು ಇಲ್ಲ.
password ಆಗಿಲ್ಲ.
ಹಾ, ಅದೇ ಮುಂದ್ ಫೈಲ್ ಹೊಟ್ಟೋಗಿದೆ, ನನ್ನ ಹತ್ರ ಈಗ ಎಲ್ಲಿರುತ್ತೆ ಅಂತ ಹೇಳಿ. ಪರ್ಮಿಷನ್ ಬೇಕಾ? ಎಲ್ಲ ಕಡೆ ಕ್ಯಾಮ್ರಾ ಫುಲ್ 360 ಡಿಗ್ರಿ ನಾನು ಮಾತಾಡ್ತಾ ಇರೋದು ಅದ್ರಲ್ಲಿ ರೆಕಾರ್ಡ್ ಆಗಿದೆ. ಇವತ್ತು ಬೇರೆ ಯೂಟ್ಯೂಬ್ ಅಲ್ಲಿ ಅದನ್ನ ನಾನು ಪ್ರೀವಿಯಸ್ ಅವ್ರಿಗೆ ಯಾರಿಗೋ ಹೇಳಿದ್ದೆ, ನೀವು ಇದು ಮಾಡಿದೆ ತಪ್ಪು ಅಂತ. ಇಲ್ಲ ಅಕೌಂಟಬಲ್ ಮಾಡ್ತಿದ್ದೆ. ನಾನು ಏನ್ ಮಾತಾಡಿದ್ರೆ ನೀವೇನ್ ಮಾತಾಡಿದ್ರೆ ಅದು ರೆಕಾರ್ಡ್ ಅಂಡ್ ಡೈರೆಕ್ಟ್ ಲೈವ್ ಅಲ್ಲಿ ಇದೆ. ಆದ್ರೂ ಏನು ಮಾಡಕ್ಕಾಗಲ್ಲ, ನೀವು ಕೇಳಿದ್ರೆ ನಾನು ಕೊಡ್ತಾರೆ ಸರ್. ಒಳ್ಳೇದೇ ಅದು ಆರ್ಡರ್ಸ್ ಎಲ್ಲ ಮುಗಿದೋಯ್ತು. ನಾಳೆ ಸರಿ ಆಯ್ತು, ಬೆಳಗ್ಗೆ ನಂಬರ್ ಕೊಡ್ತೀವಿ. ಲಿಸ್ಟ್ ಆಗಿದೆಯಾ? ಸರಿ ಬಿಡಿ, ತಲೆ ಕೆಡ್ಸಿ ಹೇಳಿ ಸರ್, ಕೊಡ್ತಾರೆ ಇಮಿಡಿಯೇಟ್ ಕೊಡಿ. ಮೇಡಮ್ ಅವರೇ ಎಲ್ಲ ಹೇಳ್ತಾರೆ ಏನ್ ಮಾಡ್ಬೇಕೆಲ್ಲ. ಹಾ. ಗೊತ್ತಾಯ್ತು. ಹಾ. ಏನಪ್ಪ? ಅಲ್ಲೇ 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 ಏನ್? ಯಾರು ನೀವು? ಹಿಂಗ್ ಬನ್ನಿ, ಹಿಂಗ್ ಬನ್ನಿ. ಇದಾವೆ ಸರ್, 7-8 ಇದೆ.
ಅಣ್ಣ ಸೀರಿಯಲ್ ನಂಬರ್ 56 ಅಲ್ಲಿ ಅಮೆಂಡೆಡ್ ಪಿಟಿಷನ್ ಹಾಕಿದೀವಲ್ವ ಅಂತ ಚೆಕ್ ಮಾಡಿ ಹೇಳಿ.
ಚೆಕ್ ಮಾಡಿ ಹೇಳಿ. ಸರಿ ಅಮ್ಮ, ಆಯ್ತು. ಒಟ್ಟು 5 ಕೊಟ್ಟು ಕಳ್ಸಿದ್ದೆ, ನನಗೆ ಬಂದಿರೋದು 3. ಇನ್ನೆರಡು ಬರ್ಬೇಕಲ್ಲ. ಒಂದ್ಸಲ ಹೇಳಿ ಆನಂದ್. ಹಾ, ಅಲ್ಲ ನಿಮ್ದು ಸೇರ್ಸೆ ಇನ್ನೆರಡು ಬರ್ಬೇಕು ಅಂತ ಹೇಳಿ. ಕೊಟ್ಟಿದ್ದೀರಾ ನೋಡಿ. ಒಟ್ಟು 3 ಬಂದಿದೆ ನನಗೆ. 3325 ಎಷ್ಟು ನಿಮ್ ನಂಬರ್? ಕೂತ್ಕೊಳ್ಳಪ್ಪ ಕೂತ್ಕೊಳ್ಳಪ್ಪ. ಪಾಸ್ವರ್ಡ್ ಮ್ಯಾಟ್ರ್ಗಳು ಬಂದಿದ್ದಾವ ನೋಡ್ಕೊಂಡು. ಯಾವುದು ಯಾವುದು ಎಷ್ಟು ಸೀರಿಯಲ್ ನಂಬರ್? ಸೀರಿಯಲ್ ನಂಬರ್ 56. 56. ಏನಾಗಬೇಕು ಅದರಲ್ಲಿ? ಅಮೆಂಡೆಡ್ ಕಾಸ್ಟ್ ರೈಟ್ ಹಾಕಿರೋದು ಇಲ್ವಾ? ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ಮಾಡಿದ್ರು. ಹೌದಾ? ಪಿಟಿಷನ್ ನೋಡ್ಕೊ. ಹೌದಾ? amended to be clarified and clarified. A date of submission of the not passed. List of events along with memorandum petition. Council for the year was amended petition are the order was 28/6. It will take on the academic list of events. How that will be also amended petition academic. Even the council petition thanks. ಎರಡು ನೋಡ್ತೀವಿ. ಅಂಕಾದ ಲಿಸ್ಟ್ ಎಲ್ಲಪ್ಪ. ಬಿಡಿ ಒಂದ್ ನಾಳೆ ನಮ್ದಲ್ವಲ್ಲ ಅದಕ್ಕೆ ನಮ್ಗೇನ್ ನಾವ್ ಯೋಚನೆ ಮಾಡ ನಮ್ಮದ್ ನಾವ್ ಯೋಚನೆ ಮಾಡ Cell number 41.
May I seek, my lord, a small indulgence for it?
Yes, yes.
My lord, item number 56. Tomorrow, my lord, I have a personal difficulty today. My lord, I have to go on with the matter. My lords, may kindly have it tomorrow, my lord, 56.
56, what is correspondence? 56, yes, Mr.
Yes, my lord, I am the petitioner. My lord, we'll inform the respondents, my lord. Yes.
Tomorrow, please. Yes, 56, please this matter tomorrow. Please, the request.
So grateful, my lord, I'm greatly obliged.
Yes.
Serial number 41.
Interim order may kindly be continued.
Interim order granted is 16, yes.
41.
So grateful.
Dhananjay Kumar. Plus 174.
Yes. You want time? Yes. At the request of counsel for the petitioner, week's time is granted to do the needful.
Serial number
Now, why you have not paid that process fee, madam?
office objection or
Office objection is not complied. We will not extend that interim order. No, you have not paid the process after taking that interim order. Yes, paid it and come, yes. You are taking interim order and not paying that process, Mr. Yes.
serial number 42, 43 adjourned. Serial number 44, Sumitra GM.
Awaiting service of notice to respondent.
Serial number 45, Vijay Shekhare Gowda.
Yes.
Of the court.
Hmm.
But this is a matter,
Hmm.
the partition suit, there were two partition suit filed by the parties.
Copy of the next-
Parties are interrelated
Yes.
and they made a partition deed and compromise petition, both in those suits.
Yes.
That was taken into consideration and passed an order. Kindly page number 183 of earlier judgment. Therein both parties amicably settled their issues in a compromise petition filed before the court.
Hmm.
Accordingly, the suit came to be decreed.
Hmm.
After 4 years, the defendant 4 and 8 in that suit
Hmm.
filed a application for setting aside the compromise decree.
Hmm.
That came to be allowed by the trial court at page number 37, 38.
30.
Kindly go to page number 43, my lord. That is the operative portion of the order,
Yes.
43.
What
So
is the
this
reason
an-
for set aside in that degree?
Set aside the order, kindly, the judgment and decree passed in earlier suits
Hmm.
came to be set aside and both suits restored on file. After that, now they are not taking up the issue for evidence. Directly he put for a case for arguments and deciding the case.
Main matter.
Main matter
Where
itself.
is that?
No, that is at page number, order sheet, I will produce that, page number 252, 251. Plaintiff counsel submitted, heard the arguments on both sides, complete, hence call for arguments as per the submission mentioned by the plaintiff counsel. They heard the defendants
Hmm.
and we are the plaintiff. They posted for arguments. We contended that the issue,
Evidence and all?
evidence is not led.
Yes. How issue notice stay of further proceedings in OS number 80 of 2002, pending in the file of senior civil judge JMFC Chintamani till next date of hearing.
Please oblige.
Office objection.
In the meantime, petitioner is directed to comply of subjects.
Oblige.
Serial number 46, Chaitanya SG.
Awaiting service of notice.
My lords, may be permitted to take service on the counsel appearing in the trial court. My lord.
Yes.
My lord, one more small intelligence, my lord. I'm producing one small document, my lord. This is the legal notice sent by the owner. That is the respondent number 1 to respondent number 2. I'm just want to demonstrate how this suit is a collusive suit, my lord, because
No,
they-
you file it in that counter.
no, my lord, just for a perusal, my lords, because they admit that I have vacated the premises, my lord. And they have said that I have completed all the formalities for handing over the keys.
Council, now it is for service to be complete.
Yes, my
Now
lord.
awaiting service, let that notice has to be served.
My lord, the problem is that, my lord, on 10th of this month, matter is set for final arguments in this matter, my lord. I have not cross-examined the plaintiff. I have not cross-examined the defendant number 2 also.
That order you are challenging.
Recall and reopen, my lords. I filed, I was not on record, my lord. I came as an NOC advocate very much later to the proceedings. On the same day when I filed my wakalat, I filed an application for recall and reopen, my lord. The same was rejected on the ground that you have taken ample opportunities, that since it's a eviction suit.
You are,
But-
you are that tenant.
Yes, my lord, I am the tenant.
Then naturally you are.
My lord, I have vacated. They themselves in the legal notice, which has been marked as Exhibit P8.
You are not in that position.
No, my lord, I am not in that position at all. Now that they are imposing arrears on me also, I filed another writ petition and this honorable court granted stay in that matter. Because 32,000 rupees per month rent I had to pay as per the agreement. But since that agreement elapsed and I have vacated the suit premises, this honorable court said that you need not pay and granted a stay in the
That
matter.
order.
My lord, I have produced them. The writ petition number 19687 of 24, my lord, was
Give that order.
extremely sorry, my lord. The High Court order is not, I have not
You
attached it.
produce that Monday.
Monday, my lord.
Yes.
My lords, it's listed on 10th, my lord, so.
I thought, ugly. Yes, let us see that. If you are already
Yes, ma'am.
vacated.
Yes, ಇಲ್ಲ ಅವ್ರು legal notice ಎಲ್ಲ ಹೇಳ್ಬಿಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ.
ಆಯ್ತು ವೆಕೇಟ್ ಆದ್ಮೇಲೆ even if the degree passed for an vacating, how it will affect your
No,
right?
I don't mind, my lords. If the decree is passed, I don't mind.
Then why do you want to?
Only reason is that they are imposing penalty on arrears, my lords. Arrears ಕಟ್ರಿ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ. 2017 ಅಲ್ಲೇ ನಾನು ವೆಕೇಟ್ ಮಾಡಿದ್ದೀನಿ. 2017 ಇಂದ
ಅದರ ನೀವು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ why do you want to recalling that evidence witness?
ಇಲ್ಲ, ಬಟ್ ಅವರೇ ಹೇಳಿದ್ದಾರೆ. They have written one flowery email saying that I have accepted the keys from you and you have completed all the formalities ಅಂತ. ಇದರಲ್ಲಿ ಏನಾಗಿದೆ, I have my wife is actually supposedly staying in that premises. We both have domestic issues pending, matrimonial issues pending, and therefore in order to harass me, this lady is now colluding with the owner of the property and trying to extract money from me. Only
Yes,
in that line is
Monday you
Yes.
produced.
grateful. And I may be permitted to take service on the council number.
Yes, in the meantime, petitioner is also permitted to serve a copy on the council appearing for the respondent before the trial.
Yes.
Serial number
Great.
47, Nagaraja SR.
That is,
Claim.
this petition filed for the seeking speedy disposal, my lord. The suit is pending in the year 2014, my lords. In the 2019 posted for plaintiff evidence, suit for partition, my lord. Now, my lord, the first petitioner is the dependent number 8. He's aged about 63 years. All the other
For
partition, my lord.
suit for partition.
Partition, my lord. In the year 2001 itself, suit
ಏನ್
was
ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಇದೆ ಈಗ?
stage plaintiff evidence ಇದೆ.
Why it is adjourning from What is the year of
Reason,
the
my
suit?
lord, they have produced the entire art sheet, my lord. They have filed similar application, no dispose, speedy trial or adjournment, so issues was one or the other reason filing applications.
Stating that application is not mandatory, he denied that contents. ಆಯ್ತು ಅವ್ರದ್ದು ಸೂಟ್ ಡಿಲೇ ಆದ್ರೆ ನಿಮಗೇನು
ಅಲ್ಲ,
ಡಿಪೆಂಡೆಂಟ್ ಅಲ್ಲ.
Dependents, my lord, but we are here aged about 60 above, my lord. In suit is a similar case, my lord, are already decreed by filing joint memo by the son of court in RFA 129, my lord. Already they have settled joint. Only for the dispute between the schedule is concerned, my lord. Since 2001, they were suffering, my lord.
ಬಾಕಿದವರಿಗೆಲ್ಲ ಸರ್ವಿಸ್ ಆಗಿದೆಯಾ? 6-1 ಆಯ್ತು. 6-1 to 5. 6 ಆಗಿದೆಯಲ್ಲ? Yes. Notice issued to that respondent number 1 to 5, written with postal share unclaimed. In service of notice to 1 to 5 is held sufficient. In this writ petition, petitioner sought direction to the trial court to dispose of that suit OS number 100 of 2014 as expeditiously as possible. The respondents are served unrepresented. First respondent, the plaintiff has filed a suit for partition and separate possession in OS number 100 of 2014 before Senior Civil Judge Nelmangala. Now that matter is posted for evidence of
Plaintiff
the
evidence.
plaintiff evidence. The parties are taking the time, one or the other reason. Even after 10 years, suit is not disposed of. Hence, counsel for the petitioner sought for early disposal of the suit. In view of the above, without expressing any opinion on the merit of the case, the trial court is directed to dispose of the suit as expeditiously as possible, not later than 1 year from date of receipt of a copy of this order.
Please.
Yes.
Serial number 48, Kantaraju NK for petitioner.
Here for respondent number 1.
Petition.
My lord, we had.
For having served the copies, I am for producing the acknowledgements in the first writ petition.
My lord, we had prayed for time in the morning as there is inconvenience to the senior. The matter is in trial court on 21st, my lord. It may be kindly be posted on 10th or 11th.
No, there's urgency is this. Your lordship may look at the order passed by the trial court on the last date of hearing.
Yes, what is that?
What up, sir? I have filed a memo requesting the trial court to adjourn it because matter is coming up before this honorable court on 6th. The trial court has rejected my memo. Your lordship may look at the order sheet plus D7 files memo along with status of WP 15/8 of 2004 clubbed with number so and so and seeks 3 weeks time to submit his arguments on the objections filed in the report of the commissioner. As the D7 made out no grounds for grant of further adjournment. Just the prayer for adjournment to submit his argument on the reject application so and so is hereby rejected.
No,
Consequently, is portion.
pending of the case before this court there is no obligation for the trial court to adjourn it. Only after that, sometime courts, if the parties are agreed that will not precipitate the matter and all, then they cannot be allowed to take that.
Please.
Now that morning, senior has appeared, said that she is not well. Something she said, some family members, some problem. She said that when is the suit?
21st.
Huh?
21st.
21st.
21st it is posted for orders, Orders, not for argument. My argument is rejected. My prayer is rejected.
What is that you are challenging here?
Challenging the order dated 27/5/2024, whereunder appointed the private architect as court commissioner to inspect the properties of plaintiff and seventh defendant. That has been challenged. I have filed my objection. The objections have not been complied with. I filed objections. Your lordship may turn to objections filed by me.
Suit
for injunction, declaration of title, and delivery of possession, and restoration of demolition of construction, which was made by the seventh defendant after restoring the possession. They did not.
Commissioner is appointed for what?
Well,
Commissioner is appointed for
commissioner to measure the properties of plaintiff for seventh defendant. That we have objected.
That we objected. Plus,
Only
they
formal
did not
part.
produce any records before the trial court to satisfy whether I have enclosed the property or not. Plus, when the matter was, trial is concluded, posted for final arguments. They have argued the matter on 27/5/2024. And on 5/6/2004, further argument it is posted. At that stage, the court has suggested you file an application for appointment of commissioner.
See,
On 14/6/2024, they opened.
Don't pass any order. We'll have it that whichever the date you want. Yes.
Please, my lord.
Well,
Yes.
further proceedings may be stayed. Let them argue the matter in the
Other
meantime.
Proceedings in OS number 2380 of 2015, pending in the file of 9th Additional City Civil and Session Judge, Bangalore, till next date of hearing. When do you want, Mr.?
10th or 11th, my lord.
10th, 11th, we have some heavy matters. 18th.
My lord, 13th, 14th.
13th, no, that week is
18th, there is inconvenience, my lord.
then when the case is there?
So 21st,
21st.
plus it can also beyond the date, plus if they want it.
No. Now I will not grant interim order. I will send it beyond that.
No,
My lord.
I am not.
You have, yes. That is all that. Then I am deciding that the date you don't interfere. Yes.
My lord, date before
19th.
it.
19th.
Please, any date, I'm ready.
Any date, but
Can always be done because these are enclosed property. That is the situation. Enforcement has to be accepted. If parties have not produced appropriate records before the court,
Yes.
can always seek assistance from the.
No, it's for that, if it is assisting the court for adjudication, they can. Yes.
Report will not be based on record.
No. No, why it has been waited till that matter is posted for arguments? When they are arguing, see, the problem is, no, now that it will be reopened now, if that commissioner reports comes, he may object it, then evidence if it is necessary. That is the reason he said when it is arguments, it has been.
Yes. Asking for appointment of commissioner.
Yes, we'll have it on 19th.
any date between 10th or 10th to 15th, my lord, kindly.
10th to 15th, that week, all full, it will not reach. If you want, I will give you a date. Yes, 19th. Yes. Yes.
Interim order, plus.
Yes. Interim order, all they are arising out of the same suit.
Same suit, plus.
Yes,
In
yes.
one matter, it's okay.
One matter it is granted it. For appointment of the commissioner only.
Plus, recalling.
The commissioner has to come and explain the report, what he has been given. Application and that application is also. Second, third one is to recall further evidence not declared.
Let us say on that day we'll see.
My lord, anyway, date is given before the next date of hearing, my lord. Interim order kindly may not be granted.
Let it be there, anyhow. Yes.
Serial number 49, Rupesha B for petitioner, Sangamesh RB.
Appear for petition, my lord. Or affidavit ಆಗ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ರು affidavit ನಮಗೆ ಕಾಪಿ ಕೊಟ್ಟಿದ್ದಾರೆ.
But this matter was.
No, he said.
I'll file an affidavit. I said I will not claim any relief in respect of the sites purchased by him. Last date, may I?
Yes.
Let's refresh the facts. I have filed the affidavit.
Yes, just.
I have given the copy to my friend in the morning.
Yes.
My lord, may I make one submission, my lord?
Yes.
My lord, they have purchased, my lord, 1 acre of land on 4/11/1992. They have, my lord, obtained GPA in respect of remaining 2 acres 22 guntas on 4/11/1992.
Yes.
Thereafter, my lord, they have purchased, my lord, another 1 acre on 5/7/1993. ಈಗ ಸೆಕೆಂಡ್ ಸೇಲ್ ಡೀಡ್ ಆಗೋದಕ್ಕಿಂತ ಮೊದಲೇ in between ಸೇಲ್ ಡೀಡ್ has been executed in my favor.
Yeah, wait, let him just give the brief facts then.
Lords, may I give? Lords, what happens is,
What is this suit for?
Lords, suit for declaration.
Yes.
Suit for declaration, Lordships will find the plaintiff at page number 13.
You are
Declaration.
the plaintiff. You are the plaintiff.
I am the plaintiff, Lords. Suit for declaration in respect of two properties, item number 1, schedule 1 and schedule 2, Lords.
Yes.
Lord, schedule 1 is measuring 1 acre. Out of 3 acres, 29 guntas, survey number 85/2.
Yes.
Schedule 2 is also 1 acre.
out of survey number 85/2, out of 3 acres, 29 guntas. Lords, page 19, schedule is there. Lords, my suit claim is that, Lords, suit schedule property was purchased by me, item number 1 and item number 2 were purchased by me under 2 sale deeds, 4/11/1992 and 5/7/1993, 1 acre each.
Yes.
In respect of these two properties, I am claiming, Lords, declaration.
Yes.
And Lords, at paragraph number 3 of the plaint, I have explained, Lords, as to how I have purchased, when I have purchased.
Yes.
Lords,
What is that order he is challenging?
Lords, the order he is challenging is he wants to implead in my suit that has been rejected by the trial court.
Who is he?
Lords, he is, Lords, this survey number is totally measuring 3 acres, 39 guntas, Lords. I will explain that, Lords. 3 acres, 39 guntas.
Yes.
Out of 3 acres, 39 guntas, Lords, on 4/11/1992, Lords, the owners, that is the defendant number 1 to 17, Lords, they have given me a registered general power of attorney for 2 acres, 22 guntas.
2 acres, 22 guntas.
Yes, my Lords. 4/11/1992.
Yes.
They give a GPA for an extent measuring 2 acres, 22 guntas.
Yes.
Lords, out of this 2 acres, 22 guntas, which is subject matter of GPA, I have made.
You said that you yourself is sold 1 acre and 1 acre as
1 acre I have sold in my own favor.
remaining 1
And
acre.
1 acre, 22 guntas, I have formed sites.
1 acre.
22 guntas, out of 2 acres, 22 guntas GPA.
1 acre, 22.
1 acre,
guntas.
22 guntas, I have formed various sites and sold it to various persons.
Yes. In remaining 1 acre. you
Remaining 1 acre I have purchased, which is the subject matter item number 1.
Yes.
Then, my Lords,
Second is that you
second
have
item
directly-
I have purchased in 1993 from defendant directly, which, my Lords, nobody is concerned about. Now, my Lords, after selling this item number 1 in 1992, out of 2 acres, 22 guntas, 1 acre I purchased.
Yes.
And another sale did 5 acre on 5/7/1993
in
from the
out-
owners directly for 1 acre. Lords, the defendant, what they do, they sell it in favor of third parties on 13/4/2007 in respect of the very same 2 acres. 13/4/2007.
2017.
2007, my Lords.
2007.
7.
What is that extent?
2 acres.
It is to whom that impleading applicants?
Not to the impleading applicants, to third parties, my Lords. Now, my Lords, I have challenged this sale deed of 24/2/2007. My Lords, may kindly come to the prayer, page number 18, my Lords, in my suit.
Yes.
Page number 18, running page 18.
Yes.
May I read the prayers, my Lords? Prayer 1, declare that the plaintiff is.
You also seeking for declaration that it is null and void.
Declare that the registered sale deed dated 24, third prayer, 24/2/2007 in the office of certain is illegal and void, restrain the defendant. Now, my Lords, the impleading applicants are nowhere concerned with these two properties, item number 1, item number 2, 1 acre, 1 acre. Because they are the purchasers of sites which are formed by me in 1 acre, 22 guntas. And to that effect, I have sworn an affidavit here, and the very same finding is given by the trial court. I am not challenging anything with regard to that. I admit their sale deed. It's me who has given the sale deeds. In this affidavit, what I have said now, your Lordships may kindly peruse.
Land which is purchased by that impleading applicants, you have no.
I have no claim. I am not doing
My lord.
anything. I don't want any relief. I will read the affidavit and complete.
No, my lord. May I submit, my lord? There is the problem. My lord, kindly see. Para number 2 of his, para number 3 of his plaint, not page
I will
number
make
15.
one submission. Why this, my Lords, the purchaser,
Let
2007
me-
purchaser is there. He has set up these people to implead into it. This is the
Madam,
only thing.
They themselves have sold.
Yes, yes.
my lord.
What is that, Mr.
My lord, kindly come to page number 15, para 3, my lord. Para 3 ನಲ್ಲಿ 3ನೇಲಿಂದ on 4/11/1992, the defendant number so and so are executed a registered GPA in favor of the plaintiff to an extent of 2 acres 22 guntas. Now they say, my lord, ಇದು 2 acres 22 guntas ಅಲ್ಲಿ ಸೈಟ್ ಮಾಡಿ ಸೇಲ್ ಮಾಡಿದ್ದಾರೆ. ಪುನಃ ಇನ್ನೊಂದು ಎಕರೆ ಪರ್ಚೇಸ್ ಮಾಡಿದೆ ಅಂತೇಳಿ. After execution of sale deed in my favor by the plaintiffs, my lord, they have purchased another 1 acre. Now they say ನಿಮ್ದು 2 acres 22 guntas ಅಲ್ಲಿ ಬರಲ್ಲ, 1 acre 22 guntas ಅಲ್ಲಿ ಬರುತ್ತೆ ಅಂತ now they are making allegation in the affidavit, my lord.
No.
Let them say,
what-
let them say, first sale deed ಆಗಿದೆ 1992 ನಲ್ಲಿ 1 acre ಗೆ I am not disputing. ಸೆಕೆಂಡ್ ಇದೇನು ಸೆಕೆಂಡ್ ಸೇಲ್ ಮಾಡ್ತಾರಲ್ಲ ಅದ್ರೊಳಗೆ ಬರುತ್ತೋ ಇಲ್ಲ GPA ಒಳಗೆ ಬರುತ್ತೋ ಅದು ಯಾರಿಗೂ ಗೊತ್ತಿಲ್ಲ. Nobody can identify. Let them say out of 2 acres 22 guntas these sites are farmed. I have no objection ಅಂತ ಹೇಳಿ. ಅವ್ರು ಹಂಗಂತ ಹೇಳ್ತಾ ಇಲ್ಲ. ರಿಮೈನಿಂಗ್ 1 acre 22 guntas ಮಾತ್ರ ಹೇಳ್ತಾರೆ. ಅದು ಸಬ್ಸಿಕ್ವೆಂಟ್ ಸೇಲ್ ಡೀಡ್. ನಮ್ ಸೇಲ್ ಡೀಡ್ ಆದ್ಮೇಲೆ ಆ ಸೇಲ್ ಡೀಡ್ ಇರೋದು.
No, see, they have to say that they have purchased the property of 2 acres 22 guntas
GPA.
by through GPA. Out of that, they have found a site in 1 acre. In that 1 acre, your property is coming.
1
ಹೌದು,
acre
ಹಂಗಂತ
22
ಹೇಳ್ಬೇಕು.
guntas I
ಅವ್ರು-
farmed sites.
ಅವರು ನಾನು ಏನ್ ವೈ ಐ ಆಮ್ ಮೇಕಿಂಗ್ ದಿಸ್ ಸಬ್ಮಿಷನ್ ನನ್ನ ಪ್ರಕಾರ 2 ಎಕರೆ 25 ಗುಂಟೆಗೂ ಪೂರ್ತಿ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ. ಎಲ್ಲಿ ಬರುತ್ತೆ ಅಂತ ಗೊತ್ತಿಲ್ಲ. ಅಟ್ಲೀಸ್ಟ್ ಲೆಟ್ ದೆಮ್ ಪ್ರೊಡ್ಯೂಸ್ ಲೇಔಟ್ ಪ್ಲಾನ್. ಇಲ್ಲಿ ಬರುತ್ತೆ ಇವರು ಅದಕ್ಕೆ ಇದೆಲ್ಲ ನಮ್ದು ಈ ಕಡೆ ಅಂತ ಎಲ್ಲೂ ಇಲ್ಲ.
No, you don't know that which is your property.
My property, they themselves admit they have
No,
executed.
you have a schedule to your sale deed.
Yes, my lord.
They're saying that it is coming under that 1 acre
No,
22 guntas. For that they are not claiming.
No. They say first 1 acre purchase ಮಾಡಿರೋದಕ್ಕೆ I have no objection. ಅದು separate sale deed ಇದು schedule ಇದೆ.
For that only I am seeking
Second,
declaration.
ಒಂದೇ ನಿಮಿಷ. ಸೆಕೆಂಡ್ ಸೇಲ್ ಡೀಡ್ ಏನ್ ಹೇಳ್ತಾರೆ 1993 ಸೇಲ್ ಡೀಡ್ ಅದಕ್ಕಿಂತ ಮೊದಲು ನನ್ನ ಸೇಲ್ ಡೀಡ್ ಆಗಿದೆ. 1993 ಸೇಲ್ ಡೀಡ್ ನ ನಮ್ ಸೈಟ್ ಒಳಗೆ ಸೇರ್ಸ್ಬಿಟ್ಟು ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ. ಅವರೇ ಮಾರಾಟ ಮಾಡ್ಬಿಟ್ಟು ಪುನಃ ಅವರೇ ಸೇಲ್ ಡೀಡ್ ಮಾಡಿಸ್ಕೊಂಡಿದ್ದಾರೆ
No,
ಓನರಿಂದ.
Mr. Council, now they are saying that in 1 acre, 2 acres, 22 guntas, in which they have farmed the site, that is not the part of the suit scheduled property.
all.
For that,
I am filing
they
affidavit.
have purchased the same.
No, no.
They are not
My-
claiming.
No,
Now,
my
why
lord.
it is
Therefore, my lord.
It is posted for filing of that affidavit only, my lords.
No, is there any?
Now I am saying, lords, you let him produce.
Interim order in this case.
Yes, my lord, it is there.
There
It
is
is
an
there.
interim order. ಇದು ಆರ್ಡರ್ಸ್ ಫೈನಲ್ ಜಜ್ಮೆಂಟ್ ಪೋಸ್ಟ್ ಆಗಿದೆ. ಇಲ್ಲಿ ತಂದು ತಗ್ಲಾಕ್ಸ್ಬಿಟ್ಟಿದ್ದಾರೆ.
No, we'll clarify that, let that pass in a final order, Mr.
My lord,
Interim order will be vacated.
ಅದಲ್ಲ my lord, may I make this submission, my lord. ಅವರು ನಾನು ಇವ್ರ GPA ಪ್ರಕಾರ ನನ್ ಈ GPA ಒಳಗೇನೆ ನಾನು ಮಾಡಿರೋದು ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಅಫಿಡೇವಿಟ್ ಹಾಕಿದ್ರೆ I have no objection. ಅದನ್ನ ಹೇಳ್ತಾ ಇಲ್ಲ ಅವರು. 2 acres 22 guntas ಟೋಟಲ್ GPA ಇದೆ. ಅಲ್ಲಿ ಎಲ್ಲಿ ಸೆಗ್ರಿಗೇಷನ್ ಮಾಡಿದ್ದಾರೆ ಅವರು? 1 ಎಕರೆ ಎಲ್ಲಿ ಉಳಿಸ್ಕೊಂಡೆ ನಾನು? 1 ಎಕರೆ ಯಾವಾಗ್ಲ ನಂದು ಆದ್ಮೇಲೆ ಸೇಲ್ ಡೀಡ್ ಆಗಿರೋದು.
What is that you are written? Wait.
Kindly come to page number 15, para 3. May I read, my lord? It is submitted that originally survey number 82 was situated so and so village, approximately 3 acres 29 guntas. On 4.
What are you reading, Mr.?
My lord, plain tally para 15.
No, you don't read that. You read the affidavit, Mr.
Affidavit I will read, my lords.
Ah,
I am clearly
affidavit.
stating, lords.
Mr.
My lord, may I read, my lord?
Para
Para
two.
3. From para 3 in the.
No, this is the problem in VC, Mr. You wait, Mr. He will read that.
Yes, my lords. Para 2, my lords.
Yes.
I submit that I have filed a suit in OS number 513/13 before the Honorable Additional Civil Judge so and so at Mysore. The defendants therein with respect to properties purchased by me under registered sale deed dated 4/11/1992 to an extent of 1 acre and another registered sale deed 1329 dated 5/7/1993 to an extent of 1 acre executed by defendants number 1, 4, 6, 9, 11 and 14. Totally to an extent of 2 acres. Out of the total extent of 3 acres, 29
No, you are
guntas.
not saying that you have.
Next para.
First, you have purchased 2 acres 22 guntas by a GPA.
2 acres 22 guntas by GPA. I submit
No,
that
you
the
have not
remaining.
stated. See, he has executed GPA in respect of 2 acres 22 guntas.
That I have stated in my plaint also. I will, if that also I will add, my lords, if necessary.
That-
Just you, see,
that only
you have
I am saying.
purchased- Wait, Mr. 2 acres 22 guntas, there is a GPA in my favor.
That I have
Out
stated.
of that, 1 acres I have purchased by registered sale deed. Remaining
1 acre 22 guntas I have
I have
found
found the
sites.
site. In that, one site has been sold to him.
Yes,
For
sir.
that, this suit is not related. Yes, Mr. That's all.
ನಾನು ಅದನ್ನೇ
My
ಕೇಳ್ತಾ
lords,
ಇರೋದು.
my lords will
2
find in the
acres
next
22.
para. ಆ next para ಅಲ್ಲಿ ಅದನ್ನ ಹೇಳಿದೀನಿ ನಾನು.
2 acres 22 guntas
I
ಅಲ್ಲಿ ಬರುತ್ತೆ
submit
ಅಂತ
that
ಹೇಳ್ತಾ ಇಲ್ಲ ಅವರು.
remaining extent of 1 acre 22 guntas out of 3 acre 29 guntas was sold by me as registered power of attorney holder to various purchasers in the form of sites. I submit that I have no interest nor any claim with respect to the
No,
sites
no,
sold
you
to the
first
petition.
clear GPA in respect of 2 acres 22 guntas.
I will clarify that. I will clarify.
Acres, tomorrow there cannot be a, whether it is in 1 acre 22 guntas or 1 acres which you have purchased. That
I
is-
will clarify that. ಅದು ನಾನು plaint para 3 ಅಲ್ಲಿ ಹೇಳಿದೀನಿ. The same thing that I have stated in my plaint itself.
Yes, yes.
Lords, I will make that changes and file.
Yes, yes.
Tomorrow, my lords.
When do you want? Tomorrow,
Monday, my lords.
Monday.
Same orders list, my lords. I'll-
Till then, interim order.
Yes, interim order granted.
Matter is posted for judgment. ಅಲ್ಲಿ ಬಂದಿದ್ದು ಹಾಗೆ ಹೋಗ್ಬಿಟ್ಟಿದೆ ಅಷ್ಟೇ. I'll file it.
ಅಲ್ಲ ನನ್ಗೆ ಅದು objection.
ನಾನು in fact ಅವರು ಬೇಕಿದ್ರೆ let them give his schedule of those two sites. I will say that these two scheduled sites which he has given, I will not interfere.
Yes, what
ಅವರಿಗೆ
else you give
ಇದಕ್ಕಿಂತ
the
ಇನ್ನೇನ್
schedule
ಬೇಕು
also?
ನನಗೆ ಅರ್ಥ ಆಗ್ತಾ ಇಲ್ಲ.
You give the schedule, you will say that this is.
ಹಾಕ್ಲಿ.
Yes.
ಅವ್ರದ್ದು
Pass on
ಸೈಟ್
to-
ಗಳದು ಶೆಡ್ಯೂಲ್ ಕೊಡ್ಲಿ. ಸೈಟ್ ನಂಬರ್ 1, ಸೈಟ್
ಹೇಳಿ
ನಂಬರ್
ತೊಂದ್ರೆ ಇಲ್ಲ.
to
ಅಷ್ಟೇ
those
ಹೇಳಿ
two
ಸರ್.
schedules,
ನನ್ನ
I will
ನನ್ನ
say I am
schedule
not
ಹೇಳಿ.
claiming any relief.
No, you give the schedule to him, mister. That they will
ಆಯ್ತು.
say that. Yes.
Because they want to interfere at the instance of the 2007 purchaser.
But
ಅಷ್ಟೇ ಇರೋದು. The
you
objective
take
is
that
this.
scheduled and
ಅವ್ರು
do it
ಕೊಡ್ಲಿ.
with
ನಾನು
process.
ಆದ್ರೆ I will not interfere ಅಂತಾನೆ ಹೇಳ್ಸ್. I am obliged.
Hearing interlocutory application matter, serial number 50, Hanumantappa Ravi for petitioner.
IA number 1 of 23.
Hmm.
Petitioner died, my lord, 20th January 2021.
Petitioner is dead. Who are the tellers?
One, Narasimha and then, Muniraj.
No, how they are related?
They are sons, my lord.
Hmm.
Sons, sir.
Hmm. No, why you want to seek for a review?
The rate of new developments took place by the state government, amending a source section, the 5 of the CH-11 Act, that joint benefit shall go to the petitioner's pilot. In that background also filed this petition.
That cannot be anywhere to the benefit matter which has been closed, mister. That-
But it is. interest
That
of
is
the-
also still that has been validity has been challenged and pending before that. What has happened to that?
It's pending, my lord, sir.
Constitutional validity has been challenged, matter has been heard and reserved, I think so.
It's pending is one there.
Let us see, yes, leave this matter of 2 weeks.
And let the notice to the responding.
No, let us see that. First, your application will be allowed.
Please, ma'am.
Yes, who is that?
First petitioner, and second also son of the late Muniyamma. They died on May 20th, 2021.
No, who is dead, mister? Muniyamma is.
Muniyamma died, ma'am. Petition-
ಆಯ್ತು ಅವ್ರು ಎಲ್ಲಾರು ಹಾಕಿದಿರಲ್ಲ ಪಿಟಿಷನ್ ಅಲ್ಲಿ.
ಅವ್ರು filed the amended petition, ma'am.
ಅಲ್ರಿ ಪಿಟಿಷನ್ ಅಲ್ಲಿ ಐತಲ್ರಿ ಕಾಸ್ಟ್ ಐಟ್ಲಲ್ಲಿ
Amended.
ಅಮೆಂಡ್ ಹಾಕಿ ಹಾಕ್ಬೇಕು ನೀವು. ಕೇಸ್ ಹಾಕ್ಬೇಕಾದ್ರೆ ಅವ್ರು ಸತ್ತೋಗಿದ್ರೆ ಎಲ್ಲಾರನ್ನ ಪಾರ್ಟಿ ಮಾಡಿ ಹಾಕಿದಿರಲ್ಲ, ಇನ್ನೇನ್ ಬೇಕು? ವೈ ಐ ಯು ಟೇಕ್ ಔಟ್ ಯುವರ್ ಪಿಟಿಷನ್ ಮಿಸ್ಟರ್. ಕಾಪಿ ಇಲ್ಲ ನಿಮ್ಮ ಹತ್ರ. ಮತ್ತೆ ಪಿಟಿಷನ್ ಅಲ್ಲಿ ಕಾಸ್ಟ್ ಐಟ್ಲಲ್ಲೇ ನೀವು ಮಾಡಿದೀರಾ. ಮುನಿಯಮ್ಮ ಡೈಟ್ ರೆಪ್ರೆಸೆಂಟೆಡ್ ಬೈ ಇಸ್ ಎಲ್ಲಾರ್ಸ್ 1A ಕೃಷ್ಣಪ್ಪ 1B ಮುನಿರಾಜ್. ಮತ್ತಿನ್ನೆಂತಕ್ಕೆ ಅಪ್ಲಿಕೇಶನ್ ಐ ಎಸ್ IA, Learned Counsel for the petitioner submits that he will not press IA 3 of 2021. Dismissed as not pressed.
Serial number 51, Ravi Kumar L for petitioner, Badrinath R.
I pay for the respondent.
Yes.
My lord, for the petitioner's counsel, my lord.
Hmm.
Plaintiff's petition, my lord.
Hmm.
Lord, this has some checkered histories, my lord, so I'll just narrate, my lord, what the case is.
Yes.
The plaintiff, my lord, filed suit in 217 of 2024.
Hmm.
That is a suit for bare injunction.
No, now that this suit is for what?
Bare injunction.
Who has filed?
The plaintiff, the present plaintiff, the petitioner.
The petitioner is the plaintiff.
Hmm.
You have filed a suit for injunction.
Yes, my lord.
What is that order you are challenging now?
Now, my lord, just before I come to the order, my lord, the defendant has also filed another suit.
Hmm.
422 of
What
20.
is that order you are challenging?
Now, my lord, in an application filed by the defendant in my suit.
Regarding this,
I just-
if anything required, I will
I-
ask that.
very well.
Yes.
In
What is
my
that
suit,
order you are challenging?
in my suit,
Hmm.
he files an application of 151
Hmm.
seeking for police protection pursuant to a direction granted by this court in a writ petition. In my suit for injunction.
Hmm.
He has also filed a separate suit 422 of 24 seeking for declaration injunction.
Hmm.
Both these suits are not club.
Yes.
What had
No, in
happened?
this case, any injunction order in your favor?
There's injunction order operating in my favor. In his suit, there was an injunction order operating in his favor.
Hmm.
An appeal was preferred. We came before this court in a writ petition.
Hmm.
Lords may see the order passed by this court in the writ petition, my lords.
No, you will see that order passed by the trial court in his police protection supplement.
Yes, my lords. It's, my lords may take the reasoning starts, my lord,
Page.
at 126.
Yes.
Heard the counsel for the plaintiff and paragraph 4, my lord, bottom.
Yes.
Heard the counsel for the plaintiff and defendants, peruse the affidavit and materials available in record. It's an admitted fact that the plaintiffs have filed the present suit for a relief of permanent injunction, and on perusal of the order sheet, it appears that initially the order of ex parte injunction was granted to the plaintiff on IA number 1.
Hmm.
The same was confirmed on 9/8/2024. This said order has been challenged till the Honorable High Court of Karnataka. Now the defendant has filed a present application to provide police protection in respect of an application scheduled property, which has shown in the written statement scheduled property. It is to be noted that after passing of the order on IA number 1, defendant has preferred an appeal before the Honorable Senior Civil Judge in MEA number 29 and 30 of 2024. And in the said appeal, the Honorable Appellate Court set aside the order of this court, which was passed on IA number 1. Thereafter, the present plaintiff preferred appeals before the Honorable High Court of Karnataka in WP number 2655 of 24 and 26562 of 24, wherein it was directed that both the parties to maintain status quo in respect of the alleged respective properties of both parties. The defendant has filed the present application for providing police protection to implement order passed in the said writ petition. It is pertinent to note that the plaintiffs have objected to the instant application by contending that the defendants cannot seek police protection with the intention to grab the property of the plaintiff. He has sought for police protection, and in the writ petition it is clearly
He can see this court has passed an order to maintain status quo in the suit. OS, that order will be gone. See, if I pass an order, what is to maintain status quo in the writ suit? If writ petition is disposed of, that doesn't mean that you are not. See,
I'm not on the ground that I had.
now I will tell you if there is any other thing.
Yes, very well.
Now there is an order of status quo in the suit. Even when the trial court is not granted, this court has granted the status. If status quo is violated, any party can file an application.
That is the reason, my lord, I'll come how the conduct of the parties matters.
Yes.
Initially, there was an injunction. Injunction was set aside. This court order, my lord, how this court passed an order, my lord, would now be relevant in determination whether the defendant gets a right to file this application in my suit or he gets the right to file this application in his suit. This suit, as I stated earlier, my lord, are not clubbed. There is no counterclaim in this suit.
No, order passed by this court in which matter?
In the writ petition filed against, I'll read the order, my lord. It's a beautiful order, my lords would find.
This order is passed, status quo in the your suit or his suit?
In my suit, but with a clarification. There's no status quo. My lords may kindly come to page 105. I produced the order of this court, my lord.
Yes.
Paragraph 6, my lord. Page 105, paragraph 6.
Yes.
Having heard the counsel for the petitioner, learned senior counsel for the respondent, and perusing the petition papers, this court is of the considered opinion that since an order of temporary injunction has been granted in favor of the respondent defendant in his suit in OS 422 of 24, the petitioners cannot be permitted to interfere with the said scheduled properties. As regards the suit scheduled property claimed by the petitioners here in OS number 217 of 2024, although there may be some discrepancy in the description of the schedule, nevertheless, since the petitioner plaintiffs are contended that they have acquired ownership over the suit scheduled property under registered sale deed dated so and so, it is not the contention of the respondent that they are not the owners of the said property. They shall not in any way interfere in the suit scheduled property as described in 217 of 2014. This court would also direct the parties to maintain status quo in terms of the stated herein. The petitioner herein shall not interfere in the suit scheduled property as described by the respondent in OS number so and so. The respondent defendant in OS number so is also directed to maintain status quo in respect of the possession of the suit scheduled property in OS number so and so. Injunction with respect to his property is granted as described in that OS. In my suit, there are two independent suits. Now his application, if any, should have been filed in his suit. The reason he invokes 151 is this, my lord. This application, my lord, is not.
In both cases, there is a status quo.
Yes.
Status quo, it is not benefit to that only a plaintiff. If plaintiff has established the case, court will not say status quo, grant an absolute injunction order restraining. If status quo is granted to that, both there is a dispute that who is in the possession. Therefore, court has granted an status quo.
My lords are correct on the prospect. The reason I read out the order is this. The Honorable Court does not say, my lord, that the status is granted with respect to the scheduled property as described in 217. It does not say so. It says that the interim order is granted with respect to 42 as it is described in that suit. Interim order is granted in my suit as is described in their suit. His application, if any, under 151 should have been filed in his suit, not in my suit. The reason they do is this. My lord, this
no,
is
in both suits, the property is same.
No, different. That's where it comes in, my lord. I claim only one extent of property. In my suit is with respect to two scheduled properties.
No, it's not the same property.
No. Identity of the property is completely different. Now, my lords may see my plaint, my lord. My lords would find the schedule at page 35.
No, see, in your suit, you say that a scheduled property.
It's only a one land, my lord has said, which measures 1 acre.
1 acre. See, why you have made him as a party in that suit?
My lord, because he was trying to interfere with my possession.
Your position in that. Now court has granted a status quo.
My lord, my claim is on respect to 1 acre of land. Now kindly see his schedule, my schedule, my lord, should find at page 35, my lord.
Yes.
There's one schedule, my lord. It's an agricultural land measuring survey number 42, new number 213 to a measuring of 1 acre. His plan, my lord, should find at page 114. Hmm? 144, I'm sorry, my lord.
144.
This is 2 parcels of land measuring 1 acre 32 guntas. The first schedule, my lord, is 36 guntas of a different survey number. OD number is 227. Now kindly see this.
Yours is, which is the survey number 213.
My new number is 213. He contents is this 227, a separate extent 36 guntas, 228 measuring 38 guntas, totally 1 acre 32 guntas. If application, if any, should have been filed in a suit where is scheduled property and identity of the scheduled property is being adjudicated upon. In my suit, there now kindly see his written statement, my lord. There is written statement, my lord should find.
Now, what is this allegation in that your suit? What is that status quo is violated means what?
No, my lord, status quo violation, there is no violation of status quo. They filed this application contending that this court has granted an interim order of status quo. They need police protection to implement the interim order of status quo.
No, implementation and production of the police only if there is somebody is violating that. Otherwise, question of appointing that police. See, there is no provision which provides to appoint a police for implementing that order. In some of the judgment and all court said that to violated that, to protect that you can appoint. Otherwise, taking an injunction order tomorrow filing in the police, that is not provided until there are judgments also. Now, why you have filed an application for police protection? There should be an proof to show that he is violating that order.
Page
Share that what is that violation he is doing? Yes. Where is that application?
Page 107 is the application, my lord. The reason, my lord, should find at page 110.
Yes. Yes.
My lord, the reason that they give is at paragraph 5, my lord, page 110.
Yes. Yes, read.
I submit that after passing of the interim orders, plaintiffs by using the unlawful methods with rowdy elements, often causing interference of my scheduled property by damaging the stone slabs which covered the said property as stated supra. In view of the same against the illegal, unlawful, unauthorized acts, I have filed a complaint against them in criminal cases registered so and so. Copy of the FIR is so and so. And for the defendants and 50 to 60 of their associates at 3 AM came in a vehicle.
No, your property is in that other suit.
May kindly look into my written statement in the OS number 37 page number.
OS number?
In the same suit, my lord, the written statement, my lord, should find, it starts at page 37, my lord.
Yes.
The prayer, my lord, should find at page 56.
Before that, there is a sketch is there in page number 41.
Page number?
41 in my written statement.
What is that?
Where Muniyaktappa is in 215, my lord.
Yes, now that why it is posted today?
Vacating interim order. Where my written statement, it can be looked into there. In this written statement itself, I had been filed.
Where is that?
Page number 56, 57, 2 items.
Page 56 is the prayer.
Yes.
Therefore, the defendant above named, where the honorable court will please to dismiss the court with exception. No conflict.
Yes.
This
description is provided for, which tallies with the legal statement plain in the other suit. So if it may be any or any application, but that is only in this suit.
Yes.
Now, may see what it is. The 39, order 39. Once he provides not, if only the dependent interface and application is made. This issue no allowed Supreme Court has said whether a dependent is to file an application is before the Supreme Court.
See, if he is interfering your property where you have also obtained status quo, you file in a police protection there.
But where this honorable court passed an order, kindly.
No, you are claiming two property.
No, I am
One is
claiming one.
your suit.
Throughout.
And also,
No. I am claiming only one property. In my written statement, in his suit schedule property, I had clearly explained in page
no,
57.
if you are feeling that your suit schedule property
one.
is interfering by this person, file in a police protection in that.
But where in that,
Otherwise, here if you file in a police protection, police has to see suit schedule properties.
but where yesterday also one matter was there regarding Podi Durastu, where this honorable court directed both the parties to maintain status quo to work out the remedy before the court below. That copy itself I can be produced before the court within a couple of days.
Yes, produce that. Yes. At the request of the parties, leave this matter next week. Interim order granted earlier is extended till next date of. Yes.
Cell number 52, Dhruv M. Patwari.
No, awaiting service of notice. Notice is not served. Lawyers is not the service. Party has to. No, that is one of the options which has been given matter. It is not in a service of notice. Await service of notice. You take hand summons and serve them. If you want hand summons. You have a.
I'm saying this case subject to deposit of 50%. The matter before your honor is this, but trial court
No, have you deposited that?
not deposited as filed an IA to modify this order.
No, why you have not deposited this when the court has passed an order?
Two reasons, sir. One is because the section 11 appointment of arbitrator was passed by the trial court. The lordship's judgment is also filed. 2019 judgment, like trial court does not have jurisdiction to appoint the arbitrator. Second, the dispute was between the parties.
No, anyhow, this court has passed an order after hearing you to pay that 50%. Now you can't change that after some days. You could have argued on that, and if your court has granted, you could have challenged that.
I filed the IA to.
No, stay is subject to deposit. Otherwise, there is no stay.
What the award is being executed is a nullity in law. That's absolutely.
No, yes, you are seeking modification of that order. It has to go before the same judge. I'll verify. Yes, leave this matter next. Yes, office will verify and fix the date because it should be on VC. Yes, I'll tell you. Yes.
Cell number 53, Satish and DJ for petitioner, connected matter.
This will pass over little while.
I may require a short.
I have filed wakalat on behalf of respondent number 4 in WP 29759. I don't have the entire set of papers. So if it could be listed for a week adjournment, if my learned friend could accommodate, I'll make submissions pursuant to which on merits.
But I have one for the submission to make.
I have no objection.
I have one for the submission to make.
But by how clear my wife and children are trading, where taxes are there, well, Lord, they should be allowed to live peacefully. And they are not able to, well, Lord, even the electricity and water have been cut.
But
And
Manoj,
you are
for me,
Total.
hearing, your lordship, well, Lord, wanted to know whether if there is feeding in the.
No, that's I understood. Let us
It is
before,
there.
yes, before,
Just,
no, I will hear. Before starting, if all agreed, date, otherwise I will hear.
I'll
that.
just, I'm sorry, I have one short request to make and there is a reason for it. Last time, my learned friend wanted to press on his application. I said, I'll file my reply. We prepared a reply. What has happened is today, yesterday, last date, my lord, during the course of the hearing, your lordship said, oh, why don't you maintain status quo? Perhaps it just fell from the court. In anticipation that there may be some order passed, around 30 people have been collected by them outside the boundary, waiting to, my lord, enter the property. If there is an order passed, that's what my instructions are. I have to place that on. 1 second, sir, please. I did not interrupt my learned friend. Let us please, I am making my learned friend should wait to let me finish.
Yes. Yes.
This can't go on like this. Please.
Thing or the other which is not on record. Last time, my lord,
I have not passed any order.
I am
hearing it.
making a submission to the court. I don't understand this. I've never come across this sort of,
Yes.
anyway, my lord, all I'm submitting is I need to place this on record. Please keep it. I don't know, my lord, friend wants for a week. I'm not getting into that. Please keep it either on tomorrow or on Monday.
For appearing for.
I am for the person who actually owns the property.
No.
I am for R6's counsel. Defendant number 6's counsel. I stand correct. R1 in the writ petition. R1 in the writ petition. I am for R1. I think my learned friend Mr. Datar is appearing today for the first time.
for the first
No,
time,
except that petitioner and respondent number 6, I think others they can assist, but they have no, because when the trial court has passed an order of status quo.
It was not at their instance.
Wait.
Yes.
Nobody has challenged, only defendant
I
number
challenged.
6 has challenged. That means to say, others has no objection for the status quo and all. You have challenged and you have succeeded.
Yes.
By that he has affected. Only you two has.
I
an
actually have a
important part.
submission to make, my lord. He was not the original plaintiff.
No,
Your
I
Lordship.
know that, I know.
Therefore,
See,
he has not ever made an application.
Yes, all are arguing
I
and
understand.
doing
I
and the
understand.
last occasion. It is only when the trial court has passed a status quo.
Yes.
And defendant number 1 to 6 has been directed not to create third party.
Correct.
That has been
So-
accepted by, except you.
Yes.
All are accepted because they have not challenged.
Correct.
Only you have challenged.
I will go one step further. Even he did not challenge.
Only you two has an grievance now before this. court.
Actually, he doesn't have a grievance. He doesn't.
No.
1 second, sir. I'm answering the court. This can't be a private
No,
conversation.
He has because.
No, I'll tell the court why. He was not
you
even a
have
plaintiff.
absolute order, therefore he is before this.
No, he was not even a plaintiff. He was a defendant. I'm sorry. Sir,
Wait,
my
wait.
learned friend should just let me speak, or you please speak.
Now, Mr.
every time it goes on, my lord.
Now, I will learn a lot, but not this sort of advocacy. Let me point out one other fact to the court.
For me to hear.
I understand. Can I
say that-
point out one submission? I have one submission to make. Please see what injunction is sought for by him. He is a defendant. I am a co-defendant. Injunction sought for before your lordships is that one defendant is seeking an injunction against another co-defendant. That is not permissible in law. There are judgments. I want to place that also. I will place it. All I'm submitting is this development that has occurred today. In the afternoon, I'm told this has occurred. I have oral instructions. I will place it in writing. Please keep it on Monday. I will place it because there is a serious threat that if the court passes any order favoring him, I will be put to irreparable prejudice.
No, don't say like.
I'm
that.
not saying. I'll modify my
I-
submission.
Don't say that, pass against him that it will.
I
you are
don't say.
not- you are
I'm sorry,
concerned
my lord.
with the
I'm sorry.
judgment, Pass an order.
I'm sorry. I'll stand corrected. I bow down. I'm sorry. My words were not careful enough. I apologize and I'll not correct myself. What I'm submitting is I'll just please permit me to place this on record. Please keep the matter, my lord, according to him. 30 days have gone on in this fashion. Today, the matter was heard day before yesterday. Let it be 32 days. Keep it on Monday. That's all I'm saying.
Yes.
Nothing will happen.
Monday, that is-
The actual fact that
Yes, you may.
my wife and children are inside the house. They have cut the electricity, they have cut the water. Now the only source of water is a pond, my lord. It's an estate. The house has been in existence from where, my lord, we grew the crop and all. We have been there from 1955 onwards as tenants. Now, by virtue of disconnection of the electricity and also disconnection of the water, my lord, there is no water supply. We need to go to the cattle pond there and get the water which is inside this thing. And and my daughter, my lord, who has to go to the school, she is not able to go to school. There is no electricity.
Monday, you will have it at 2:30.
Obliged, my lord.
See, one thing. First thing is
Yes.
whether this now his claim only in respect of that house.
Yes,
Others, this court is already decided, commissioner appointed and all. Wait,
absolutely.
only house, whether it is in a suit scheduled property.
Correct.
And
have
whether he has a right over it.
That's
Absolutely.
Wait, mister. Then your arguments under the law, whether he can be challenged and all.
I bow down.
Now it is only that first I want to know that because nothing has been find out from that records to show that what is that property is claiming and whether it is part of the suit schedule.
I bow down. Right?
You
We'll
have
point.
first assist.
We'll point.
If it is not suit schedule property, then it is out of this court to decide all this.
Please.
Correct.
If it is a suit schedule property, then whether he can claim or not.
I bow
That's
down.
your
My lord,
funding.
I would
Yes, no
also,
further that.
I bow down completely to that.
Yes.
Only to that extent, whatever, my lord, we will place and assist your lordship. Monday, my lord, your lordship.
I think major is that only you two has to be. I've
And,
seen
and
that
my learned
paper.
friend, Mr. Ravi Shankar, for the reason that he is my predecessor in title, I'll make good.
They have not challenged.
I mean,
That's all right.
are
I mean,
assisting the court.
I bow
no
down.
problem.
Yeah.
I don't think it is much.
Lord, can I say what your lordships are really confined the problem in a very neat manner, and after all the heat and dust settles down, we can address your lordships in a calm manner and will not point out and
Only that
assist them.
now
We'll do
his
that.
argument is in respect of that house, whether it is in a suit schedule property. Second, whether he has a right.
I bow down, my lord.
Then
We will
if he
assist
has a right, then I have to see whether, as on the date of filing the suit, is there any materials to show?
Correct.
I'm very grateful.
These are all that.
That I am so grateful.
Well,
to your
in the
lordship.
meantime, in the meantime, commissioner was to submit the report. 30 days have gone by, harvesting my lord, or he is the person who is in
We'll
custody.
intimate the commissioner to be present on that.
My lord, what we will do is we'll inform him
Commissioner
over
has
the
to-
telephone.
Yes. that
Your
we
lordship
know
may
is
not
the-
make it an order because it may not look nice. We will inform him
but
over the
Srinivas to
telephone
be
and request
present
him.
on that.
Commissioner has
We'll
to
request
submit the report, and in that order itself, it has made clear that just because.
No, we'll see. I
I'm not
also
saying-
wants that commissioner to be present. on
I
that.
know.
If it is required.
All I'm saying is because he's a fairly senior member of the bar, it doesn't look good if it's in the order. We will telephonically inform.
yes.
That's all, my lord.
It's better Monday at 2:30.
2:30,
It
so
is
great.
convenient for
So
him also.
yes,
He
yes.
can't come and.
Our ಬೇರೆ ಕೆಲಸ ಎಲ್ಲ affect ಆಗ್ತದೆ.
Yes, 2:30. If you are filed in a wakalat, even if your wakalat is not there, I will permit if it is required. Yes,
So great, so great.
No, he is same, wait, 2:30, yes. Don't waste my time that see that advocates are waiting. I got, yes.
Grateful.
Yes. All matters, your maybe that matter involves so many acres, others having in 1 acre, 2 acres, everybody having the problem, civil matters. Therefore,
Whether it is 80 acres or 1 acre, human
want to
being
cut short because of
absolutely.
that.
I'm very grateful.
For not for my benefit to go to the chamber, see that I can reach.
So
other
grateful,
matters.
so great, so great.
Yes.
Very, very
Everybody
deeply
is
obliged.
saying that posted for orders, evidence is completed. Even every day 100 memos are moved.
Court ಹೋಗೋರ್ಗೆ ಅದು ಕಷ್ಟ ಗೊತ್ತಾಗತ್ತೆ. As a lawyers will not be definitely
Yes,
so great.
yes. We'll see that. Yes. Call me.
Serial number 55, Shavan Madhav KP per petitioner, SV Prakash.
The 54.
54.
Serial number 50, sorry,
Yes.
serial number 54, Sharan B. Tadahal, Chandrasekhar C.
Yes.
I'm for the respondent.
Yes, Mr.
Lord, the interim order is, we have made an application for vacating the interim order. And there is no way at all. They are making unlawful claim as an easementary right
What is that matter?
on private property.
No, I don't think it take much time, but whether you are ready, Mr. Ready. Yes, Mr.
ಅಲ್ಲಿಗೆ ಏನಾಗಿದೆ ಅಂದ್ರೆ ಫೆನ್ಸ್ಗೆ ಇದು ಫೆನ್ಸ್ ಮೆಶ್ ಹಾಕಿದ್ರೆ ಮೆಶ್ ಎಲ್ಲ ಸುಟ್ಟು ಹಾಕಿದ್ದಾರೆ.
No, this
This
injunction,
is,
what
this
the
is how.
injunction matters I am hearing, I think I can hear and dispose of the suit itself. That much time is consuming for this application.
We understand.
See, earlier these are all as treated as in a CRP. There is
Yes.
no to- You are all aware that how
Yes, yes.
Justice Rajendra Babu was discussing.
400
That
cases.
should be that correct method.
400
400, 500. Otherwise, this will be that taking my time. Yes. When do you want? Tuesday.
ಅಲ್ಲ ಸುಟ್ಟಾಗ್ತಾ ಇದಾರೆ ಏನ್ ಮಾಡೋದು?
Now that there should not be anything by taking in a time and.
They should not take law into their hands.
That's you have to instruct your party should not be happen anything from today onwards till Tuesday.
Tuesday.
Tuesday, Monday, ಆ matter ಹಾಕೊಂಡಿದ್ದೀನಿ ಮತ್ತೆ ರೀಚ್ ಆಗಲ್ಲ. You have seen that now.
I understand.
Yes.
ಬರೀ ಗಲಾಟನೆಲ್ಲ ಮುಗ್ದೋಗುತ್ತೆ.
Yes.
ಅದು ಹಿಯರಿಂಗ್ ಆನ್ ಐಎನ್ಎಲ್ ಬಂದ್ರೆ ಬೆಟರ್.
ಹೌದು, vacating ಇದ್ರಲ್ಲೇ ಬರುತ್ತೆ.
ಸರಿ.
See, wherever there is an vacating, I said that memo was moved, I will take that matter
Please,
because
please, your lordship is right. Please.
we are liberal in granting the interim order and we will take that for vacating also in liberal and possible.
Please.
Yes, interim order granted earlier is extended till next date of it.
Tuesday.
Much obliged.
Tuesday.
Cell number 55, Shravan Madhav KP for petitioner, SP Prakash.
Plaintiff's petition, my lords, 39-192 was, application was rejected.
Hmm.
It was challenged in the miscellaneous appeal, my lords, that was also rejected.
My lord,
Yes, early hearing.
concurrent finding, my lord.
Hmm.
Suit for permanent.
Your argument here, no, suit for,
Injunction, bare injunction, my lords.
no, their injunction, you are the plaintiff.
Lords, may kindly take page 53, my lords.
Yes.
I'll explain the title flow, my lords.
No. Now that your application under order 39 rule 1 has been rejected by the trial court.
But only on two grounds, my lords.
Hmm.
One, there is a declaration suit,
Hmm.
which was filed by the defendant.
Hmm.
In 2008 is pending. Because now that suit has been dismissed and a fresh suit has been filed.
That defendant has filed.
Defendant had filed a suit.
Declaration on what basis?
My lord, for that, title needs to be clear, my lord. I'll just take 2 minutes.
Hmm.
Page 53,
Yes,
para 24.
yes.
Para
Yes.
24, my lord, this explains my title.
Yes.
From the copy of safety dated so and so, we found that DVS Employees Housing Cooperative Society has sold site number 98 measuring 40-60 feet, the suit scheduled property in favor of LC Madhavaya. LC Madhavaya further sells it in favor of Keshavamurthy.
Yes.
Keshavamurthy further sells it in favor of Purnima,
Hmm.
wife of Shamsundar. In the next page,
Yes.
54. Wife, Purnima, wife of Shamsundar.
No, you have purchased from whom?
Purchased from one Dr. Ramesh CB.
Ramesh.
CB
Hmm.
had purchased the property from the said Purnima.
Yes. You have purchased from Ramesh.
Ramesh.
Ah, yes.
56 mallards.
I think you say give the date, it is enough. What is your date of sale, Mister?
14/2/2022.
22.
Correct.
That defendant has purchased from when?
They have not purchased any property. I will just explain it. Para 27 mallards.
Yes.
From the copy of sale deed dated 1971, it is found that K.S. Ramchandra Rao, son of Shama Shankara Narayan Rao, has sold 5 acres in survey number 51 in favor of Alappa, son of Islampura Timmappa. Next page. The said 5 acres of land in survey number 51 of Navle village is bounded on so and so. The K.S. Ramchandra Rao has sold 3 acre 28 kuntas. In favor of Kengal Halappa. Further, next, in the same parameters, 1 acre 8 kuntas bounded on so and so in favor of Islapur Halappa. Next, para 21. From the said sale copy of sale deeds, it is found that in survey number 51, Islampur Halappa had purchased 5 acres under registered sale deed dated 1971 and purchased 1 acre 8 kuntas under registered sale deed dated 1973. That means Islampur Halappa got 6 acres 8 kuntas. Likewise, next paragraph on page 56. Likewise, Kengal Halappa, who is none other than the grandfather of the defendant, got 2 acre 20 kuntas in survey number 51. From the copy of sale deed dated so and so, it is found that Kengal Halappa, son of Hanmantappa, had sold 2 acre 20 kuntas in favor of in survey number 51 situated at Navle village. Bounded on so and so in favor of DVS Employees Housing Cooperative Society. Now, the next line is important. That means the property which has been retained by the grandfather, the defendant's grandfather, Kengal Halappa, after selling 1 acre 8 kuntas out of 3 acre 20 kuntas, has been sold in favor of DVS Employees Housing Cooperative Society. What he originally owned was 3 acre 28 kuntas, which he had completely sold.
Yes.
His contention is that there was 16 kuntas of that which was adjacent to survey number 15. Because in their possession.
Now that trial court has rejected your application.
Yes.
Now what is that order by here? Is there any interim order passed by this?
No, my
Now
lord.
both of them maintain status quo. I will direct the trial court to dispose of.
Please, my lord, expeditiously, that only.
going on, my lord, he is
No.
affecting on a regular basis.
No, Mr. Counsel, from last 2 years, you don't have any benefit of that
Please.
interim order.
Correct? That is not, that.
No, you continue, status quo is there.
My consent, let there be an order saying that my consent
No.
will not be
No, my lord.
disturbed.
Now that you have 2 courts as against you, it is very limited power for me to interfere, Mr. At least I will, what is the stage in the suit?
Evidence
I will directed to dispose of the suit within 6 months. Otherwise, if I confirm that, then even you can't seek for possession.
Document was given by them in the trial court.
It is not part of the
NIM document, sir.
Yes.
Nandu copy.
What is this documents?
Lords, may kindly come to page 8, my lord. The page number is at bottom of the page. Page 8.
Yes. ಏನ್ ಹೇಳಿ?
Lords, may kindly say the first line. ಮಾರಾಟವಾದ ವಿಸ್ತೀರ್ಣದಷ್ಟೇ ಇದೆ. ಈ ಪ್ರಕರಣವೇ ಈ ಪ್ರಕಾರದ ಛಾಯಾಪತ್ರ ಹಕ್ಕು ಬದಲಾವಣೆ ಆಗಿರುತ್ತದೆ. ಪಾರ್ಟಿಗಳು ಹೇಳುವಂತೆ ಕರಾರುಕೇರಿ ವ್ಯವಹಾರ ಆಗಿದೆ ಎಂಬ ಬಗ್ಗೆ ಪುರಸ್ಕರಿಸುವ ದಾಖಲೆಗಳು ಜಿಲ್ಲಾಧಿಕಾರಿಗಳು ಕೂಡ 8 ಎಕರೆ 28 ಗುಂಟೆ ವಿಸ್ತೀರ್ಣವನ್ನು ಜಮೀನನ್ನು ವ್ಯವಸಾಯೇತರ ಉದ್ದೇಶಕ್ಕಾಗಿ ದಿನಾಂಕ ತಾರೀಕು ಸೋ ಮತ್ತು ಸೋ ಆದೇಶದಲ್ಲಿ ಭೂ ಪರಿವರ್ತನೆ ಆದೇಶ ನೀಡಿದ್ದಾರೆ. ಈ ಹಂತದವರೆಗೂ ವಾದಿ ಪ್ರತಿವಾದಿಗಳು ಯಾವುದೇ ಭಿನ್ನಾಭಿಪ್ರಾಯಗಳು ಕಂಡು ಬಂದಿರುವುದಿಲ್ಲ. ಸರ್ವೆ ನಂಬರ್ 51ರಲ್ಲಿ ಮಾರಾಟವಾದ 8 ಎಕರೆ 28 ಗುಂಟೆ ಜಮೀನು ಸರ್ವೆ ಇಲಾಖೆಯು ಸೋ ಪ್ರಕಾರ ಮಾಡಿದ ನಂತರ ಸರ್ವೆ ನಂಬರ್ 51/5 ಎಂದು ವಿಭಾಗಿಸಿ 16 ಗುಂಟೆ ಪ್ರತ್ಯೇಕ ಇಟ್ಟಾಗ ವಿವಾದ ಸೃಷ್ಟಿಯಾಗಿದ್ದು ಮೇಲ್ನೋಟಕ್ಕೆ ಕಂಡುಬರುತ್ತದೆ. 3 ಮತ್ತು 4ನೇ ಪ್ರತಿವಾದಿ ಕಡೆ ಹೆಸರು ಈ ವಿವಾದಿತ ಸರ್ವೆ ನಂಬರ್ 51/5ರಲ್ಲಿ 16 ಗುಂಟೆಗೆ ಹೇಗೆ ಸೇರಲ್ಪಟ್ಟಿತ್ತು, ಯಾವ ಆದೇಶದಂತೆ ಎಂಬ ಬಗ್ಗೆ ಪುರಾವೆಗಳಿಲ್ಲ. ಪ್ರತಿವಾದಿ 3 ಮತ್ತು 4ರಲ್ಲಿ ಮೇಲ್ಮನವಿಗರಾಗಲಿ 51ರಲ್ಲಿ ಖರೀದಿಸಿದ್ದು ಒಟ್ಟು 8 ಎಕರೆ 28 ಎಕರೆ ಮಾತ್ರ. ಪ್ರತಿವಾದಿಗಳು ತಾನೇ ಖರೀದಿಸಿದ ಪೂರ್ಣ ವಿಸ್ತೀರ್ಣ ಮಾರಾಟ ಮಾಡಿದ ಮೇಲೆ ಅವರ ಬಳಿ 16 ಗುಂಟೆ ಹೇಗೆ ಉಳಿಯುವುದು ಸಾಧ್ಯ ಎಂಬುದನ್ನು ಗಮನಿಸಬೇಕಾಗುತ್ತದೆ. Their claim is 16 guntas. This order, there's no order which is set aside this observation, because ಅವ್ರಿಗೆ ಏನು ಕ್ಲೇಮ್ ಇಲ್ದಾನೆ, just because there is one suit, my property is being interrupted.
Yes.
All I am requesting is that
Now what is the stage? It is in
Evidence ಇದೆ, evidence ಇದೆ.
Indian ನಿಮ್ದು ಒಂದೇ ಎವಿಡೆನ್ಸ್, ಅವ್ರದ್ದು ಅಷ್ಟೇ ಸಿಂಗಲ್ ಎವಿಡೆನ್ಸ್. Let them complete that. Now see, this order is passed
22.
When the suit is 2022,
Please.
you have no interim order in your favor.
difficulty, my construction is being interrupted.
Now that I can't interfere, Mr. If you want, I will confirm it and yes. Or I will modify it to maintain status quo till next date of disposal.
Pass or I'll just seek instruction for 2 minutes.
No, you need not. I will pass an order on merit and confirm that.
The whole point is they don't have any claim.
No, I will consider that. I will consider and pass an order. Yes. Sorry. This petition is filed by
there is some certain change of circumstances, my lords, after the order was passed. I may be permitted to approach the trial court with a fresh application, my lords. I'll adjudicate it again.
No, why you want to delay your suit, mister? Get it disposed of early. ನೀವು ಒಂದು ಆಗ್ತಿರೋ ಅಪ್ಲಿಕೇಶನ್ ಅಂತ ಇಟ್ಕೊಳ್ಳಿ, ನಿಮ್ ಫೇವರ್ ಆಗಿ ಆರ್ಡರ್ ಆಯ್ತು, ಅವ್ರು ಬರ್ತಾರ ಮೇಲೆ ಮತ್ ಸ್ಟೇ ಆಗುತ್ತೆ. ನಿಮ್ ಸೂಟು ನೀವು ಒಂದೇ ಎವಿಡೆನ್ಸ್ ಮಾಡಿ ಮುಗಿಸಿ, ಅವ್ರದ್ದೊಂದು ಎವಿಡೆನ್ಸ್ ಕ್ಲೋಸ್ ಮಾಡಿಸಿ. ದಟ್ ಈಸ್ ದ ಬೆಟರ್. ಇಟ್ ಈಸ್ ಎನ್ ಬೇರ್ ಇಂಜಂಕ್ಷನ್ ಸೂಟ್, ಮಿಸ್ಟರ್. ಇದ್ರಲ್ಲಿ ಏನು ಎವಿಡೆನ್ಸ್ ಮಾಡ್ಬೇಕಂತ ಏನಿಲ್ಲ. ಎಸ್, this petition is filed by plaintiff challenging order dated
24
24/5/2023 passed by Second Additional Senior Civil Judge JMFC Shimoga in MEA number 42 of 2022, whereby order dated
29 September 22.
29/9/2022 passed by Principal Civil Judge JMFC Shimoga on IA number 1 of 2022 has been confirmed. Plaintiff has filed a suit for bare injunction. Along with that plaintiff, he has filed an application under Order 39 Rule 1 and 2. On service of summons, defendant has filed a written statement. Trial court, after considering that submission of both the parties, has dismissed that IA number 1 of 2022 filed by the plaintiff under Order 39 Rule 1 and 2 in OS number 363 of 2022. Being agreed by the same, plaintiff has filed an appeal before Second Additional Senior Civil Judge JMFC Shimoga in MA number 42 of 2022. The first appellate court has confirmed that order. Being agreed by the same, the plaintiff is before this court. Both the court has considered that material produced by the documents has given a concurrent finding and passed the impugn order. Both the parties are claiming regarding the possession of the property.
They are not disputing the binding possession.
Yes, inter-alia. But they have passed a concurrent order. Since the suit is set down for evidence, under these circumstances, in the interest of justice, this court can modify that order passed by the first appellate court, and parties may be directed to maintain status quo till the disposal of the suit. Accordingly, the petition is allowed in part. Order dated so and so passed by first appellate court is modified to the extent that parties are directed to maintain status quo till the disposal of the suit. The parties are directed to be, the trial court is directed to dispose of the suit as expeditiously as possible, not later than 6 months from date of receipt of the copy of this order. Parties are directed to cooperate for early disposal.
The court may not be influenced over the observation.
Yes, it is made clear that trial court has to dispose of the suit within 6 months without influencing any observation made by both the courts. Notification ಪಾಸ್ ಆಗಿದ್ರಿಂದ ಅವ್ರಿಗೆ ಹೇಳ್ಬಿಡಿ ಅಲ್ಲಿ ಪೋಸ್ಟ್ ಮಾಡಿ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಲೀಸ್ ದಿಸ್ ಮ್ಯಾಟರ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಂತ ಅವ್ರು ಪೋಸ್ಟ್ ಮಾಡ್ಕೊಳ್ಳಿ. ಅವ್ರು ಏನಂತ ನೋಟಿಫಿಕೇಶನ್ ಇದೆ, ಮಾಡಿಫಿಕೇಶನ್ ಇದೆ ಅಲ್ಲೇನ?
Serial number 56, 57 adjourned. Passed over matter. List number 1, serial number 26, T. Sheshagiri Rao for petitioner.
Yes. Yes, none appear. Reach this matter next week.
Serial number 27, Krutika Raghavan.
Reach that matter on Wednesday, next week, Wednesday.
Madam, office objections have been complied with this.
Yes,
morning.
yes.
Your Lordship, this writ petition has been preferred since we haven't been allowed to render our evidence, Your Lordship, in the lower court proceeding.
Yes, you are the plaintiff.
Please,
So
we are the
for-
defendant in the lower court proceeding, Your Lordship.
You are the
Petitioner-
defendant.
Please,
No, you said the plaintiff. Oh, yes, defendant. Yes,
please.
you are the defendant. Suit for
This is a money recovery suit which has been instituted by the respondent, who was an ex-employee of the petitioner company, based on certain alleged unsettled dues.
Now, where is the plaint?
Plaint is at annexure C, Your Lordship.
What is the prayer?
Prayer is to set aside two impugned orders dated 24/7/2024.
Please to judgment and degree directing the defendant to pay that monetary benefit, not set aside. You see that prayer in page 39.
Please.
Read that.
In the plaint, their prayer is for monetary benefit, Your Lordship. Sorry, I was talking about the prayer in our petition.
Now that first I want to know that why the suit has been filed, for what purpose?
Your Lordship, it was on unsettled dues that have been alleged by the respondent.
Respondent.
Please.
No, that you are the defendant. They have filed a suit for recovery of money
Please, Your Lordship.
for 15 lakhs. Is it?
Please.
What is the purpose, madam?
Your Lordship, two of our Order 3 Rule 2 applications were dismissed by the trial court.
No. Why that 2 lakhs, the 15 lakhs they are claiming? On what, madam? Why they have paid to you?
Your Lordship, they claim that there is a net TDS that is due from the petitioner company. All termination dues that haven't been paid by the petitioner company is claimed by the.
Now that, what is that application you have challenging that which order?
Both applications that we have filed are under the same provision, Your Lordship. Order 3, Rule 2, requesting a substitution of the authorized representative. The first application was filed.
Defendant had filed an application under Order 3, Rule 2, permitted to substitute the recognized agent representing the defendant company. So and so, signatory so and so. Your application for, yes, that has been rejected.
Please.
Why?
Your Lordship, it has been rejected on a non-technical ground, Your Lordship. They mentioned in the first application, they mentioned that it was rejected since we hadn't.
No, you read from page 27. Defendant counsel filed a present application. From there you read that.
The defendant counsel filed an application under Order 3, Rule 2 of the CBC for substitution of the authorized.
Yes, next para, yes.
The defendant counsel filed the present application along with the certified true copy of the minutes of the meeting of the Administrative Committee of the Board of Satchmo Holdings Limited, and submitted that Mr. Ramanujam MN was appointed as authorized representative of the company to represent all matters on behalf of this company. Your Lordship, on the second para in page 28,
yes,
they mentioned that while perusing the case file was filed by Sanjay Kumar Das against Messrs. Nitesh Estates Limited, and the present application is filed by the defendant representing Satchmo Holdings Limited, Your Lordship. We want to submit that both entities are the same. Since the suit was instituted in 2016, the entity has undergone name change since then, Your Lordship.
that you have to file an amendment to change that name of that entity first. Then you have to go for a representative.
Please.
See, as long as the plaint is there, in the plaint it will show that Messrs. Nitesh Estate Limited. But if it is changed to that other name, first you have to file an application and get it changed. Then you have to seek for that.
Please. All further pleadings, however, have been under Messrs. Nitesh Estates Limited, presently known as Satchmo Holdings, Your Lordship. So there is no inconsistency in the pleadings, in the cause title of the
Now
pleadings.
you are saying that so and so is representing not Nitesh Estate Company.
We haven't mentioned that he's representing.
These are all the technicalities. It should be followed in the rules, madam. It is not that casual way you can do it. Tomorrow they can say that this is not the company which I am work.
Please.
Unless you take a permission of the court, after court verifying that, yes, this has been changed this name. If it is permitted, after hearing other side, then you can seek for a representation. Otherwise, anybody can come and say that I am representing. That is the reason why rejected. You read that further.
The cause title of the case and cause title in the written statement has not been changed, and there is no application filed by the
Correct.
parties.
Same ground.
Please.
Yes. Defendant name has been changed. When there is no such application filed for defendant or plaintiff along with the document in support, this court cannot entertain that present application. What is to the application stranger to that case? Yes, correct. Perusing the case stated so on to recovery of the money suit held so and so. Yes, you first file an application for amendment.
Your Lordship, the trial court matter at this point has been reserved for judgment, Your Lordship.
We can't help, madam. Yes, somebody has represented. Now, what is the difficulties?
If Your Lordship, we're left remediless unless we're allowed to tender our evidence, Your Lordship. If another application under Order 3 Rule 2 may be considered by the trial court, we'll be able to file the application to justify our name change and to tender evidence at the earliest.
No, see, first you have filed it in the name of Nitesh Estate Limited.
Please.
Nobody is represented.
At that point, evidence wasn't tendered, Your Lordship.
No, why?
Your Lordship,
Maybe name
unfortunately,
changed, but your representative can be done it now.
Your Lordship,
This is-
both authorized
this is
represent,
One of the method to drag that matter.
Your Lordship, not at all. If
Now that these are all that method to drag when there is a suit for recovery of the money. Now this is not an ordinary companies. These are all the big companies. They know
Yes.
they knows how to, try this thing. Yes,
Your
sir.
Lordship, if I may,
Now
please-
that they are saying that fag end of the time we have changed that name, therefore permission. This and all. No, madam.
Your Lordship, if I may be allowed to make one last submission.
Yes, yes.
The only reason we filed 2 applications for the authorized representatives to be substituted was that was owing to the ill health of the authorized representatives on record, Your Lordship.
No, that we can do, file an application representing the Nitesh estate, so and so, because earlier is not well, one thing. Or you have to get it first name changed, then you have to seek for an application. But this application is concerned without changing. Now we want to represent which company?
Satchmo Holdings, Your Lordship.
Satamo
Please.
Holding Limited. This is not the plaintiff before the court. How can they permit that representative?
They are the same entity, however, Your
It's
Lordship.
for your official work, you can do it. In the court, unless you file an application and get it,
Please, please.
that cannot be, madam. Yes, even father and son also, that if you want to come on record, he has to get it by court proceedings. You can't do it. Yes, nothing wrong in that order. Thirdly,
Yes.
this petition is filed by defendant challenging that order dated (24/7/2024). Why you are asking 2 orders?
Your Lordship, because if I may be allowed to point out just one sentence from the impugned order on page 28, Your Lordship. They had mentioned that we'll be given the liberty to file another app. Your Lordship, the last but 4th line on page 28. If the defendant intends to substitute Ramanujam MN in the place of KB Swami, then they are at liberty to file fresh application with genuine original documents that are complete. This is in reference with a board resolution.
Pursuing the case, suit is filed by recovery of money and the suit is held from suit is ported for argument at main suit. At this stage, defendant has filed an application. It's pertinent to note that defendant already filed a similar application which was already dismissed by this court, which shows that defendants are protract. Madam, this is not first time.
Your Lordship.
Now you are allowed me to read second para, then it's give some more this thing.
Your Lordship, in the previous impugned order, they have mentioned that we'll be given the liberty to file an application again under Order 3 Rule 2, Your Lordship.
Where?
Which on page 20.
Page?
20. Last but 4th line. If the defendant intends to substitute Ramanujam MN in the place of Shri KB Swami, then they are at liberty to file fresh application along with genuine and complete documents.
No, that
This is Annexure A, page 20.
what is this order? Both order you are challenging.
Under the same provision, Your Lordship, please.
First order is this 26/7.
24/7,
24/7.
please.
Which page number?
20, Annexure A,
Page number 20.
please.
There they have permitted you to
File another application under the same
solution
provision.
used by the defendant to prove the fact that Ramanjan was appointed an authorized attorney of the defendant company in the so and so. No, earlier you have not stated that the Ramanjan has been represented by new company. You said he has to be represented by Nitesh only.
Your Lordship, which is why we filed a board resolution along with the second application that we filed. Since we were directed to
No, madam.
enclose the original documents.
See, first You have filed that Ramanjan has to be represented by Nitesh company or this thing?
Satchmo Holdings, Your Lordship.
Yes, new company.
Please.
You read that page 20,
From para 3, Your Lordship.
when you have that application filed in that earlier.
We have
Where is that application in that first time you have filed it?
annexure E, Your Lordship, page 77.
77.
Hmm.
Ramanjanan is representing Stacham company.
Please.
Where is that? 88.
That's part of the second application, Your Lordship.
No, first application,
Page 77.
77.
Along with that, we hadn't enclosed the board resolution and it was only a
We'll see that first. What is that prayer you have? For the reason accompanying affidavit, defendant humbly place this on record, please to permit that substitute that recognize the agent representing defendant company Nitesh Estate Limited known as.
అదే రీఫండ్ ఆర్డర్ అయిపోయిందండి సార్ ఇప్పుడు బ్యాంక్ పంపిస్తారంట
So and so.
ఇప్పుడు ఎండ్ ఆఫ్ డే
As authorized so and so. Now, what is that second application?
second application is annexure F, Your Lordship. That's on page 80.
Please to permit that substitute recognized representing Nitesh company known as Satcham Holding Limited. Swami so and so. Similar application.
Please.
Now that where is the first order? What is that liberty is given?
First order is at annexure A on page 20.
When there is no such resolution is produced, the defendant to prove the fact that so and so was an appointed and authorized company that so and so. We relied upon the incomplete Xerox copy without reflecting such part of the document. This cannot be believed that income tax Xerox copy. To the Ramanjanan in place of Swami, then their liberty to file a fresh application. Original complaint documents negative. When this order has been passed?
The first impugned order, Your Lordship.
Yes.
24/7/2024.
Same officer, second time.
Same officer, second time.
Yes. Now you come to the second order. Second order, he has given some different reason.
The second order's reason,
Case filed by the Sanjay Kumar Das against the Nitesh Kumar Limited, filed in defense so and so. His cost title of the case and that earlier he has not taken this contention that cost title is not.
please.
Now he has taken that.
But our
that is-
applications are identical, Your Lordship.
No, identical. But fact is, unless you amend that cost title, you can't be permitted. But earlier occasion, court has not mentioned regarding that amendment.
Please.
They said you have to produce the board resolution. Now they are saying that cost title is not amended. That is required, madam.
Your Lordship, we'll do the needful if we're able to.
No, you can file in a
Recall
fresh, I will permit it to file in a fresh application first. Get it amend that cost title and then you file an application for.
At this point, we're not allowed to do that because it's reserved for judgment, Your Lordship.
Defendant filed an application pertaining to note that defendant has already filed a similar application. No such application is filed defendant by plaintiff along with the document in support of this court. No, now also you have not produced any document.
Your Lordship, we've produced the original executed
There
board
is no
resolution along with the
application filed by
second
the parties
application.
to state that defendant name has been changed. And there is no such application filed by that. Now they are taking in a different ground. You have not changed that name of the company. See, there may be an earlier court has dismissed. Court may not be mentioned that you have to change the name.
Yes.
But law is that, but court has not mentioned, you can't say that, I can't change that,
Understand, Your
that
Lordship.
benefit can be given.
I understand.
You can't do that, madam.
Your
Without
Lordship, if
changing
we
that
may be
name of-
given the room to immediately file that application and bring this
Now, it
information
is
before the
posted
trial.
for what?
Judgment
When?
reserved on 19/2, Your Lordship.
No, that can be reopened again, that you have to be given a evidence and all. Can it be permitted at this stage? No, see, who is representing before this? You are the counsel who is appearing before the trial court.
I have been appearing before the trial court. I have been appearing before the trial court along with my colleagues, Your Lordship.
No, madam, it is minimum requirement that when company name is changed, in the
Yes.
cost title, it has to be get it changed, madam.
Your Lordship,
Otherwise, that company is different.
I fully understand, Your Lordship.
Now,
There
that
was-
is the law. Now your understanding is not the concern here.
No, please. We were only focusing on getting a new authorized representative on
The
record.
court also committed a mistake in that earlier round. They have not mentioned that cost title list has to be amended. They said you produce that resolution with a new application. You have also done same thing. Now
Yes.
court has taken a different point saying that cost title is not amended.
We only focused on filing the applications under Order 3, Rule 2, because we were in a hurry to tender our evidence for this matter, Your Lordship.
No, then why you have not tendered evidence?
Your Lordship, unfortunately, both authorized representatives that we were to propose and the one that was already on record had severe ill health and health complications. One of the authorized representatives also has terminated his employment tenure.
Yes. Or issue notice. Stay of further proceedings in OS number 2948 of 2016. Pending in the file of which court, madam?
Your Lordship, Principal City Civil and Sessions Judge, CCH 5.
Pending in the file of Principal City Civil and Session Judge. Now, why you have challenged both order?
Your Lordships, since there
Need not be, madam. Yes. Till next date of hearing. You are doing trial and error before the High Court. Yes.
apologies, Your Lordship.
You also take hand summons to that party.
Please.
In addition, petitioner is permitted to take out hand summons to the respondent. Office objection again. Yes.
Deeply
The head
request.
counsel for the petitioner submits that office objection is complete. Office to verify and proceed further.
One mention, my lords, I'm sorry, the previous matter.
Sir, it's not done in transit.
Yes. Yes, Mr.
Previous matter which was
Obliged.
passed over matter, my lords. Those I.
No, passed over we are taking now.
Yes, but my matter, my lords, the moment I appeared, I think it got urgent. The urgency, there was a bit of an urgency, my lords, because I am running a school.
Pass over, madam. Yes, we'll pass it over. We'll
26, yes, my lords.
we'll pass it.
Serial number 29.
No, see, my
Parmeshwara
court
Appa-
is like in a train. If you miss that ticket, you will not get it, mister. Because so many matters are pending. I can give 1 or 2 times chance, otherwise nothing. You have to be wait for that next time. Yes.
Serial number 29, Parmeshwara Appa MD.
Office objection complaint, my lord.
Yes.
It's regarding chit transaction, my lord. Petitioner is the guarantor. Is working as a teacher, assistant teacher. He retired from service from next month, my lord.
Now, what is the suit for?
Suit for chit transaction is taken the award from the arbitrator. Thereafter filed a execution petition. In the execution petition is filed an application under 21 Rule 58. Attachment of salary, my lord.
Oh, what is wrong in that? There is
Is-
a degree you have not paid. They have
He is paid the after award pass, he is paid the 2 lakhs. As per the statement, my lord.
what is that award amount?
Award amount 3 lakh, that, my lord.
3,29,420.
Is paid 2 lakhs.
When?
Is after award passed, it, my lord.
When? Show me the documents.
2010-2020, my lord.
2010.
10-2020.
What is that document to show that you have paid it?
That is statement is there, my lord.
Here statement. See, have you given through the check?
Through collected by the agent, my lord.
What agent?
Chit transaction agents.
Yenido.
2 lakhs is collected, is ready to close the account.
Eli the 2 lakhs.
1,50,000 and 50,000 is 2010-2021.
Award agirade yavattu?
24-2020, my lord. April ಅಲ್ಲಿ award ಆಗಿದೆ. October ಅಲ್ಲಿ payment ಆಗಿದೆ.
ಆಯ್ತ್ರಿ, ಇವೆಲ್ಲ ಕೊಡ್ಬೇಕಾದ್ರೆ ಏನಾರ ಬರ್ಸ್ಕೊಂಡು ಕೊಡ್ಬೇಕು. ನೀವು ಅವ್ರು ಅದನ್ನೇ ಕಾಯ್ತಾ ಇರ್ತಾರೆ. If you are giving that you say that this is not related to this account.
ಅಲ್ಲ.
Then how will you defend it?
ಇಲ್ಲ, he is an employee.
ಈಗ ಬ್ಯಾಲೆನ್ಸ್ ಎಷ್ಟಿದೆ?
Is government employee.
No, 3 lakhs ಅಲ್ಲಿ ಎಷ್ಟು ಕಟ್ಟಿದ್ದೀರಾ ನೀವೀಗ?
2 lakhs is paid, my lord.
2 lakhs. In 1,29,000.
He is an guarantor, my lord.
You can't do anything. You won't recover from that borrower.
Salary attachment next month retired ಆಗ್ತಾ ಇದೆ.
ಮತ್ತೆ you deposit 1,29,000.
ಇಲ್ಲ 3 ಜನ ಮೇಲೆ ಆಗಿದೆ salary attachment. R2 is already dead. Against that person is also our past then.
ಅದು ಅವ್ರಿಗೆ ಬಿಟ್ಟಿರೋದು. ನಿಮ್ದ್ರಲ್ಲಿ if you deposit 50,000 rupees. Yes, heard. Issue notice. Stay off. ಏನ್ ಅಟ್ಯಾಚ್ಮೆಂಟ್ ಆರ್ಡರ್ ಆಗಿದೆ?
Salary attachment 1/3 of salary ಅಂತ.
Yes. Stay off order dated. What is the date of the order? 16/1/2025. In execution case number 102 of 2017 by 4th additional civil judge JMFC na?
JMFC.
Civil judge JMFC only in respect of the petitioner is concerned subject to condition. Petitioner has to deposit 50,000 rupees before executing court on or before 20th of February. Yes.
20th. Kindly hand delivery. So file the memo for dispensation R2 to 4 million. Notice.
Who are that? ನಿಮ್ಮ ಡಿಗ್ರಿ ಹೋಲ್ಡರ್ ಯಾರು?
Degree holder R1 million.
Dispense notice to 2 to
4.
4. Emergent notice to R1. Yes. Office objection submitted, complaint office to verify.
Serial number 32, Omkara N.
Appeal for the petitions matter, my lords. My lords, this writ petition arises out of suit for mandatory injunction, my lords. My lords, petitioners own a land of 2 acres, 4 guntas. My lords, the defendants in the suit are obstructing. My lords, petitioners approached civil court seeking for directing the defendants to remove all or whatever obstruction caused to the suit road and for the relief of permanent injunction.
Suit for
Mandatory injunction.
mandatory injunction.
Please.
You have filed an application for
Striking off the issues, my lords.
why?
My lords,
You are the defendant.
I'm the plaintiff there.
You want to seek for a striking of that. Why?
Please, my lord, there are 2 propositions. First one is already in a matter which was material between the parties, which has been decided previously, that has not, which was entered in compromise, and they permitted us to use the road since the year 2011. They go back in with it. And my lord's learned civil judge commits an error saying that that may not be considered at this point of time.
No,
But-
that where is your application?
My lords, my application,
Striking out that issue number, striking out the issues you are seeking.
issues 1, 2, 3.
Why? What are the issues?
Issues are there, my lords. My lords would find page 52. May I read, my lords?
Wait. Yes.
My lords, issue number is whether plaintiff proves that there exists a road leading to the suit A scheduled property from the Puttige Panchayat so and so, which passes over the property survey number 2/4, 2/1C, 2/1B2, 2/1B1 in Puttige village towards east to west, and it thereafter runs in 167/2C of Puttige village towards south,
there
along
is
with that
no
so and so,
other
a plot number so and so,
Now,
and
what is
ultimately,
this your prior in the plaint?
my lords,
Prior in the plaint.
plaint. My lords would find it on page number 34 onwards, my lords, 35.
54.
35, page 35 minutes.
35.
My plaint starts from page 30.
35. Yes.
My lords, prior to that, my lords, I may be permitted to pass on
Now you
the
see
sketch so that I may be able to assist my lordships better.
No, you show me that prior, Mr.
Prayer is that, my lords, paragraph 6A for the mandatory injunction directing the
Page
defendants.
number
35, my lords.
34.
My plaint starts at 30, my lords, page number 30.
Yes, 6. The relief. July 3.
For a mandatory injunction directing the defendants to remove the 2 gates erected across the.
Which, Mr. Page 34.
Please, my lord.
Para 9.
My lords, it comes para 9, please, my lords, para 9, and subsequently the numbering error is there, which is rectified.
ನಾವು ಪ್ಯಾರಾ 9 ಆದ್ಮೇಲೆ
Continuation, my lords, next page.
ನಾವು ಪ್ಯಾರಾ 9 ಆದ್ಮೇಲೆ ಇದೇ ನಂಬರ್ 4 ಬಂದಿದೆ. ವಾಟ್ ಇಸ್ ದಟ್ ಮಿಸ್ಟರ್?
4, Roman 4, Roman 5, Roman 6, my lords.
Roman 4, Roman 5, Roman 6.
That is the main heading of my lords. My lords, if you would see page 31, first paragraph, Roman number 1, second paragraph, Roman number 2, third paragraph, Roman number.
ಆಯ್ತ್ರಿ 5, 6, 7, 8, 9 ಆಯ್ತು.
My lords.
9 ಆದ್ಮೇಲೆ Roman 4 ಯಾಕೆ ಬಂತಲ್ಲಿ?
Because my lords, on page 31, the Roman number paragraph 1 is my cause title. Roman 2 is the names address of other.
Roman 4 is the cause of action.
Please.
5 is the?
5 is the valuation. 6 is my prayer.
6 L ಬಂತು.
Continuation, following that. That
Plaintiff
blocks, it is
therefore
in the.
pray
Yes.
judgment and degree against the defendant in terms of following.
For a mandatory injunction directing the defendants to remove the 2 gates erected across the suit road and to remove all and whatever the obstruction caused to the suit road within the time to be fixed by the court. Lords,
No, is it not required for that issue?
It is not required,
No,
lords, for 2
issue
reasons.
1 to 3 has been removed. That other 2 issues only remains for bare injunction.
Please, my lord.
No, here you have sought that mandatory injunction directing the defendant to remove the 2 gates. There should not be any issue to prove that whether there was any gate or not.
My lords, may I request my lordships to see para 4 on page 32. My lords, this I may be permitted to pass on the sketch so that I may be able to better assist my lordships. Now,
Mister,
to the land which I own, my lords,
you
to reach there,
no, you
it is easement
sought-
of necessity, my
No,
lord.
you sought for a mandatory injunction to remove the 2 gates.
Remove the 2 gates.
If that would be that prior, if the issues has been framed that whether plaintiff is entitled to the mandatory injunction as prayed for, whether the plaintiff is further entitled for the permanent prohibitory injunction, is it enough?
My lord's existence already stood proved. My lords, my learned civil judge wants to frame this issue for the purpose of existence. My lords, kindly see, my lords, page 4 of my document which I produced before my lordships now. That is the document which compromise entered in the year 2011 between the same parties. My lords, in that page 4, it reads, my lords, I may be permitted to read page 4.
Have they disputed in that written statement?
They say that there is no gate, there is nothing.
Then if that would be
My
the
lords,
case, you should
it
not.
went contrary to the compromise which they entered with me
No,
prior to that.
that has to be decided when deciding the case, mister.
Please, my lords, I may be permitted to read just one
When
point.
they are denied, even though if it is, see, suppose you said that there is an earlier partition, they have denied.
My lords, that denial is not acceptable in the light of section 58 of Evidence Act. My lords, no facts need to be proved when it is admitted, either actual or constructive. My lords, I may be permitted to read page 4 in my document which I produced, which is a compromise petition.
Take out notice, yes.
My lords, kindly be stated, because my lords, now they are continuing. Or the further stage, my lords, further date is fixed. Monday matter is going to be posted
what?
before learned trial court.
For what?
For
Monday?
issues are from now, it will go on to further evidence, my lords.
Where is that order sheet?
I have produced it, my lords.
Heard issue notice.
22nd.
They have further proceedings. It is your suit.
It's my suit, my lords.
There further proceedings in OS number 216 of 17 pending before which court, mister?
Mudubidri, CJ and JMFC, Mudubidri.
Civil judge, JMFC, Mudbidre, till next date of hearing.
My lords, before we part from the discussion, my lords, page 4 of the document which I produced, ಅಲ್ಲಿ one suit ಅಲ್ಲಿ compromise ಆದ್ಮೇಲೆ, in that compromise suit, it is categorically court has
See, issues has been framed on the basis of pleadings of both the parties. If they are denied, then you have to be established. Establishment by evidence and documentary, you show that there is a compromise. Therefore, then court will give a finding.
But by the virtue of constructive admission, my lords, they are not supposed to raise the contention itself is, my lords, so there's a finding that which
Yes,
was supposed.
yes, we'll see.
Grateful,
You
grateful.
get it stayed, your ಮಾಡಿದ್ರಾ? Yes, of subjection office to verify.
Serial number 36, Mahendra N.
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ನನ್ನ ಪಾರ್ಟಿ ಇಲ್ಲ ಅನ್ನೋದು ಒಂದು ಅಬ್ಜೆಕ್ಷನ್.
Petitioners not a party before the court below to be clarified.
This property was sold in the year 2004 by converting the property agriculture to non-agriculture. After that, our name is entered in the panchayat. By taking advantage of the revenue record, RTC, they filed the suit on 12/3/2024. Very 3 days. 16/3/2024 in the before the Lok Adalat, they have entered into a compromise.
Where is that?
I have ink page number 105 order sheet. One not six is a sheet. Heard issue suit summons to
No, suit for what?
suit for
partition.
partition filed by the respondent 1 to 3.
No, Shantamma has filed the suit against whom?
Their brothers.
Brothers. Who are you?
My lord, our Putmadaya and his brothers have sold the property to me,
You are the purchaser.
purchaser.
When they have sold?
2004. I have produced the sale deeds.
2004.
2004. Before sale, they have converted the agriculture to non-agriculture because it is a trust. They converted, and after the converted, they have sold the property, have produced the sale deeds.
Then they have.
They have not challenged the sale deeds. Even in the compromise, respondents are also party to the sale deeds also. ಅದೇನು ಡಿಸ್ಕ್ಲೋಸ್ ಮಾಡಿಲ್ಲ. ಲೋಕ್ ಅದಾಲತಲ್ಲಿ ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡ್ಕೊಂಡಿದ್ದೀವಿ.
ಎಲ್ಲಿದೆ ಲೋಕ್ ಅದಾಲತ್ ಆರ್ಡರ್?
My lord, page number 107 ಇಂದ ಶುರು ಆಗುತ್ತೆ. 106 ಅಲ್ಲಿ
compromise petition as a lawful same is accepted and suit disposed of in terms of the compromise.
ಈವನ್ ಲೋಕ್ ಅದಾಲತಲ್ಲೂ 6 to 17 ಹಾಕೊಂಡು ಕನ್ವರ್ಷನ್ ಆಡ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ. ಈ ಡಿಗ್ರಿ ತಗೊಂಡು ಈಗ ಪಾಣಿಯಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡಿಸ್ಕೊಂಡು ಈಗ ಬೇರೆಯವ್ರಿಗೆ ಮಾರಾಟ ಮಾಡಬೇಕು.
Where is the plaint?
Plaint. My lord, 85.
ನೀವು ಪರ್ಚೇಸ್ ಮಾಡಿರೋ ಪ್ರಾಪರ್ಟಿ ಯಾವುದು?
ಎಲ್ಲ ಪ್ರಾಪರ್ಟಿ ಹಾಕೊಂಡಿರೋದೇ ಪರ್ಚೇಸ್ ಮಾಡಿರೋ ಪ್ರಾಪರ್ಟಿಗೆ ಮಾತ್ರನೇ.
ಅದಕ್ಕೆ ದಾಖಲೆ ಮಾಡ್ಕೊಂಡಾರ?
ಹೌದು ಸ್ವಾಮಿ.
All property you have purchased?
Yes, yes, my lord.
Heard. Issue notice. The respondents are directed not to create third-party interest in respect of petition scheduled property till next date of hearing.
Much obliged.
ಏನಿದೆ ಅದೇನ್ ಬೇಡ. Submission is accepted, office objection is overruled.
Much obliged.
Serial number 41. Dhananjay Kumar.
I've paid the deficit process fee, my lord.
Yes,
Other objections, I will comply by Tuesday, my lord.
complaint.
Will comply, my lord.
Yes, at the request, week's time is granted to do the needful. Interim order granted earlier is extended till next date of hearing. First order, ಅದೊಂದು ಕರೀರಿ ಇನ್ನೊಂದಿತ್ತು.
Second time passed over matter. Serial number 26. T. Sheshagiri Rao.
But the petitioner institution may not runs a school. It's called National Public School, not it's.
Office objection is compliant.
Yes, please. Yes, please. The dispensation application has also been filed.
ಏನು office objection ಏನು? Registration certificate of the petitioner to
Yes,
be
Mr.
filed.
Sir. It's been filed. All that has been, all that has been taken.
Nature of R1, R2 are to be stated in the cast title. There are details to be stated correctly. at-
All the ones which were raised in the morning, they have been compliant. Now,
Nature of the respondent number 1 to 4, what is that?
they are media channels, Minots. Now, Minots may kindly turn over to 56. This is how Minots, Minots news is being broadcasted. The photos at 56 for me. Sarkari Jagdali Kaski Shah. Laksha Hana Luti. This is the time, Minots, because admissions are going on. Now, Minots, Yelanka Chikbetalli, survey number so and so. Yedekre Jagavanu Rungida so and so.
No,
Then,
what is the suit for?
Minots, it's a suit saying that please do not broadcast these defamatory messages because it's my admissions are going on. Minots, kindly see Minots, at 56, what they are doing, Minots, is Poshakare Hushar. Illi nim makkalna serisbedi. 58, your lordship will see.
No, that where is the plaint?
Your lordship will find the plaint at page 22 minutes, 22. Now minutes, it's a suit for injunction. Lordship, your lordship will see annexure C. This relief has been granted by the court already.
Now, you first show the plaint.
Minutes. Plaint is at 22. Your lordship may come down to the prayer at 26.
Twenty-six.
26.
Yes. Judge decree forfeiture prohibiting the injunction against the defendant, restraining the defendant, their representatives, respond agent, henchman, associated man, anyone coming through under them, may not carry out printing, publishing, telecasting website, so on, so. So on, so.
Now, minutes, IA number 1 is allowed.
What is your IA number 1?
Minutes, IA number 1, please do not broadcast such defamatory material.
Where is that IA number?
Minutes, 26 minutes for 1 month. Your lordships can come down to, I'm sorry, 30 minutes.
30 is that
First
application-
IA.
application.
Yes, ma'am.
Yes,
Minutes, this is allowed.
yes,
This has been granted.
granted.
This has been granted. The main prayer has been granted. Now, what happens, minutes, is these are all digital news channels. They don't have a satellite license on their own. Minutes, they broadcast this news not on minutes the regular TVs, but on minutes the digital media platforms like YouTube, Facebook, or minutes such as Instagram. Minutes, now they are using these two links dedicated only for this news. That link is found at 37. Minutes, whatever your lordship saw in IA number 1, that is the main relief. This is minutes an incidental relief because broadcasting, the court has said, don't do. Broadcasting is done on these channels. This is a practical difficulty. If there is a satellite license, I can tell a media channel, please, you cannot do this. This minutes is hosted on YouTube Live. And this is, we have requested the court. These are the links which will have to be locked down because this is where the broadcasting is happening. The court says, let them not broadcast, they are debarred from broadcasting. But unless this link is brought down or taken down, the broadcasting will not stop.
Now,
Because
how
yes.
can you take down that link?
That is why the host is made as different number 5 there. Your lordship will see in page 37. The host provided is YouTube. So unless there is a direction to YouTube so the direction there is to the respondent number 1 and 2, who are the news channels, you cannot broadcast it. Now they will come up with a look, I have already web hosted it. It is not in my hands. So this is a comprehensive direction telling all these people, please disable these links because there's already an order that the broadcast cannot be done. So this is the link, this is the direction what the IA number 2 sought for. And the court said, we'll hear to them because now the relief in IA number 1 is already granted. It cannot be broadcasted. But until IA number 2 is granted, IA number 1 will not take effect.
YouTube is also a party in the plaint.
Yes.
They are the parties.
Yes, because it is not their fault. It is not their fault, but they are a service provider. They are a service provider. They are defendant number 5. In page 37 itself, in the IA itself, your lordship will see.
No, is it possible for them to remove that link?
They will only disable it.
It can be done by them.
They do it. In
what is that order passed by the trial court?
The order passed by the trial court said 19.
Page
19, annexure. I'll read the order. Orders on IA number 1 and 2. Peruse the plain governments, contents of IA number 1 and 2. Annexed affidavit and documents produced. Plaintiff filed the suit seeking the decree of perpetual prohibitory injunction against defendant, restraining defendants, the representatives, anchors, newsreaders, correspondent, agent, henchmen, associates, anyone or anyone claiming through or under them from any manner carrying out or airing or printing or publishing or telecasting or web hosting or trolling the plaintiff or issuing any statement against the plaintiff or resorting to any such acts, deeds and things which are aimed to defame or lower and damage the honor, dignity, reputation, respect, reverence and goodwill of the plaintiff. Plaintiff through IA number 1 seeking ad interim ex parte injunction restraining the defendants, their representative, anchors, newsreaders, correspondent, agents, henchmen, associates, anyone claiming through them or under them from in any manner carrying out or airing or printing, publishing, telecasting, web hosting or trolling the plaintiff or issuing any statement against the plaintiff or resorting to any such acts, deeds and things which are aimed to defame or lower and damage the honor, dignity, reputation, respect, reverence, and goodwill of the plaintiff till disposal of the suit. Plaintiff through IA number 2 seeking ad interim, ex parte, temporary injunction against the defendants, directing the defendants to remove the URL links mentioned in IA number 2. At this stage, plaintiff established ground against the defendant as the plain developments and document produced discloses that there is a threat of broadcasting, publishing, and circulating defamatory news against the plaintiff by the defendant. The plaint pleading discloses that plaintiff is a reputed school and imparts quality education to its students. If the defendants continued posting the alleged false and defamatory articles against the plaintiff, then definitely the image of the plaintiff will be damaged. And the balance of convenience also lies in favor of the plaintiff. The document produced on record further discloses that the defendant seems to be chosen social media news channels and paper media for circulating the news against the plaintiff. If the defendant posted or published or circulating any defamatory articles against the plaintiff, the reputation of the plaintiff will be destroyed and irreparable loss will be caused to the plaintiff. Hence, at this juncture, this court feels plaintiff established grounds for granting ad interim ex parte temporary injunction against the defendant. However, plaintiff through IA number 2 is seeking mandatory injunction to remove the URL links. But this court finds that without hearing the defendant, the relief claimed in IA number 2 cannot be granted. Hence, this court proceeds to pass the following order. Notice the order is passed. First, IA number 1 is allowed. Then notice the last line in page 20. So suit summons is issued in IA number 2. Now, effective relief is already granted by the court. The enforcement of the relief which is already granted, would require the host providers, if not remove, disable those links for the moment. They can re-enable if the news channel comes and says, no, this is true news. And I'll also tell what is the controversy. Lease was granted to the school 20 years ago. Consequently, since these are educational institutions, at a rate which was prescribed for in the subsidized format in those years, that was paid, a regular conveyance has been effected. Now, some news channels are come up and they are stating that there has been a collusion between the institution and the deputy commissioner. This is exactly the controversy, nothing else, nothing else. That is the controversy at 56, what your lordships are seeing. Sarkari Jagdali Kasgi Shala. Then 57, Yerdekre Jaminu. Then 58, Poshakare Hushar. Then Makkala Bhavishyanu so and so Madalu, Hortide, so and so school. Then half rate, cheap rate. Your lordship will see at 60. Kayam Manzurati. Kayam Manzurati Vaja Madadidare, Pratibhatane Madu Echarike Nida, Ambedkar Sen, Rajyadyakshuru. Then Sarkari Bokasadali Ilvante Kasu, so and so Kayam Manzurati. Then these are the photos where they are trying to say what we are doing. 64 minutes.
Which is that school?
The name of the school is National Public School, Vidyaranyapura.
No, this why that then society?
The society is the
Society is running the school.
Yes, the name of the school there is National Public School.
Yes.
Now, and your lordship will see the sale is at not today, but at 46. It's not of today, 2021.
Now, what is the next date in the trial court?
It is at 28th March. The problem is by then the admissions are going on. Everybody will now ask, there appears to be some issue with your school.
No, whether this can be done, we don't know that on technical
On technicalities, what happens once there is an order. This will be tendered to the CEN police station, cyber economic nerve. They will in turn instruct the host providers in view of so and so order, the links can be disabled. The links can be disabled, temporarily disabled. If not brought down they can be temporarily disabled. So that till they appear the broadcasting cannot happen.
No, that you have not said that you are a link related to that your case. No, if your interim order is that digital media platform or the petition scheduled your link. Where is that you are scheduled?
The URL links which are described in the prayer column itself.
No, you said petition scheduled URL link. Where is that?
I'm so sorry, my lords, the URL links which are described in the prayer itself. There are only two links on which the broadcasting is happening. What your lordship saw in Annexure D.
No, it should be in that your
I'll incorporate that.
because that interim order which is issued.
Please, my lord, I'll incorporate that.
Suppose that.
I'll incorporate those.
Yes, you incorporate.
I'll incorporate.
Issue notice. Interim order as prayed for. You incorporate that.
Please, my lord, I'll do the need immediately.
In the meantime, the petitioner is directed to comply of his objection.
B group matter. Serial number 58, 59, 60 adjourned, serial number 61. Mohammed Saleha for petitioner. Authorized Baba K.
58 for me.
50?
58, I am the petitioner, my lords. I have not sought for any adjournment.
58. ಅವ್ರೇನಕ್ಕೆ ತಂದ್ರು?
First hour.
ಅವ್ರೇನು ಹೇಳಿದ್ರಲ್ಲ suit. He said I will intimate you ಅಂತ ಹೇಳ್ಬಿಟ್ಟು. Our suit is ಏನಕ್ಕಿದೆ? What is that suit for?
Suit is for recovery, my lords. It's a very short point, my lords.
But he has taken time.
And then information, I'm waiting till almost.
Yeah, he said that
the point is only this much for me. The suit is for recovery. It's an ex parte decree. Execution is filed after 6 years. I file a miscellaneous, it is not heard on merits.
ಯಾವತ್ತಿಗೆ ಹೋಗಿದೆ ಅದು? ಏನಾಯ್ತು?
Next week.
Yes, it will come in that next week.
One date fix about something. 11th
To sign off.
10th ಆಗ್ಬೋದಾ?
You do one thing. Next week ಅಂತ ಅಂದ್ರೆ it has to be come on next 11th or 12th.
10th ಆಗ್ಬೋದಾ sir?
No, 11th or 12th, you move that memo.
Please, my lord.
On that memo, we'll give a date post next week.
Serial number 61.
ಅಕಸ್ಮಾತ್ next week ಅಲ್ಲಿ ಬರ್ಲಿಲ್ಲ ಅಂದ್ರೆ.
ಅಲ್ಲ ತಾವ್ ಡೇಟ್ ಏನಾದ್ರು ಕೊಡ್ಬೋದು?
No, I have already
We've
signed
signed
and
and
sent
signed.
it to that.
Please.
Therefore, otherwise I could have been corrected it.
Please.
Now it is send it to that branch.
Please.
Only thing is that you have to wait till next week of this next Wednesday. If it is not come, you move that matter, we'll have post it on Thursday.
Please.
Serial number 61.
Please, petitioner, my lord.
Yes.
My lord, the order impugned in this petition is, my lord, the report filed by the FSL expert has been accepted by the first appeal court, my lord. My lord, kindly turn to, I will, ಒಂದು ಎರಡು ಇದರಲ್ಲಿ ಮುಗಿಸ್ತೀನಿ ಸ್ವಾಮಿ. Turn to
Suit
page
for?
specific performance, my lord.
You are the plaintiff or a defendant?
Plaintiff, my lord. My lord, kindly turn to.
Now, what is that order you are challenging?
That order accepting the FSL report given by a animal husbandry graduate. That is under challenge, my lord. Kindly turn to page 109 of the 109.
ಏನನ್ನ ಅವರು who is he? How can that animal husbandry director is
He is a forensic expert, my lords. His basic degree is animal
He's a
husbandry.
forensic expert.
Please, my lord.
Yes, my lord. Kindly,
As if he is projecting, you say that how can that be?
Please, my lord.
no, my lord, page 109, my lord.
Yes.
Cross examination of this FSL expert.
Now, which is that order you are challenging?
Order annexure F, my lord.
Read what is that reasoning. Page. Report ಅಲ್ಲಿ ಏನ್ ಹೇಳಿದ್ದಾರೆ?
Report alle
Accepted, my lord. Signature and thumb impression is not belongs to me. That is the defendant, my lord. That is the report.
Till he has to give a report saying that it is his signature, plaintiff will not agree. Till that,
That is the-
it is,
Please,
it
please,
is always there.
please, my lord.
Therefore, that appointing the commissioner, this is the problem.
My lord, my humble submission, one submission, I leave it to your lordship.
Yes.
ಇದೇ ರೀತಿ there are crores together ಅವ್ಯವಹಾರ ನಡೀತಾ ಇದೆ ಸ್ವಾಮಿ. FSL expert, he must be an expert in particular science. ಸುಮ್ನೆ ಅನಿಮಲ್ ಹಸ್ಬೆಂಡ್ರಿ ಮಾಡ್ಕೊಂಡ್ ಬಂದು FSL ರಿಪೋರ್ಟ್ ಕೊಡೋಕ್ ಬರುದಿಲ್ಲ ಸ್ವಾಮಿ.
No, certificate ಇರ್ಬೇಕಲ್ಲ, ಇಲ್ದೇನೆ.
ಏನಿಲ್ಲ ಸ್ವಾಮಿ. kindly,
The certified person, my lord, qualified person in the cross examination, his basic degree was in the animal husbandry.
ನನ್ಗೆ ಹೇಳಕ್ ಬಿಡ್ಲಿ ಸ್ವಾಮಿ ಆಮೇಲೆ ಹೇಳಿ.
Please.
Kindly go through the page 109 mela. The admission before the court is the best admission.
Yes, yes.
My lord, may I read the, my lord? ನಾನು ಪ್ರಾಣಿ ಶಾಸ್ತ್ರ ವಿಭಾಗದಲ್ಲಿ MSc PhD ಪದವಿಯನ್ನು ಪಡೆದಿರುತ್ತೇನೆ. ನಾನು ನ್ಯಾಷನಲ್ ಇನ್ಸ್ಟಿಟ್ಯೂಟ್ ಆಫ್ ಕ್ರಿಮಿನಾಲಜಿ ಅಂಡ್ ಫಾರೆನ್ಸಿಕ್ ಸೈನ್ಸ್ ನವದೆಹಲಿಯಲ್ಲಿ 3 ತಿಂಗಳು ತರಬೇತಿಯನ್ನು ಪಡೆದಿರುತ್ತೇನೆ. ನಾನು ಫಿಂಗರ್ ಪ್ರಿಂಟ್ ವಿಚಾರಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟಂತೆ ಯಾವುದೇ ಪರೀಕ್ಷೆ ನಡೆಸಿ ವರದಿಯನ್ನು ನೀಡಿರುವುದಿಲ್ಲ. ಇವರು ಪರೀಕ್ಷೆನೆ ಮಾಡಿ ವರದಿ ಕೊಟ್ಟಿಲ್ಲ ಅಂದ್ಮೇಲೆ ಹೌ ದಿ ಕೋರ್ಟ್ ಅಕ್ಸೆಪ್ಟ್ ದಟ್ ರಿಪೋರ್ಟ್?
ಫಿಂಗರ್ ಪ್ರಿಂಟ್ ಅಲ್ಲಿ ನಾನು ಡಿಗ್ರಿ ತಗೊಂಡಿಲ್ಲ ಅಂತ ಹೇಳ್ತಿದ್ದಾರೆ ಸ್ವಾಮಿ ಅವರು.
ಡಿಗ್ರಿ ಬೇರೆಕತ್ತೆ ಇಲ್ಲಿ ನೋಡಿ ಸ್ವಾಮಿ, ನಾನು ಕನ್ನಡ ಚೆನ್ನಾಗಿ ಬರುತ್ತೆ.
ಯಾವುದೇ ಪರೀಕ್ಷೆ ನಡೆಸಿ ವರದಿ.
ನಾನು ಫಿಂಗರ್ ಪ್ರಿಂಟ್ ವಿಚಾರಕ್ಕೆ ಸಂಬಂಧಿಸಿ ಪಟ್ಟಂತೆ ಯಾವುದೇ ಪರೀಕ್ಷೆ ನಡೆಸಿ ವರದಿಯನ್ನು ನೀಡಿರುವುದಿಲ್ಲ.
ಅಂದ್ರೆ ಅವ್ರು ಅದಕ್ಕೆ ಯು ಕಾಂಟ್ ರೀಡ್ ದಟ್ ಅವರು ನೀವು ಆ ಪದವಿ ತಗೊಂಡಿದ್ದೀರಾ ಅಂದಾಗ ಪದವಿ ತಗೊಂಡಿದ್ದೀನಿ
ಇಲ್ಲಿ ಮೇಲೆ
ಬಗ್ಗೆ ನಾನು ಯಾವ್ದು ಅಂದ್ರೆ ಇವತ್ತಿನವರೆಗೂ ರಿಪೋರ್ಟ್ ಕೊಟ್ಟಿರ್ಲಿಲ್ಲ, ಇದೇ ಫಸ್ಟ್ ಅನ್ನೋ ತರದಲ್ಲಿ ಹೇಳಿರೋದು ಅವ್ರು.
ಮೇಲೆ ಏನ್ ಹೇಳ್ತಾರೆ ಸ್ವಾಮಿ, ನಾನು ಪ್ರಾಣಿ ಶಾಸ್ತ್ರ ವಿಭಾಗದಲ್ಲಿ MSc PhD ಪದವಿಯನ್ನು ಪಡೆದಿರುತ್ತೇನೆ.
ಆಯ್ತ್ರಿ ನೀವು MSc ಮಾಡ್ಬಿಟ್ಟು PhD ಮಾಡ್ಬಿಟ್ಟು ಲಾ ಮಾಡಿ ಬಂದ್ಮೇಲೆ ನೀವು PhD ಮಾಡಿದ್ರ ನೀವು ಲಾಯರ್ ಅಲ್ಲ, ನೀವು ಆರ್ಗ್ಯೂ ಮಾಡಕ್ ಆಗಲ್ಲ. ದಟ್ ಈಸ್ ಅಡಿಷನಲ್ ಕ್ವಾಲಿಫಿಕೇಶನ್.
Kindly period this. He must be qualified in that particular science. I relied upon this division bench judgment.
That doesn't mean that you don't have any other qualifications also.
ಇರ್ಬೋದು ಸ್ವಾಮಿ, ಅದ್ರಲ್ಲಿ ಸೈನ್ಸ್ ಎಲ್ಲ ಎಕ್ಸ್ಪರ್ಟ್ ಇರ್ಬೇಕು. 45 ಎವಿಡೆನ್ಸ್ ಆಕ್ಟ್ ಅಲ್ಲಿ ಎಕ್ಸ್ಪರ್ಟ್ ಅನ್ನೋಕೆ ದೇರ್ ಇಸ್ ಡೆಫಿನೇಷನ್.
ಎಸ್,
ಇವು ಯಾವ್ದೋ ಅನಿಮಲ್ ಹಸ್ಬೆಂಡ್ರಿ ಓದ್ಬಿಟ್ಟು ಒಂದ್ ತಿಂಗಳು ಟ್ರೈನಿಂಗ್ ತಗೊಂಡ್ ಬಂದು FSL ರಿಪೋರ್ಟ್ ಕೊಡೋಕ್ ಬರಲ್ಲ ಸ್ವಾಮಿ.
ಎಸ್.
ಸೊ ಮೈ ಹಂಬಲ್ ಸಬ್ಮಿಷನ್ ಲಾರ್ಡ್, ನಾನು ಫಿಂಗರ್ ಪ್ರಿಂಟ್ ವಿಚಾರಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟಂತೆ ಯಾವುದೇ ಪರೀಕ್ಷೆ ನಡೆಸಿ ಇವರು FSL ಇದೆ.
See, even that commissioner report is not in a final, Mr. It is one of the evidence for the court to decide. It will also decide on the basis of.
My humble submission, ಸಮಯ ಇಂಥ ಅನ್ಯಾಯ ವಿಪರೀತ learned, most of the learned advocate brothers not going to cross examine the FSL expert. FSL report ಕೊಟ್ಟ ಅಂದ್ರೆ ಸುಮ್ಮನೆ ಬಿಡ್ತಾರ, ಮುಗಿತು ಅಂತ.
Yes, yes, yes.
ಎಷ್ಟು ಜನ ಪ್ರಾಪರ್ಟಿ ಹಾಳು ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ.
Yes.
This is serious.
Yes, you give that judgment. Yes, read. Which is that paragraph you want to read?
I further relied upon my lord.
No, first you read this judgment. Which is that?
ನನ್ನ ಹತ್ರ ಒಂದು ಕಾಪಿ ಇಲ್ಲ.
You get that copy first. Yes. At the request of.
ಇವತ್ತೇ ಇತ್ತು ಸಮಯ. Till further proceedings time. Next week ಯಾವ ಡೇಟ್ ಕೊಡ್ತೀರಾ?
No, today only you argue that. Yes. Leave this matter next week.
Cell number 62, K.R. Nagaraja, government advocate.
Lord, I appear for the petitioner plaintiff.
Yes.
Lord, listen on hand between the petitioner and forest department. Lord, I have laid a suit for bare injunction. Lord, in respect of 3 acres of agricultural land, claiming that I have been in settled possession over said land. Now, the forest department, while admitting our grant of our predecessor and also my possession, they are causing interference, saying that it is comes under within the deemed forest. But there is a categorical letter by the forest department addressed to Assistant Commissioner. Lord, out of 31 acres, 19 acres has been declared as deemed forest in the year 2015. We were all granted in the year 1995, my lord. Myself and 4 others, totally out of 31 acres, 11 acres have been granted to different persons. We have been in possession. I have produced, my lord, RTC, everything. There is no dispute at all. They are causing unnecessary interference to our possession.
No, Mr. Even if it is granted by you, central government, if it is a forest land, it will not give any right.
No, my lord, this is
That
not
is what that law laid down by Supreme Court.
Yes, my lord. Govardhan case, my lord, correct, my lord. But this is a case where this is not a forest land. Lord, subsequently, 2015, the government has passed a government order saying it is deemed forest. It was a Gomal land, my lord. In the year 1995 itself, we were all grantees. In 2015, my lord, they have declared as deemed forest on the letter of the forest department. But that we are not objecting for the deemed forest. We are only concerned to protect our property, which has been.
Once it is declared as a deemed forest, you are out. You could have challenged that before that competitor.
No, my lord, they are not disputing our grant at all. They have admitted our grant.
Even not only grant, even there is no dispute that government has given a grant and all. The Supreme Court said that.
Correct, my lord. Here is a case where, but there is no dispute regarding the grant or the forest land.
No,
they admit, my lord, they admit our deemed forest land is about 19 acres and that. And also they admit out of 31 acres, 11 acres has been granted. There is no dispute at all.
Now, where is government advocate? Our case where is she there?
ಇದರ ಆಮೇಲೆ ಒಂದು ದೇ ಸಾಟ್ ಮಿಲಾಟ್ ಜಾಯಿಂಟ್ ಸರ್ವೆ ಮಾಡಿ ಅಂತ ಅದರಲ್ಲಿ ಡಿಮ್ಡ್ ಫಾರೆಸ್ಟ್ ಅಲ್ಲಿ ಎಷ್ಟು ಆಗಿದೆ ಸರ್ವೆನೇ ಮಾಡಲ್ಲ ಸುಮ್ಮನೆ ನಮ್ಮದು ತೋರಿಸ್ಬಿಟ್ಟು ಈಗ ನಮ್ಮದು 1 ಎಕರೆ ನೀವು ಇದು ಮಾಡಿದ್ದೀರಾ ಅನ್ನೋ ಕಾರಣಕ್ಕೆ ತೊಂದರೆ ಕೊಡ್ತಾ ಇದ್ದಾರೆ ನಮ್ಗೆ ಲ್ಯಾಂಡ್ ಎಂಜಾಯ್ ಮಾಡಕ್ ಆಗ್ತಿಲ್ಲ ಅವ್ರು ಡಿಮ್ಡ್ ಫಾರೆಸ್ಟ್ ಒಳಗಡೆ ಬಂದ್ರೆ ತಗೊಳ್ಳಿ ಸ್ವಾಮಿ ನಮ್ದೇನು ಇದಿಲ್ಲ ಸ್ವಾಮಿ ಹಾಗಾಗಿ ಈಗ ಟ್ರಯಲ್ ಕೋರ್ಟ್ನವರು ಅದೇ ಆ ತರ ಹೇಳಿರೋದ್ರಿಂದ ಇಲ್ಲಿ ನೋಡಿ ಸ್ವಾಮಿ ಇಂಕ್ ಪೇಜ್ 85 ಮಿಲಾಟ್ on the
nobody is there. Government said we'll have it next week.
As your lordship, please. Yes. Interim order will kindly be.
Interim order granted. None appear for respondent. Counsel for the petitioner is present. In interim order, release this matter after 2 weeks. Interim order granted earlier is extended till next date of it.
Oblige, my lord.
Yes.
For respondent number 1, 2, 3.
Rakesh Kini for petitioner, Abhishek Marla, I appear for petitioner. Petitioner is defendant to this. Just bring some facts.
No. Previous, just produce the.
Just produce one.
No, what is this, mister? So many 65 pages for a cost list.
I being the plaintiff had filed a application for appointment of commissioner, my lords, which was allowed.
Okay, submit, my lord.
And now
Yes, yes.
I just submit. Suit for declaration and injunction.
You are the plaintiff.
I'm one of the defendant.
Defendant.
There are around 485 defendants. I'm
Yes.
one of the defendant.
Suit for
Declaration and injunction. During the pendency of the suit,
my lords,
they filed an application.
one submission, my lords. He has produced the copy, my lords, of as per the direction of this honorable court. I'll ascertain this and I'll get back in the next date of hearing.
Because nothing survives, writ petition can be allowed. I'll just come within a minute.
Kindly, the order of this
I
honorable
will
court.
give an opportunity. Let us see what he wants to
Please,
see.
please.
He said that writ petition can be disposed of. What is
Yes.
it?
This honorable court, my lords may kindly see the order of this honorable court dated 10/12/2024. This honorable court, when they were also present, granted interim order. Interim order may kindly be seen. Second para. Learned counsel for the petitioner is directed to furnish list of gold and silver ornaments and other articles of defendant number 1, which are in the custody of Bandaramani. Till the next date of hearing, the interim order dated so and so is stayed. So I was directed to give list of articles. I have given list of articles on last date of hearing. Then what happened on the last date of hearing? What they said is with weight has to be given.
Measurement
So now
only.
with weight I'm giving. So nothing survives in this writ petition.
No, what is the suit for?
Suit for declaration and injunction. During the
Declaration and injunction regarding what?
I'll just show the plain.
No, you ಹೇಳಿ ಅಷ್ಟೇ ಸಾಕು ಹೇಳಿ ಯಾಕೆ ಅಂತಂದ್ರೆ ನಾವು normally will think about that land. Now you are saying that weight and all. Therefore, I think it's
Only on the point of court commissioner, my lords.
no. First, let me know that fact. What is that?
I'll just show the prayer, madam.
You
Prayer-
just
Prayer is at page number 135. Page 135.
My lords, he has challenged the
declare
application,
that
my lords.
trust
Yes.
is created, get up involved documents. What is this?
Declaration that document number so and so. Declaration of trust created and got up documents invalid and not binding on defendant number 1 and devotees of quadri so and so, so and so, so and so. And injunction restraining the defendants from alienating, creating, encumbering or any claim or any property belong to defendant number one. So this is the prayer in the suit one. Now they
I
have
the
filed-
property, what is that you are telling that some weight and all?
application is totally different, what they have filed. The application is actually not maintainable, but trial court had allowed the application. My lord may see their application.
No, I am not understanding that.
Milords,
I-
if
I'll just-
I'm permitted to make a
Why
submission.
this court has directed that?
Milords, he had filed an application, we being the plaintiff had filed an application for appointment of commissioner to ascertain the ornaments and belongings of the Daiva, that is defendant number one. It is a Daiva which has been represented by defendant number one, respondent number 5 herein. He being the member of committee had challenged that order wherein the trial court had allowed the application and appointment of commissioner was allowed. He challenged that particular order in this writ petition.
Now he is saying that in the commissioner work. I have
ಅಗತ್ಯ
done it,
ಇಲ್ಲ
I have-
ಅಗತ್ಯ ಇಲ್ಲ ನಾನೇ ಮಾಡಿದ್ದೀನಿ ಅಂತ ಬಟ್ he has done that but I have to get the
ಅಷ್ಟೇ,
instruction.
ಅವ್ರು verify ಮಾಡ್ಲಿ ಬಿಡಿ ಅಷ್ಟೇ. That's all.
the next date of
Now
hearing
it
I'll
is only for the
ascertain the
appointment of the commissioner.
please be not.
Instead of commissioners, you have furnished all the details.
What
Please.
the honorable court said, instead of
Yes,
commissioner.
I understood. Now I understood.
Please.
Now that instead of commissioner, he
Instead of
said,
commissioner going and
yes, you have done it. If he is satisfied, then
please
even if he's not satisfied, it has to be allowed.
that we'll see on
that,
that.
that the court has to decide.
Yes.
Please me.
When do you want, mister? When will you get that?
Next week, Milords.
Interim order may kindly be extended.
Is this matter on 17th?
Please,
Interim order
Milords.
granted earlier is extended till next date of it.
Here number 64,
Appear for the petitioner in this.
Hare Krishna Pramod for petitioner, Vardarajan MS.
On the last date, Your Honor had pointed out that there was a two-page order of the Supreme Court with respect to termination of tenancy. I have located that. I'm just passing on a copy of the Supreme
What is
Court.
that?
This is the dispute arose primarily with respect to whether the present dispute is a commercial dispute or not. There was one issue that had come up, which in fact your lordships pointed out on the last date that your lordships had in passing read an order. That order your lordships will
No,
see.
that, yes, that termination of tenancy.
Please.
Yes, you got that judgment.
I found the judgment. It is kindly see page 2 of the compilation that I've just
Yes.
give him a call. This is in fact Mr. K.V. Vishwanathan, who's now a sitting judge of the Supreme Court, had argued this matter.
Yes.
But it so happens that this SLP was subsequently withdrawn. I have produced a
No,
copy of
not
that
withdrawn, it is dismissed.
No, it was withdrawn. I have produced the withdrawal as well.
Withdrawn.
It is withdrawn.
No, on the next day itself, I have find it and it shows that it is dismissed. It
Page
is
3, your lordships will see.
disposed
the-
of antiday.
Disposed of is withdrawn. It was withdrawn.
Yes.
And the findings of the Calcutta High Court were affirmed.
Yes.
But that was specifically on the point of 106 of the Transfer of Property Act. Because the Calcutta High Court distinguished it by saying that because 106 is a statutory notice and a statutory right of eviction, therefore, whether it is a commercial dispute or not is subject on the.
But in Calcutta High Court, still matter is pending. It is not disposed of.
It is pending, and in fact, there are several decisions of the Delhi High Court where they've distinguished it by saying that the Calcutta High Court was not pointed out to the explanation to Section 2. In fact, in the end, I have produced the Calcutta High Court judgment as well. There is no reference to the explanation to.
What is
Section
that explanation? Put it. Commercial Court Act. Yes.
The lordships will find the explanation after 22, Roman number 22. A commercial dispute shall not cease to be a commercial dispute merely because it also involves action for recovery of the immovable property or for realization of monies out of immovable property given as security or involves any other relief pertaining to immovable property. That is what is relevant as far as we are concerned. For recovery of the immovable property itself is a suit for eviction. So therefore, that was the distinction that was not pointed out as far as the Calcutta High Court is concerned. But in the present suit, there is no dispute. I'll just take your lordships through what the present suit pertains to. It is a suit for damages or mean profits, whatever their case may be. But it is essentially in the nature of damages or mean profits. It is not for eviction because eviction is all.
No, any judgment in related to that explanation and all.
There, I have several judgments. I will just pass.
Now, what is that you are challenging here?
It is an application under Order 7 Rule 10 where me as a defendant, we have said that it is a commercial dispute and therefore the matter has to be returned to the plaintiff to be presented before the appropriate court.
That they have dismissed it.
That has been dismissed. Kindly look at the impugned order. In fact, the trial court does not say that it is not a commercial dispute. The impugned order, kindly come to page 16. The impugned order starts at page 16. Your lordships may kindly come to page 20 and 21, para 11.
It appears from the entire pleading in the plaint that claim is damages. No, actually, you are the defendant.
I am the defendant.
No, how it will benefited you to if it go to the commercial court?
No, at the end of the day, it
No,
is not a question of
ultimately-
benefit.
Ultimately, lawyer is using that brain to see that matter has to be dismissed. But how it will helpful to the client, you are not seeing that. Actually, if it is goes to the commercial court, your case will be disposed of within 6 months. If it is here, you can drag it for the years.
At the end of the day, in the interest of justice, I think all of us want a disposal.
no,
Whether
it's
this way or that way, all of us want a disposal, your lordship.
It is a,
And if that is the case, let my learned friend concede to the reference to commercial court. I have no difficulties. In fact, this is a case where the defendant says, let it go to commercial court.
he should have agreed that.
He should have agreed. I have no, in fact, I have been saying that.
Yes.
Kindly see para 11.
No, let us see. We will also examine and see that.
Please. My
Not
only
be very-
difficulty is the trial court matter is listed tomorrow for cross-examination of PW1.
What is the
First and
next?
for 10th, Milan. Therefore,
Cross-examination will stay some. Yes, thing.
It may be stayed till, because we have, in
Well,
fact, this
Somara
matter has
case-
got listed three.
Transferred to that commercial court. Whatever the loss happened to you, no, that will be recovered. That
Right.
will.
I mean, in fact, as far as limitation is concerned,
No,
they will be.
I will also examine. You should not be,
Please.
see, otherwise. All that recovery, tenancy, everything will go to that commercial court
Commercial
only now. Now, the purpose for constituting the commercial court is defeated.
In fact,
If
I have
that
produced,
explanation is read what you have
in
said.
fact, I have produced one
I
decision
will
of
also
the
see that
The
Delhi High
Delhi,
Court.
no, in fact, in the citations that I've produced, there is one decision of the Delhi High Court, which categorically says that mean profits is covered under the definition of any other purpose under the explanation to section 2. That's categorically mentioned. There are two decisions that I've produced. One is a 2024 decision of the Delhi High Court, which says that mean profits
Every
is
day,
covered.
I am seeing that 80 to 100 matters, 50 matters from commercial court. Now constituting of the commercial court purpose is defeated. Now everybody is filing in the commercial court.
But as far as the speed of the commercial court is concerned, we are all very
Now that
happy.
we have reduced to 3 lakhs, then it is still worse now that 3 lakhs means everything will covered in 3 lakhs. Earlier it was 1 crore.
Yes.
Now by amendment, they have reduced to 3 lakhs. Let us see. I will
Please.
just examine.
trial court posted for 10th, Milord. On the day, I will not precipitate the matter.
My,
Undertake that.
Taken
yes.
up.
my
Learned
only
till far-
request is, let there be a stay, because both of us
We
have
will
been
understand
appearing
Stay not
regularly.
necessary,
It is
Will
not that either of us are
precipitate
dragging. In
the
fact, the matter has been
before the
listed for
trial
the
court.
third time before your lordship.
Stay in vehicle now, I'll precipitate model.
Yes, learned
Alla,
counsel.
let it be recorded. Ash.
Yes,
Not-
learned counsel for the respondent plaintiff undertake that he will not precipitate the matter before the trial court till next date of hearing.
Please.
Release this matter on 19th. Yes, we'll see
March.
that one. Yes, other matter? Any?
Serial number,
Submission.
serial number
Not yet.
73.
So far,
I may permit.
49 in the 59 ಬಂದು 59 in the 69 4 hearing dates I have been waiting. Lower court ಅಲ್ಲಿ date ಕೊಡ್ತಾ ಇಲ್ಲ ಸ್ವಾಮಿ.
What is
Ba-
that? Which
This
is the
is
serial number?
69 your lordship.
What is that matter?
My matter is regarding production of document. I have
The
produced the
69, I
document.
apply for the defendant, plaintiff,
Docu-
Miller.
Yes.
A short date may be given, Miller, and will.
Documents I had produced because
This matter
11th,
on-
No, Miller, earlier their application has been
Last
rejected.
no 13th 11th ಕೊಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ ನಾಳೆ ಇದ್ರೆ ಇಲ್ಲ ಮೀನ್ ವೈಲ್ ಲೆಟ್ ದ ಮ್ಯಾಟರ್ ಬಿ ಸ್ಟೇಡ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ ಪ್ಲೀಸ್
No, no, no,
we'll
Miller,
do it on,
for
11th,
staying, I
please.
oppose, Miller, and
ಲಾರ್ಡ್ಶಿಪ್ 11th ನಾಳೆ 11th ಕೊಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ ಆರ್ಗ್ಯುಮೆಂಟ್ ನಿನ್ನೆ
tomorrow let
adjournment
them take a
application
time, Miller,
ಹಾಕಿದ್ರೆ
we will
only
not
3
oppose
days.
that,
I
their
to
request.
11th, if it is not reached, then I will consider for your interim prayer. Yes,
Serial number 73 also,
ಇಲ್ಲ
Milord.
10th ಲಾರ್ಡ್ಶಿಪ್ 10th ಕೊಟ್ರೆ ಚೆನ್ನಾಗಿ.
10th, but again it will not reach.
ಇಲ್ಲ
So many
11th ಅಲ್ಲಿ ಮತ್ತೆ ಡೇಟ್ ಕೊಡಲ್ಲ
No, 10th
No,
it will
11th,
not
Miller,
reach.
we will cooperate with
Already-
them for a short adjournment, Miller.
My instruction, we have reached 100 matters. Again, it will not reach. If you want, I will give that 10th.
10th
Lord.
ಕೊಟ್ಟಿದ್ರೆ I'll try it.
Serial number 68, my lord. Only short
Serial
time.
number 73 also, Milord. Urgency is there. It will be taken on 10th.
Date is there. And trial court has come to the conclusion saying that 2 wills are there, my lord. My lordship has started clarification from other side, my lord. It is posted on 4th, my lord, and it was posted today, my lord. It was not reached, my lord. Kindly have it on 11th, my lord.
Yes, 11th, you will see.
Lord, serial number 73, my lord.
67. 78.
73. ಅದ್ರಲ್ಲಿ ತುಂಬಾ ಅರ್ಜೆನ್ಸಿ ಉಂಟು my lord. ಯಾಕೆ ಅಂತ ಹೇಳಿದ್ರೆ
By the wife has been allowed. That is the only question that the same problem may be taken up for the next week. We take
17th.
My lord, serial
Lord,
number 67.
73, serial number 73, my lord.
67, my lord. May I request
67.
Yes, ma'am. May I request it to be taken on 11th, my lords, if that's.
67.
Yes, ma'am.
My lord, serial number 73.
17th or 18th.
Lords, if it could be taken on 11th because.
No, 11th. No, I have no objection to grant. You see that some matters spotted, I have posted on that. Therefore, I am saying that. Otherwise, I will give that option to that court officer. You take any date.
No, my
But
lord.
thing is, it may not reach. Therefore,
Then, my lord,
yes.
may I
I
leave
think
it to you.
17 this week. I don't think I have given any spotted matter. Yes, 17th.
Please.
Yes.
Lord,
70.
serial
76,
number
yes.
73.
Is there, Maral?
Who is that? Yes, Mr. Prasanna.
It can be referred to mediation center Belur, my lord. Because
Mediation.
only with regard to the road, my lord.
Yes, at the request of the parties, refer this matter to Belur.
Mediation center.
Belur Lydia.
Idante. We are very.
Yes, refer to that. Senior civil judge. Belur
Civil judge,
senior idea Belur civil judge Belur mediation center of civil judge Belur. ಅದ್ ನೋಡಿ ಅದು ಏನ್ ಬರುತ್ತೆ ಅಂತ ನೋಡ್ಬಿಟ್ಟು.
Serial number 65.
Lord, serial number
Parties are
7.
directed to be appear before ಯಾವಾಗ appear ಆಗ್ತೀರಾ?
February end, my lord.
Yes, on 28th February. Yes, 28th February.
65, my lord.
Lord, serial number 73.
70?
73, my lord.
71 and 72.
73.
72. Yes, 18.
73,
my lord, serial number 73.
70 also 80. Yes, Mr. ಮುಗಿಸ್ಬಿಡೋಣ ಅಲ್ಲಿ ಮೈಕಲ್ ಡಿಸ್ಟರ್ಬ್ ಆಗುತ್ತೆ. Yes.
73 ಅಲ್ಲಿ ಏನಂತ ಹೇಳಿದ್ರೆ ಬಿಕಾಸ್ ಆಫ್ ದಿ ಫಸ್ಟ್ ಅಪೆಲೇಟ್ ಕೋರ್ಟ್ ಆರ್ಡರ್ ಮಿಲಾಡ್ ಮೈ ಎಂಟೈರ್ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಸ್ಟಾಲ್ಡ್ ಮಿಲಾಡ್ 90% ಆಗ್ಬಿಟ್ಟಿದೆ. ಇವಾಗ ಬೇಕಂತಲೇ ಜಲಸಿಯಲ್ಲಿ ಇದು ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ. ಹಾಕೊಳ್ಳಿ ಸ್ವಾಮಿ ಮಂಡೇಗೆ 73.
Yes.
ಮಂಡೇ 10th ಹಾಕೊಳ್ಳಿ 10th ಗೆ.
May I also request for a date in serial number 74?
10th it will not reach, Mr. So many matters are there.
ಅಲ್ಲ ಟ್ರೈ ಮಾಡ್ಬೋದು ಸ್ವಾಮಿ.
66.
ಯಾವ ಡೇಟ್ ಸ್ವಾಮಿ?
17 ಕೊಟ್ಟಿದ್ದಾರೆ ಸರ್.
18th.
73.
65.
I am for the petitioner, my lord. Serial number 65.
ಯಾವತ್ತು ಬೇಕು?
Interim order is there till today.
Interim order will be extended till next hearing. 18th, 19th. Yes.
Serial number
My lord.
18th.
My lord,
Yes.
my lord, serial number 67. Your lordship was pleased to grant on 17th. Kindly have it on 18th.
I appear for the petitioner. Your
18th.
lordship. 18th is fine.
18th, yes.
Serial number 75.
75.
Kindly be had on 18th.
75, 18.
Interim order may also be.
Yes, interim order granted.
Serial number 74, my lord. Any early date?
Kindly have it on 18th, your lordship.
66,
18th, your lordship.
18.
Aye, much
Yes.
of.
77, my lord.
Yes,
Kindly on 17th, my lord. 77.
77, 17th. Yes.
My lord, serial number 74, any short date, my lord?
40,
74, my lord, serial number 74.
74, 18th.
18th, my lord, grateful.
ಲಿಸ್ಟ್ ಆಗೋಯ್ತು ನೆಕ್ಸ್ಟ್ ವೀಕ್.
ಕೋರ್ಟ್ ಆಫೀಸರ್ 73 ಯಾವ್ದು ಕೊಟ್ಟರು? ಯಾವ ಡೇಟ್ ಕೊಟ್ಟರು?
ಫೋನ್ ಮಾಡಿ ನನ್ಗೆ ಹೇಳಿದ್ ಲಿಸ್ಟ್ ಆಗೋಯ್ತು.
ಕೋರ್ಟ್ ಆಫೀಸರ್
ಈಗ ಅವ್ರ ಅದನ್ನೇ ಹೇಳಿದ್ದು ಲಿಸ್ಟ್ ಕ್ಲೋಸ್ ಮಾಡ್ಬಿಟ್ವಿ, ಬಂದ್ರೆ ಅವ್ರಿಗೆ ಅದನ್ನ ಹೇಳ್ ಕಳ್ಸಿ ಅಂತ ಆಯ್ತು ಅಂತ. ಸರ್ ಹೇಳಿ.
73 ಯಾವ ಡೇಟ್ ಕೊಟ್ಟದ್ದು?
ಹೌದು 17th
17th ಆಯ್ತು.
17. ಆಯ್ತಪ್ಪ, ಈಗ ಲೀಸ್ಟ್ ಆಗೋಯ್ತಂತೆ. CJ ಅವರು ಅಲ್ಲಿ RJ ಕುತ್ಕೊಂಡು ಲಿಸ್ಟ್ ಇಶ್ಯೂ ಮಾಡ್ಸಿದ್ರಂತೆ. ಅದಕ್ಕೆ ಅವ್ರು ನನಗೆ ಹೇಳಿದ್ದು RJ ಕುತ್ಕೊಂಡು ಇಲ್ಲೇ ಲಿಸ್ಟ್ ಇಶ್ಯೂ ಮಾಡಿಸ್ಬಿಟ್ರು ಸರ್, ಅವ್ರು ಬಂದ್ರೆ ಅದನ್ನೇ ಹೇಳಿ ಅಥವಾ ಸಾಹೇಬ್ರಿಗೆ ಹೇಳಿ ಅಂದ್ರು. ಸಾಹೇಬ್ರು ಇಲ್ಲ ನಿಮ್ಗೆ ಹೇಳಿ. ಯಾಕಂದ್ರೆ ಅವರು 4 ಗಂಟೆಗೆ ಇಶ್ಯೂ ಮಾಡ್ಬೇಕು, 5 ಗಂಟೆಗೆ ಇಶ್ಯೂ ಮಾಡ್ತಾ ಇದ್ದಾರೆ. ನಾನೇನ್ ಮಾಡ್ಬೇಕು? ಅವ್ರು ಹೇಳಿದ್ರೆ ನಾನು ನಿಮ್ಗೆ ಹೇಳ್ತಾ ಇದ್ದೆ 65 ಅವ್ರು ಈಗ ಜಸ್ಟ್ ಹೇಳಿದ್ರೆ ನಾನೇನ್ ಮಾಡಕ್ಕೆ ಆಯ್ತು. ಈಗ ನಾನು ಎಲ್ಡಪ್ ಮಾಡಿಸಿ ನಾನು ಸೇರ್ಸಕ್ ಆಗಲ್ವಲ್ಲ ಇವಾಗ. ಅದಕ್ಕೆ 18 65 18 66 18 67 18 68 11 69 10 70 18 71 18 72 18 73 17 74 18 75 18 5 18 76 ಮೀಡಿಯೇಷನ್ 77 17 77 17 ಎಲ್ಲ ನಿಮ್ಗೆ 78 17. ನೆಕ್ಸ್ಟ್ ಏನ್ ಮಾಡಿ ಅಡ್ವಾನ್ಸ್ ಆಗಿ ಬುಧವಾರನೇ ಬಂದು ಹೇಳಿ 2 ದಿವಸ ಮುಂಚೆ. ಅವಾಗ ನಾನು ಅವ್ರಿಗೆ ಹೇಳಿ ಇಟ್ಕೋಬೇಕು. ಈಗ 5:10 ಹೇಳಿದ್ರೆ ಇಲ್ಲಪ್ಪ ನಾನು ಆತರ ಸೇರ್ಸು ಅಂತ ಹೇಳಕ್ ಬರಲ್ಲ. ಸಾಹೇಬ್ರು ಏನ್ ಹೇಳಿರ್ತಾರೋ ಅದನ್ನೇ ಮಾಡ್ತಾರ ಅವ್ರು. ಈಗ ಅವ್ರು ನನಗೆ ಹೇಳಿದ್ರು, ನಾನ್ ಸಾಹೇಬ್ರಿಗೆ ಹೇಳಿ ಅವ್ರ ಕನ್ಸೆಂಟ್ ಕೇಳಿ ತಿರ್ಗಾ ಅಲ್ಲೋಗಿ ಹೇಳ್ಬೇಕು ನಾನು. ಏನದು ಸರಿ? ಏನ್ ಮ್ಯಾಟ್ರು? ಏನಕ್ಕೆ ಬರ್ಬೇಕು? ಅವೆಲ್ಲ ಇಲ್ಲ ನನಗ್ ಗೊತ್ತಾಗಲ್ಲ ಅದು. ಅವ್ರು ಅಡ್ವೊಕೇಟ್ ಕೇಳ್ಕೊಂಡು ಫೋನ್ ಮಾಡಿದ್ರೆ ಬೆಳಗ್ಗೆ ಹೇಳ್ತಾರೆ. ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಆದ್ರೆ 2008 ವರೆಗೂ ಹೇಳಿದ್ದಾರೆ ಅಷ್ಟೇ. ಅದಾದ್ಮೇಲೆ ಬರಲ್ಲ. 2008 ಆದ್ಮೇಲೆ ಬರ್ಬೇಕು ಅಂದ್ರೆ ಅರ್ಲಿ ಹಿಯರಿಂಗ್ ಹಾಕೊಂಡೆ ಮಾಡ್ಕೋಬೇಕು. ಏನು ಅವ್ರ ಅಡ್ವೊಕೇಟ್ ಕೇಳಿದ್ರು, ಅವ್ರ ಅಡ್ವೊಕೇಟ್ ಹೊಟ್ಟೋಗಿದ್ದಾರೆ, ಕೇಳಿ ಹೇಳತ್ತೀನಿ ಹೇಳ್ತಾರೆ. GOP ರಿಜಿಸ್ಟರ್ ಜುಡಿಷಿಯಲ್ ಯಾರು ಕೇಳಿದ್ರು ಆರ್ಡರ್ಸ್ ಆನ್ ಆರ್ಡರ್ಸು ಅಡ್ಮಿಷನ್ ಈ ತರ ಇದ್ರೆ ಬರುತ್ತೆ. ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಆದ್ರೆ ಬರಲ್ಲ. ಅರ್ಲಿ ಹಿಯರಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕೊಳ್ಳಿ, ಆಟೋಮೆಟಿಕ್ ಬರುತ್ತೆ. ಅದು ಮುಗಿಸಿ ನಾನು ಹೇಳ್ತಾ ಇಲ್ಲ, ನಾನು ಯಾವುದು ಏನು ಹೇಳಲ್ಲ. ನೀವು ನನ್ನ ಮೇಲೆ ಯಾಕೆ ಹೇಳ್ತಾ ಇದ್ದೀರಿ? ಆಯ್ತು, ಮಾಡಿ ನೀವು 10:30 ಮಾಡ್ಕೊಳ್ಳಿ. ಇವ್ರೆ ನಾನು ಲೀಸ್ಟ್ ಮಾಡುವಂತ ಈಗ ಹೇಳಕ್ ನನ್ಗೆ ಎಲ್ಲಿದೆಪ್ಪ ಪ್ರಾವಿಷನ್? ಲೀಸ್ಟ್ ಇಶ್ಯೂ ಮಾಡಿದ್ಮೇಲೆ ಏನ್ ಮಾತಾಡ್ತಾ ಇದ್ದೀರಪ್ಪ? ಅವರು RJ ಅಲ್ಲೇ ಕುತ್ಕೊಂಡು ಮಾಡಿದ್ಮೇಲೆ RJ ದೊಡ್ಡವರ ನಾನ್ ದೊಡ್ಡವನ? ನೀವು ಸಾಹೇಬ್ರಿಗೆ ಹೇಳಿದ್ರೆ ಸಾಹೇಬ್ರ RJ ಕರೆದಿ ಹೇಳಿರೋರು ಅಲ್ವಾ? ನಾನು ಈಗ ಹೇಳಕ್ಕಾಗಲ್ಲ. ಅರ್ಥ ಮಾಡ್ಕೊಳ್ಳಿ ಏನ್ ಹೇಳ್ತಾ ಇದ್ದೀವಿ ಅಂತ. ಕೋರ್ಟ್ಗೆ ಹೋಗುತ್ತೆ ಅದು ಹೇಳಿದ್ರು. ರೋಸ್ಟರ್ ಏನು ಚೇಂಜ್ ಆಗಿಲ್ಲ. ರೋಸ್ಟರ್ ಇದ್ದಿದ್ದೇ ಇದೆ. ಅವ್ರು ಯಾರು ಆರ್ಡರ್ ಮಾಡಿದ್ರು ಅವ್ರ ಮುಂದೆ ಪೋಸ್ಟ್ ಮಾಡಕ್ ಹೇಳಿದ್ರು. ಅದು ಅವ್ರು ಬೋರ್ಡ್ನವ್ರು ಮಾಡ್ತಾರೆ, ನನ್ನನ್ನ ಯಾಕಪ್ಪ ಕೇಳ್ತೀಯಾ? ಅವ್ರ ರೆಸ್ಪಾನ್ಸಿಬಿಲಿಟಿ ಅದು. ಅವ್ರು ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ ಏನು ಬರ್ದಿಲ್ಲ ಆ ತರ. ಸುಮ್ನೆ ಇರಪ್ಪ. ಬೆಳಗ್ಗೆ ಬಂದು ನಿನ್ ಹಿಡ್ಕಂತಾರೆ. ಅವ್ರಿಗೆ ಅರ್ಥ ಆಗಲ್ಲ. ನೋಡಪ್ಪ, ಬೋರ್ಡ್ ಬ್ರಾಂಚ್ ಅವ್ರು ಬಿಟ್ಟಿದ್ದಾರೆ, ಅವ್ರು ಏನ್ ಮಾಡ್ತಾರೋ ಗೊತ್ತಿಲ್ಲ. ಅವಾಯ್ಡ್ ಸರ್ವಿಸ್ ಆಫ್ ನೋಟಿಸ್ ಲಿಸ್ಟ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಂತ ಆರ್ಡರ್ ಆಗಿದೆ. ನಿಮ್ ಸೀನಿಯರ್ ಇಲ್ಲೇ ಇದ್ರು, ಅಥವಾ ನೀವು ಆರ್ಗ್ಯೂ ಕೌನ್ಸಿಲ್ ಯಾರಿದ್ರು ಅವ್ರು ಇದ್ರು. ಬಿಡಿ ಅಷ್ಟೇ. ಅದಾದ್ಮೇಲೆ ಬೋರ್ಡ್ ಬ್ರಾಂಚ್ ಹೋದಾಗ ಅವ್ರು ಏನ್ ಮಾಡ್ಬೇಕೋ ಮಾಡ್ತಾರೆ. ಬೋರ್ಡ್ ಬ್ರಾಂಚ್ ಯಾಕೆ ಬಂದಿಲ್ಲ? ಯಾರು ಹೇಳಿದ್ ನಿಮ್ಗೆ?
ಅದು ಹೆಸರು ಗೊತ್ತಿಲ್ಲ.
ಮತ್ತೆ ಅದೆಲ್ಲ